The Judiciary Committee will please come to order, a quorum being present. Without objection, the Chair is authorized to declare recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the Chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the yeas and nays are ordered. I'd like to remind members that we've established an email address and distribution list dedicated to circulating amendments, exhibits, motions, or other written materials that members might want to offer as part of a markup today. If you'd like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as possible. I would also ask all members, both those in person and those appearing remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. Pursuant to notice, I now call up H.R. 7946, the Veteran Service Recognition Act of 2022, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 7946, to provide benefits for non-citizens.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 7946, the Veteran Service Recognition Act of 2022, would finally ensure that non-citizen active duty military veterans and their families are treated with the dignity and respect befitting the sacrifice they have given to this country. As we discussed at our hearing last month in the Immigration Subcommittee, immigrants have served in the U.S. Armed Forces in every major conflict since the Revolutionary War. Every day, 45,000 immigrants actively serving in the U.S. Armed Forces risk their lives in support of our country. While military service can offer an expedited pathway to naturalization, many non-citizen service members leave the military without becoming a U.S. citizen because of unnecessarily burdensome requirements that they must meet. Further, many service members have family members who lack lawful status in the United States with no ability to adjust their status. As a result, while our military personnel are deployed protecting U.S. global interests and keeping our nation safe, they must worry if their loved ones will be apprehended in an immigration raid and potentially be deported. We must do better by those who risk their lives to protect our country. President Biden has taken significant actions to remove barriers to naturalization for service members. Additionally, the Departments of Homeland Security and Veterans Affairs have collaborated to create the Immigrant Military Members and Veterans Initiative. This initiative helps immigrant veterans across access VA benefits and, when appropriate, apply to be paroled into the United States. In addition to the Biden administration's actions, there has been a bipartisan commitment since 2007 to protect immediate family members of U.S. service members and veterans through the Parole in Place in Military Families Initiative. However, more must be done, and that is why we're considering H.R. 7946 today. The Veteran Service Recognition Act would direct DHS and DOD to implement the program that allows non-citizen service members to file for naturalization during basic training or as early as otherwise possible. Establish the Military Family Immigration Advisory Committee to review and provide recommendations on the cases of non-citizen veterans, active service members, and their families who are in removal proceedings. Provide an opportunity for non-citizen veterans who have been removed or ordered removed and who have not been convicted of serious crimes to apply for legal permanent resident status. And 4, allow immediate relatives of service members or veterans with an approved immigrant petition to adjust their status and obtain a green card as long as they are otherwise admissible. This legislation recognizes and honors the sacrifices of our service members by supporting them and their families and by giving them every opportunity to become U.S. citizens if they so desire. This is modest but important legislation that deserves bipartisan support. The Veteran Service Recognition Act is a narrowly tailored solution to a specific problem. The number of deported veterans is a closed universe with a small and finite number of individuals who are eligible for relief. DHS estimates that the number of deported non-citizen veterans is in the hundreds. Additionally, by addressing the naturalization of non-citizen service members during basic training, this bill will eventually eliminate the need to assist deported veterans in returning to the United States. I'd like to thank Chairman Takano of the Veterans Affairs Committee, as well as our Immigration and Citizenship Subcommittee Chair Zoe Lofgren, for for their leadership on this issue. I was honored to join them in introducing the Veteran Service Recognition Act, and I urge all my colleagues to support this important legislation. I now recognize the gentleman from California, Mr. McClintock, for his opening statement.
Thank you, Mr. Chairman. DHS Secretary Ali Mayorkas has repeatedly asserted, including in sworn testimony to this committee, that the southern border is secure. Now, this, of course, is a lie, and not even a very subtle one. We know the numbers. A stunning 3 million encounters since Inauguration Day, when Joe Biden reversed the Trump administration's enforcement measures, with roughly half of these admitted and trafficked to every community in our nation. Another 900,000 known gotaways. We're all seeing the effect of these policies, the strain on our schools, our hospitals, our public safety, working class wages and opportunities, social services. No civilization, to my knowledge, has ever survived the magnitude of illegal mass migration on the scale that the Democrats have unleashed in just 18 months. And Gallup warns there are another 42 million people in Latin America and the Caribbean who intend to come here now that they can. Well, when Mayorkas appeared before this committee, he couldn't tell us how it benefits the American people to have their classrooms packed with non-English speaking students, their emergency rooms flooded with illegals demanding basic care, how their families will be safer with increased gang activity and fentanyl inundating communities, or how working families will be made better by flooding the labor market with cheap illegal labor while they foot the bill for social services. How do our Democratic colleagues react to this unprecedented illegal migration that they've unleashed? Do they call on the Biden administration to stop the releases? Do they call on the president to actually enforce U.S. immigration laws, or at least stop incentivizing this mass illegal migration? No, they mark up this bill that readmits immigrant veterans who were later deported, mainly for committing criminal offenses. Using veterans for cover, they go on to provide that any alien who adjusts status to or is admitted as a lawful permanent resident shall be presumed to have established good moral character. What? The effect of this will be that millions of people per year will be presumed to have satisfied their good moral character burden simply by producing their green card. The legal permanent residents who enlist in our military are offered special avenues for naturalization under the Immigration and Nationality Act. About 3% of U.S. veterans today are foreign-born. Many have chosen to become U.S. citizens. Now, for a while, we allowed non-legal permanent residents, including those here on student visas, refugee claimants, and DACA recipients, to enlist in order to claim a fast track to citizenship. It was called the MAVNI program. It was such a debacle that the Obama administration had to suspend it in 2016. One MAVNI enlistment, Ji Jiaqun, was found to be a Chinese spy. A number of foreign nationals who enlisted in our military were subsequently deported for committing crimes. Now, foreign nationals who come to America legally, who obey our laws, and seek to serve our country because of a love for it and the principles upon which it's founded, are one of our greatest strengths. 11 years ago, I spoke at the funeral of Gurpreet Singh, whose family had immigrated from India legally 11 years before that. His father told a reporter that Gurpreet was, quote, always a very patriotic man for the U.S. From the time he was a little boy, he knew he wanted to serve in the U.S. military. Gurpreet was very proud of his service with the Marines. Now, Corporal Singh was wounded in combat, chose to return, overstayed his assignment to relieve a friend, and was killed in action in Helmand Province, June 22, 2011. Yet the majority seems unable or unwilling to tell the difference between a Chinese spy like Ji Jiaqun and an American hero like Gurpreet Singh. I pray the majority is not attempting to equate such heroism, devotion, and fidelity with the lawless, illegal mass migration they're not only ignoring, but actively aiding and abetting with their policies. 31,000 foreign nationals now serve in our armed forces. This is less than 4 days of border incursions that we're currently seeing. The IMMVI program has naturalized about 1,000 veterans over the last 16 months. That's the number of illegal aliens streaming across our border every 3 hours. H.R. 7946 does nothing to address the chaos on the U.S. border, makes major changes to U.S. naturalization law, and it furthers the Democrats' anti-enforcement agenda. For those reasons, I oppose the bill, and I yield back.
The gentleman yields back. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 7946, offered by Mr. Nadler. Strike all that follows after.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I recognize myself to explain the amendment. This amendment in the nature of a substitute makes one substantive change along with a number of technical changes. The main change is the addition of a new section which allows immediate relatives of service members or veterans with an approved immigrant petition to adjust their status and obtain a green card as long as they are admissible. The new section waives certain admissibility requirements related to how these individuals entered the United States and is consistent with the Parole in Place initiative that has existed since 2007 for military families. With regard to the technical changes, they are all minor and designed to ensure that the legislation is implemented as intended. For example, the Sense of Congress section is deleted and various small changes were made to the reporting requirements of Section 2. I urge all members to support the amendment. I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? What purpose does the gentlelady from California seek?
I'd like to strike the last word, Mr. Chairman.
Gentlelady is recognized.
I want to just briefly encourage all the members of this committee to support this important bill. You know, there are many challenges that face our country in the immigration arena, but this is a discrete situation that we can fix. You know, the American Legion, not exactly known as a left-wing organization, has come out strongly in support of this measure. Why? What they have said in their letter to us is that American veterans should not be deported and removed. Now, most of the veterans who have been removed from this country, who served their country in the U.S. military, were legal permanent residents of the United States, and after their discharge, they messed up. In many cases, related to PTSD that they developed because of their service. People who got involved in, and they would be arrested and convicted. Well, unlike their U.S. citizen veteran colleagues, after they were held accountable for whatever they did that was wrong, they were then kicked out of the country. Well, you know, what the American Legion is telling us is hold people accountable, but veterans, people who served our country, should not be thrown out of the United States. I know, as the chairman has said, there is a discrete number of individuals in this situation, and the administration has been on a parole basis reviewing them. But I'd like to note that these individuals, in many cases, matter of fact, in most cases, have families in the United States, American citizens in most cases, who are left in the U.S. while their family member is waiting in another country, and it's a hardship on those Americans as well. I would like to note that there is a program in place administratively since 2013, and since that time, the USCIS has approved almost 40,000 applications for military parole in place. Let's note that 2,000 of those applications were approved by the Trump administration. So this is an area where we could come together and put people over politics. Let's honor our veterans. Let's honor their families. Let's make sure that even if we can't do everything, we can do this one thing that will make us stronger, that will honor the service of people who served in our military and their families. And I want to thank also you, Mr. Chairman, for your support of this effort, as well as Representative Takano, the chairman of the Veterans Affairs Committee, and also Congressman, our colleague, Lou Correa, who has been such a leader in standing up for veterans and who has visited the veterans, American veterans who are stranded in Tijuana, hoping to rejoin their families here in the United States. And with that, Mr. Chairman, I yield back.
The gentlelady yields back. Who seeks recognition? For what purpose does the gentlelady from Texas seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman, and thank you so much for bringing this very important bill to the table. You know, I don't want us to get distracted with other issues. I mean, this is a very narrow issue about something that really, quite frankly, should have never even happened, that people get deported after serving our country. I think it's time that we put veterans ahead of politics and veterans ahead of partisan politics and vote to support our veterans. By marking up this bill today, House Democrats continue to deliver on our promises to the American people. To all our deported veterans, know that we see you, know that we stand with you. You fought for our country, now we're fighting to bring you back. A todos nuestros veteranos que fueron deportados, sepan que no son olvidados. Los esperamos de nuevo en casa con brazos abiertos. Mr. Chairman, I simply said that we support them and that we're working hard to bring them home. We have a moral obligation to those who have served our nation in our armed services. Since the Revolutionary War, immigrant service members have continued to fight in every major conflict throughout our history. That obligation is not limited only to our military members, but extends to their families, the families who support our veterans. All of us have family members in the armed forces, who have family in the armed forces, know the pain and the sacrifice of seeing our loved ones head overseas to fight for our liberty without knowing when we'll ever see them again or if we'll ever see them again. If you're willing to put your life on the line to defend this country and its values, you should be able to become a U.S. citizen. This bill simply says that it all begins at basic training. And if we don't do this, it will continue to be totally unacceptable that service members who risked all their life to protect us are thanked for their service with an order of removal. In my view, they should be rewarded with a medal. Those who have served our country, paid for their actions, and who do not pose a threat to our community should not be condemned to exile. They should be allowed to process their pending immigration proceedings within the United States, the nation they swore to defend, and risk their lives. As they are morally entitled, they should receive the comprehensive health care benefits that veterans are eligible to receive. I commend the efforts of the Biden administration in dignifying our veterans and service members who have served and sacrificed for our country. The Immigrant Military Members and Veterans Initiative has taken significant steps in the right direction. I thank the leadership of Congressman Takano and our chairwoman Lofgren on this issue. We had a great hearing over I think it was over the holidays, and it clearly, this bill is one where we need to put our veterans over politics, support them, and welcome them home. I urge my colleagues to support this legislation. With that, I wanted to also, Mr. Chairman, introduce two articles for the record, if I could get unanimous consent. The first is the U.S. has deported thousands of veterans. A new policy change offers new hope for our soldiers left behind. The second one is particular to Texas. These veterans from Texas were deported. They say they deserve a second chance. I agree with them, Mr. Chairman, and I ask for unanimous consent for the record.
Without objection.
Thank you, Mr. Chairman. With that, I yield back.
Gentlelady yields back. Who seeks recognition?
Mr. Chairman,
For what purpose does Mr. Biggs seek recognition?
I have an amendment at the desk.
Clerk will report the amendment.
I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Biggs of Arizona. Page 8.
Without objection, the amendment will be considered as read, and the gentleman is recognized for 5 minutes to explain the amendment.
I thank the chair. My amendment requires the Military Family Immigration Advisory Committee and the Secretary to consider the victims of crimes when deciding whether an individual should receive the benefits of this bill. As drafted, the bill focuses only on the deported individual And the bill does not even mention the potential victims of crimes. We know that most of the individuals who were removed from the country were removed because they committed crimes. If there was a criminal conviction, and if there was a victim, then the advisory committee should be required to consult with the victim, and the victim should have to agree that the individual warrants that the individual deserves an exercise of discretion. In other words, in most states even, we consider restitution, we consider the victim's voice in these matters. So if you've been removed because you've committed a crime against a victim, it'd be my position that the victim should be heard on the issue of reinstatement, if you will. The committee should consider whether the individual has satisfied all obligations, restitution, fines, fees, other obligations associated with the conviction. Similarly, when the Secretary is determining whether or not to waive grounds of inadmissibility, these same requirements should apply. These are basic issues that we should be required to be considered, and I hope all members would recognize that victims of criminal conduct have rights. They have their voice should be considered. And I would, with that, I'll yield back, Mr. Chairman.
Mr. Chairman?
Gentleman yields back. Does the gentlelady insist on a point of order?
I do not insist on my point of order.
Point of order is withdrawn.
But I would-
What purpose does the gentlelady from California seek recognition?
To strike the last word in
lady's
opposition to the
recognized.
amendment. You know, I assume there will be a number of amendments, but I think it's important to wrap our heads around this concept. If a U.S. veteran commits an offense, they're going to have consequences. They may be sent to jail, they may have restitution, they may have fines, just as anyone else. The question is, should they have a further penalty, and that is removal from the United States? And I think the concept behind this bill, and that has been embraced by the American Legion, is that for U.S. veterans, people who put their lives on the line, they should have the accountability that anyone else has and not go that additional step further to remove them from the United States. To provide a veto to a victim, or to provide a veto if fines and forfeitures have not been met for someone who's already been removed, goes beyond what we would do for any other veteran of the United States. As a practical matter, if you have been removed from the United States and you are, a veteran sitting in Tijuana and your family is in the United States, your capacity to actually make the money to pay a fine might be severely diminished, just as a practical matter. But the point is, these veterans should be treated just like every other veteran. There should not be an additional penalty imposed for misconduct, which is removal from the country that they signed up to serve, removal from the country they put their lives on the line to serve. They're going to be treated as every other veteran would be treated and not be given the additional penalty of expulsion from the country that they served so bravely for. So this amendment should be rejected, along with any other amendment that tries to do an additional penalty above and beyond the accountability that any other veteran would have. We do not expel, we should not expel from America those individuals who signed up, put their lives on the line to protect our country, period, stop. I yield back, Mr. Chair.
Gentlelady yields back. Does anyone else seek recognition? For what purpose does the gentlelady from Texas seek recognition?
Strike the last word.
Gentlelady's recognized.
I rise to support H.R. 7946, the Veteran Service Recognition Act of 2022, and to oppose the underlying amendment. The Trump administration made it harder to receive a certificate of honorable service, did not enforce protections for immigrant veterans, and implemented new background check requirements for non-citizens to report to basic training. This legislation is to restore honor, integrity, and justice to our immigration services for those who have faithfully served our country. These policies make naturalization significantly more difficult for non-citizens who serve in the military, subverting Congress' efforts to prioritize and protect active duty and veteran immigrants. The effects of the Trump administration policies were so drastic that naturalization of military personnel dropped from 8,770 in 2016 to just 4,570 in 2020. This is duly an affront to immigrants and a disgrace to the sacrifice of military members. This bill restores dignity to non-citizen military members by making it easier to naturalize while in the military. I'm reminded of the work we did during the Iraq War, when we helped bring families together by allowing citizen military persons to be able to move expeditiously their non-citizen family members. Remember that happening posthumously when these soldiers died in battle, because we were humane and concerned about the families and the fact that these active duty did serve and were willing to serve and die for this country. This legislation directs the Department of Homeland Security and Department of Defense to implement a program that streamlines the naturalization process for non-citizen service members during basic training or as early as otherwise possible, who deserve the respect of their country more than those who have dutifully served in the military, whether or not they're immigrant. Who else would deserve that respect? The nativism of the past administration went as far as to not just attack service members themselves, but also their families, by going to great lengths to rescind the eligibility of citizenship for military families, which we had typically done for a long time. In 2019, U.S. Citizenship and Immigration Services changed the definition of the term residence, making it so that U.S. military and other government employees stationed abroad would no longer be considered as residing in the United States, thus ineligible for U.S. citizenship. How crass and inhumane. This unfairly forced children of U.S. military members to go through a laborious naturalization process without preferential treatment due to their parents' sacrifice for their country. This bill directs the Department of Homeland Security to establish a Military Family Immigration Advisory Committee, and this committee will review the cases of non-citizen veterans and active service members through removal proceedings, and will provide recommendations on whether prosecutorial discretion is warranted or whether the removal proceedings should continue. And this will equip the Director of Homeland Security to grant special consideration to immigrants facing deportation who have served their country in the military, barring their participation in violent felony, to stop their removal. In addition, this bill allows immediate relatives of service members or veterans with an approved immigrant petition to be able to adjust their status and obtain a green card. The underlying amendment is punitive. First of all, anyone who's done a heinous crime should be assigned to their penalty. And in most instances, those individuals will be incarcerated in our prison system. At the same time, once they have paid their time, that is the way our justice system works. To suggest that those incarcerated will be plucked out of the prison, then away from their families and deported is a double penalty. They're already incarcerated, paying their penalty. They already have had victim statements when they were prosecuted and convicted. So let me give you an example. It is not a veteran, but how shameful the Department of Homeland Security, under this fearful threat from the past administration, sent a letter to one of my firefighters, a young man who loved his work, was married to a citizen, and was doing great as a firefighter in Houston. I hope I can find that young man. His wife had a panic attack, and rather than wait to be helped out of this horrible situation of getting a letter in the mail that you're about to be deported, he just simply resigned and went down to the location where his family was, missing out on his service to us and our receiving his service. We cannot run our immigration system out of fear and pain. We must run it out of respect for veterans, first responders, and others. And with that, I ask opposition to the amendment and support for the legislation. I yield back.
For what purpose does Mr. Roy seek recognition?
Speak on the Biggs Amendment.
With that, the gentleman is recognized.
I thank the chairman. I would note on the underlying measure, which I'll talk about more in a minute, the actual total number of deported veterans is unknown, but advocacy groups estimate the number to be around 300, to the best of my knowledge. And it's important to note that prior to removal, alien veterans are afforded due process through immigration removal proceedings and issued a final order of removal by an immigration judge. Now, I don't think any of us are not at least sympathetic to the question about service of a veteran and how that might affect their status in this country. But I'll have more to say about that in a minute with respect to the rules that apply to veterans, which apply to everybody. But all the gentleman from Arizona is doing, I mean, if I understand correctly, is simply saying that the literal text of the bill is that an exercise of discretion under paragraph 1A may only apply if the victim of the crime, so there was a crime and there was a victim, agrees that the individual should receive the exercise of discretion and the individual has satisfied all obligations of restitution, fines, fees, and any other obligations associated with the conviction. So all this amendment is saying for the world to understand is for this subset of individuals estimated to be around 300, maybe it's a little more, maybe it's a little less, even if we assume and accept the premise of the policy, which I think deserves a whole range of discussion and debate, that all that Mr. Biggs is saying is, okay, if the individual committed a crime, and our members of the military are not immune from the criminal proclivities of humankind, there are crimes committed, right? And then there's criminal justice for those crimes that are committed. So you commit a crime. And we're saying, well, don't victims have rights? And shouldn't that also be a part of the discussion about whether that individual gets permanent status in the United States? Gets to stay in the United States with the how many million people that are currently in line? How many people that are, known gotaways, 850,000 known gotaways over here in the last year and a half. We've got a completely broken border. We've got millions of people waiting to get here. Now you have an individual who served, and that's to their credit, but committed a crime. And all the gentleman from Arizona, I believe, is doing is saying, should we not account for the fact that the crime was committed, that the victim have a right to be able to be heard, a right to be able to present that, hey, this individual did this thing to me.
Would the gentleman yield?
I'll yield to the gentlelady.
I thank the gentleman. I would like to share with you the data that we received from the department in terms of.
If the gentlelady can make it reasonably.
I'll be very quick.
Expeditious.
Not all of the individuals who've been removed were convicted of anything, number one. And number two, some of the, who's the victim in a drug possession case or a nonviolent case, but additionally, it's not just consultation. This gives a veto to whoever the victim is. And
so generally, reclaiming my time,
and I thank the gentleman for
don't
you.
run out of time. No, of course, I'm happy. I enjoy colloquies, and I think they're important. I think, number one, so not all are, committed crimes, but there are criminals. The amendment speaks to the extent to which there was a crime and there was a victim. And to the extent there was a victim, that the victim should have a say in the status of that individual in the United States. And I think that is fundamental to it. And the idea of the sort of victimless crime, right, of drug possession. The amendment speaks to that, right? I mean, I think what the gentleman from Arizona is rightly identifying is when an individual actually commits a crime, there is a victim, that the victim ought to be able to say, wait a second, why is that guy or gal getting to stay in the United States, getting green card, getting status, getting a path to citizenship, whatever it might be, if, hey, I was the victim, right? And I thank the gentleman from Arizona. I support his amendment. I'll yield the 28 seconds to him if he wants to add anything.
I thank the gentleman. I'll just go quickly. When I hear the arguments against this, it seems consistent with the entire leftist Democrat mantra of of favoring victims over criminal defendants. This goes right to, if it's a victimless crime, if it's a DUI, let's say it's a DUI, you don't have a victim.
Gentleman yield.
This would not apply.
Gentleman yield.
It's my time and it's out. I yield back.
Gentleman's time has expired. Who seeks recognition?
I do.
What purpose does the gentleman from Rhode Island seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman, and thank you for bringing this important bill to markup. I rise in opposition to the amendment and in support of the underlying bill. With respect to the amendment, I would just say briefly, we don't have a private system of justice in this country. We have judges who make determinations and judgments all the time, but we don't allow individuals to determine the outcome of particular matters, and I think that's a very dangerous precedent, and that's why I think the amendment is not a wise one. But I want to thank you, Mr. Chairman, for bringing this really important bill to markup. Immigrants have always played an important role in our military, and their sacrifices to our country must be honored. 45,000 immigrants currently serve in our armed forces, and 2.4 million veterans, representing 13% of all veterans, are immigrants or the children of immigrants. The prior administration dismantled our immigration system, including for our immigrant veteran population, even wrongfully deporting veterans in violation of ICE policy. This legislation makes our immigration system more accessible to and fair for the brave immigrants who have fought for our country. Service members who make such incredible sacrifices for this country deserve a fair chance to make a home in the United States, regardless of their immigration status. I can think of few things that are more deserving of American citizenship than laying your life on the line for this country, our people, and our democratic values. I think the title of this bill, the Veteran Service Recognition Act, says it all. These veterans and service members must have their service recognized without burdensome hurdles. This is a matter of fairness, and we have a duty to honor our commitment to those who serve our country. I want to thank Mr. Takano for his leadership on this bill, and I urge passage of
Would
this
the gentleman
legislation.
yield?
And I'm happy to yield to the gentlelady from California.
I thank the gentleman for yielding. I just, listening to our colleague from Texas estimate that the number of people we're talking about is 300. I'm hoping that we don't spend 300 hours talking about that small group of people. There are, in this measure, provisions to protect public safety and the like. But I would note that from the information we've gotten from the MVETs that was revealed at our hearing, of the people who've applied for the administrative program, most of them are over 40. Most of the convictions are over 10 years old. Actually, the vast majority are 10 or 20 years old. It's important to note that the individuals who've been removed, they were legal permanent residents of the United States in almost every case. That's how they were able to be in the U.S. military. They could have naturalized if they had understood the process. Part of this bill is to ask our Defense Department to do a better job of having veterans, having our military personnel understand and access the naturalization opportunities. But I'll say this, all of us here, most of us here, had the good fortune, I'll just speak about myself, I feel lucky, so fortunate that I was born in the United States of America, that I'm an American citizen. I'm proud of that, and I'm grateful, and I'm happy. But I'll say this, if someone wants to sign up and risk their life in the United States military to defend our country, they're doing more to become an American than I did. I just had the good luck to be born here. And I think to strip them of their legal permanent residence, if they make a mistake after their service, is not the right thing to do. The Department of Defense estimates that up to 30% of the people who serve in our military suffer from post-traumatic stress disorder, and that is a major cause of problematic behavior, untreated PTSD. And so you have, if you take a look, and we're trying to get copies for all the members on the Republican side of the aisle, you have most of the these convictions are related to, or could very well be related to the service that the individuals had. And remember, this is not an automatic right. This gives discretion to the Department of Homeland Security Secretary to take a look at a case-by-case basis to see whether there should be a return for these 300 people that Mr. Roy has talked about. And I yield back, Mr. Cicilline, with appreciation.
And I yield back, Mr. Chairman.
For what purpose does the gentleman from North Carolina seek recognition?
To speak on the amendment.
The gentleman is recognized.
I thank the chairman. And I came in late, so I was a little bit disadvantaged as I was reading the amendment and then hearing sort of the vociferous objections to it, and I didn't even understand it. I think it worth hearing, though, that what the so Mr. Roy commented on or mentioned the relatively small number of veterans who were susceptible to deportation who were known, 300-something. Ms. Lofgren just spoke to that, and there was a little bit of information about them furnished to me that I thought worth making the committee aware of. That GAO report in 2019 said 68 veterans, 78% of them, were ordered removed because of at least one aggravated felony conviction, while the remaining 19, 22%, were ordered removed for non-aggravated felony convictions. Of the convictions I cited on the 87 veterans NTAs, 32 veterans had drug-related convictions, 20 had convictions related to sexual abuse, of which 18 involved minors. 21 had convictions related to homicide, assault, or attempted homicides or assaults. 16 had theft-related convictions, and 9 had convictions related to firearms, explosives, or explosive materials. I don't really understand, as sort of to the underlying bill, why this notion that the criminal conduct of admittedly veterans, but their criminal conduct in this particular instance should be sort of wiped clean.
Would the gentleman yield?
No, I've got one more point to finish, and then I'll do that, Ms. Lofgren. Why that would be wiped clean, and then I see, you know, you could arguably say the bill doesn't do that because it imports a discretion, and I'm a little uncomfortable. We'll say I'm very uncomfortable given the administration, the Biden administration's track record on immigration. I'm reticent to furnish yet additional discretion to the Homeland Security or the Secretary of Homeland Security because of the way it's been abused. But Mr. Biggs's amendment is so modest. It simply says, so you go back to that category of the 20 who had convictions related to sexual abuse, of which 18 involved minors. And this gives deference to the victims who suffered those crimes. And then that's characterized by the gentleman from Rhode Island as being private justice. I got to tell him, get up to speed, because there's been a revolution of victims' rights recognition in the country that's been going on for 20 or 30 years now. That is not private justice. This is a very modest amendment, and it's outright rejection, and even this kind of glowing, deference to service in the military, even to the disregard of grotesque criminal conduct. I don't get. I don't think it's very balanced, and I agree. I don't think we ought to have to debate over 300 so people for an extended time, but the presentation of the bill, particularly if it's not going to be able to be modified at all in reasonable ways, unfortunately invites the situation. And yes, I do yield to the gentlelady from California.
I appreciate that. I would like to note that on page 14 and 15, there are provisions that disqualify an applicant if there are grounds to believe the applicant is a risk to national security, if the applicant has committed or conspired to commit significant human trafficking offenses, if the applicant has been convicted of any of the following aggravated felonies: murder, rape, sexual abuse of a minor, crimes related to the operation of a prostitution ring and related human trafficking, or crimes related to the production, sale, possession of child pornography. Those cannot be waived. I would note.
Let me at that point reclaim my time. I'll give you more if I get done, but just to make the point that this 19-person advisory council is not restricted by those limitations at all. It can allow these folks in despite all those grotesque convictions. Let me yield to Mr. Tiffany.
I'll just put a finer point on this. You expect us to have full confidence in the current Secretary of Homeland Security, where the Border Patrol has said that he has lied about our border being secure, that he's done everything possible to funnel people into our country illegally, and you want us to give greater authority to him? That's reckless, and it's just wrong to do it. I yield back to the gentleman.
Let's vote. Yep.
I ask who seeks recognition, and I seek recognition, and I would yield my time to the gentlelady, Ms. Lofgren.
Yes, just a couple of clarifications here. The advisory committee that's been referenced has no authority to grant anything. They can give their advice to the secretary, but the secretary is limited by the elements of the bill itself. An applicant who has committed any of the offenses or poses any of the risks that I just read is ineligible for relief. On the issue of whether discretion can properly be exercised, as we know from our hearing, the Immigrant, Military, Members, and Veterans Initiative that the Department of Homeland Security is currently operating has received about 60 requests for relief and return to the United States from veterans and their families. Of these requests, 16 were granted and 8 were denied. So it's not as if, willy-nilly everything is going to be approved. And as for, I was a member of this committee in 1996 when we changed the definition of aggravated felony to something that is not commonly thought of as aggravated felony. The vast majority of the convictions mentioned in the GAO report are drug offenses. Now, I'm not for drug offenses. I think it's a serious problem. I know that people across, especially people who have suffered from PTSD, oftentimes turn to drugs to try and deal with the trauma that they're experiencing. That is a terrible thing. But I don't think the fact that someone has turned to drugs to solve a PTSD problem should disqualify someone from at least the potential of receiving relief. If they were a legal permanent resident of the United States, they had their status stripped after they were convicted and paid their penalty, whether it was jail or a fine, and now have been ousted from the United States and the country that they served in the military. That is not, I think, in keeping with the kind of country we want to be here, to honor those who served our country in the United States military. I would note that once again, that the advisory committee has no authority whatsoever, and the secretary is constrained, cannot consider applicants who've been convicted of any of the following aggravated felonies: murder, rape, sexual abuse of a minor, crimes relating to operation of a prostitution ring related to human trafficking, crimes related to the production, sale, or possession of child pornography, anyone who's committed or conspired to commit significant human trafficking exceptions, or anyone, if there's a reasonable ground to believe that the applicant is a risk to national security. So I would hope that we could put our veterans ahead of our politics in this markup, and that we could come together and enact this measure that will honor our veterans. As I mentioned in my prior remarks, discretion, the parole in place discretion for veterans and their families has been used many, many times. And actually, during the Trump administration, was used about 20,000 times. So this we don't have to get diverted into a partisan fight on this bill. We can come together, we can honor our veterans, and we can approve the bill and make it law, and I hope that we will. And with that, Madam Chairwoman, I yield back.
And I'll reclaim just a little bit of my time to just echo the sentiments of the gentlelady, Ms. Lofgren. I rise in opposition to the underlying, the amendment, but in support of the bill. And I'll just say from personal experience, I feel the very same thing that you said, which is I have such admiration for those who have served to defend our country in the military, citizen and immigrant. Think of the courage it takes as an immigrant and the aspiration and the inspiration it takes as an immigrant to say, I will step forward, I will risk my life for this country that I admire so much. I had two brothers serve in the Navy during the Vietnam War. One was on hospital and battleships, 2 tours of duty in Vietnam, the other stateside. I had a grandfather, Harry Eaton, who served in the Navy during World War I. I have such admiration for those who have served. I did not serve, so I hold them in awe, and I think that the underlying bill protects against the very thing that the maker of this amendment is worried about, and so with that, I yield back. For what purpose does the gentleman from Texas seek recognition?
Strike the last word.
Oh, he's up here. Oh, the gentleman is recognized.
I think people are looking at this all wrong, on my colleagues across the aisle. And in considering this, like I do, things involving the military, involving the safety of our country, as some of our Republican leaders will tell you, I don't play politics. I'm really considering what I believe is best for the country. And having represented people who were foreigners who joined the military in criminal matters, let me explain how we really should be looking at that process. People were brought in and were told, look, we're going to let you come into the United States and you're going to be on probation. You're going to serve in the military. If you serve honorably, you don't break our American laws, state laws. If you can serve honorably and well without breaking the law, then you got a shot to being a U.S. citizen, So along the way, these folks committed crimes. They were getting, and please understand, they were getting paid. Usually they were provided housing or a housing allowance. They were provided medical free. All of these things were provided as part of the agreement. But as soon as they committed a crime, then they breached the agreement, and the agreement required that they go back to their home. I didn't realize that on average, these convictions were 10 to 20 years old. But I have seen, and my understanding is normally if it's a crime within the military, they may serve the sentence, they may not, they may be deported before, but usually they'll serve the sentence and then they're deported. End of contract. You breached, you pay the price for the crime. That's not part of the deal. But then the deal is you go back home. And I do know that most people that join the military, it does take courage. And especially if you're a Chinese spy and you're going to come into the United States, that takes a lot of courage to come into the military this way. But other countries that want to see our demise, they see how vulnerable we are because of this kind of thing. There was no proper vetting when people were brought in to the military from foreign countries. A lot of times they just got proof of identity. That's good enough. We don't look for the crimes they may have already committed. But this bill does not, as has been said, it doesn't consider the victims. They ought to have a voice. And let me tell you, especially in the military, drug sale, drug transfers, they're not victimless. They do more damage to the overall preparedness of our military. They do great to the military itself. The military and America's preparedness for our enemies is dramatically affected by that. So understand, there's not anything rotten about America. This program was offered in a big-hearted way, but it was an agreement. It was an agreement that was breached by these folks. When I hear people say they serve so bravely, let me tell you, having represented some folks that were engaged in this scenario, they weren't brave. They were very destructive. So just keep that in mind. They weren't all Audie Murphy, you know. So one other thing, there is not apparently going to be proper vetting, because the same Homeland Security Secretary who told us that the border is secure and lied about that
Would the
and has
gentleman yield?
created an open, no, thank you, has left an open wound on our southern border that is just being infected worse and worse every day. We don't know who all is coming in. There's the kind of discretion we can expect. That Mayorkas will look the other way. All is good. All is right. God's in his heaven. It's all good. It's not. These are not the people to give discretion to. We need
Gentleman's
to
time
pass
has
this
expired.
amendment.
The gentleman's time has expired. For what purpose does the gentleman from California seek recognition? The gentleman is recognized.
Thank you for yielding. I'll just point out that if you're dishonorably discharged, you're not eligible for this program. So the scenario that our colleague from Texas just outlined, that person would not be eligible. And I thank the gentleman for yielding.
I thank the gentleman very much, and let me personally thank the gentleman from California for his service in his prior life to the community as relates to safety. Let me also thank any veteran that's in the room, any veteran that is my constituent, any veteran that is in America. Because in many instances, our veterans themselves are victims of PTSD, drug abuse, substance abuse, lack of housing, homelessness, separation from their family because of their bravery on the battlefield. I know my good friend from Texas, he has a good heart, and I know he did not mean to demean veterans and to suggest that they are not worthy because some of them are doing dangerous things or creating havoc. I wasn't really understanding, but I'm going to suggest that he did not mean that, because that would be a horrible comment to make about individuals who unselfishly put on the uniform, which include those who may not be citizens or legal permanent residents. And as has been said from the gentlelady from California, this legislation only applies to those who have been honorably discharged. It is clear under the Trump administration and their nativism approach, my way or the highway, or if you have one particular heritage, you're good. If you have another, you're not. We saw a drastic decrease of naturalizations of military personnel. It dropped from 8,770 to 4,570. I have another good friend. That good friend is from Arizona. I can't let the record remain in the suggestion that Democrats are for criminals and the ones on the White Horse are for victims. How dare you? We are for the American people, and we've chosen people over politics. We believe in justice, and this legislation is about justice. And I take umbrage to anyone suggesting that we would open the keys or we're for criminals. We're for criminals who are American people who get their due process. That means victims are in that process of due process. These individuals are incarcerated. What we are suggesting is, unlike other incarcerated persons, these people are deported. And the few that would count eligible under this bill, we're suggesting that their uniform, their service, warrants them having a second chance or not just being automatically deported. Democrats fight for Americans, and they fight for people who have been victimized by crime, their own family members, members who have been on this panel. So it'd be an untoward comment to juxtapose the idea of that we choose one group over another. As I said, we choose due process, justice, equality, democracy, fairness. And we embrace victims as they are needed to be embraced. I guess that's why we have fought so hard for the children who lost their lives in Uvalde, because we do feel the pain of the victims and victims' families. That's why we supported legislation that this very side stayed hours to rebut gun safety laws. Those are victims. Nobody seemed to be sympathetic there in the terms of what we were trying to do. So I just simply believe this is a very important legislative initiative, and I'd hope that we would all know that we care about all people and that we look at this bill on the merits of it and not suggest that one group versus another loves victims or loves criminals. We are for the American people, and we're for veterans, and we believe that victims should be embraced and supported, and we believe that men and women who put on the uniform and bled, as some of them have, deserve this legislation. They happen to be permanent legal resident and have not been able to become a citizen, to get a double, we all know double jeopardy is not the American way. They're incarcerated and then they're deported. That does not happen to others who are likewise incarcerated. So I ask to oppose the amendment. I yield back to the gentleman. I thank the gentleman for his kindness.
For what purpose does the gentleman from Ohio seek recognition?
Yield to the gentleman from North Carolina.
Gentleman is recognized.
I thank the gentleman from Ohio. I don't seek to engage in the debate with the gentlelady from Texas about concern for victims' rights. I think that there's enough evidence on that to be drawn from the experience of the citizens of New York City, Baltimore, Chicago, San Francisco, to make people's independent judgments on that. But I do think it's worth engaging with the gentlelady from California on what she said about the structure of this bill. Because I don't think it gets everything out that it needs to. She suggested, the gentlelady, Ms. Lofgren, that there are guardrails on the ability of the Secretary to act, to grant discretion under this. But let me explain what I read a little more closely. In Section 7 of the bill, if someone has been issued an order of final removal or they have been deported, then the guardrails that the lady described are there. They can't get an additional consideration to be brought back into the country or have the removal order canceled or rendered ineffective if they've been guilty of terrorism, sex trafficking in persons, murder, rape, child sex, child exploitation, prostitution, maybe another one I can't read. However, the issue is under this advisory council, that's under Section 4, and that operates in a different circumstance. That operates when someone is eligible for removal, but has not been removed, there's no removal order yet, and they have not already been deported. And in that case, the advisory council can recommend parole, it can recommend deferred action, it can recommend a stay of removal. And although literally the Secretary is not bound by the decision of the advisory council, it is a 19-member advisory council, and the legislation does explicitly require the Secretary to make regular reports to the advisory committee, quote, including detailed explanations for any cases in which a recommendation of the advisory committee was not followed. That certainly creates a pathway, or creates what is likely to happen in the overwhelming majority of circumstances. There are no guardrails for those who are in the United States, commit crimes, and on the predicate of their having served in the military are exempted from the processes of immigration law.
Mm-hmm.
Would the gentleman yield?
It's not my time. I'll yield back to the gentleman from Ohio, but I'd love to engage in colloquy because that's how I understand it to operate.
Yield to the gentlelady.
It's not a 19-member, it's a 9-member board, and It's advisory,
I don't think that's probably material.
just a note. It's advisory in removal proceedings, and it has no authority. So you could have a situation where a person, well, this is something that our colleague Bobby Scott used to talk about, where you have an 18-year-old engaging in relations with a 16-year-old, and it results in a conviction. You could have the advisory board say, well, this was consensual, even though you can't give consent when you're 16. That could be weighed, but it doesn't have any legal authority. It doesn't have, and it's only in removal proceedings. It's not for return of one of the 300 who is sitting in Tijuana waiting for, and I thank the gentleman for yielding.
I thank the gentlelady for that point. I think the bigger point is that this is a transmission belt to this, for how this process will occur. Yes, in an extraordinary case, there could come to pass that there would be an agreement, a disagreement between the advisory council and the secretary may refuse it. It's not going to ever happen in practicality. It might happen once in a blue moon. But the big point is that the guardrails the gentlelady described are not on the table to constrain any action that would prevent removal from being commenced against someone, and for all the future in which this law would presumably apply, and the numbers grow well beyond the 300 that appeared covered in the GAO report, all the new cases are wide open for maximum discretion in this advisory council without any guardrails. I yield back to the gentleman.
Would the gentleman yield? Because in removal proceedings, you have an immigration judge, you have the attorney, the prosecutor, and occasionally you have a defense counsel. Today, in every single removal proceeding in America, there is the prosecutor can use discretion. That's the case in every single courthouse in America, including immigration court. So this doesn't change that.
The gentleman's time has expired. The chair recognizes that votes have been called, so we will see if one more member seeks recognition. For what purpose does the gentlewoman from Washington seek recognition?
Madam Chair, I move to strike the last word.
The gentlewoman is recognized.
Thank you. I would like to speak in opposition to the amendment and for the bill, and I would just start with bringing us back to the purpose of the bill. Immigrants have defended the United States in every major conflict since the Revolutionary War. In fact, one of the first casualties in the Iraq War was of Lance Corporal Jose Antonio Gutierrez, who was not an American citizen when he died fighting for the United States. At age 17, he made the 2,000-mile dangerous journey by train, foot, and bus to the United States from Guatemala. He was adopted by a family in the United States, and he joined the Marines, wanting to give back to the country that gave him everything. Today, there are 45,000 immigrants serving in the U.S. Armed Forces, many of them likely motivated to enlist for the same reasons as Jose Antonio Gutierrez. And yet hundreds of immigrant veterans are estimated to have been deported. The Veteran Service Recognition Act would take the crucial steps necessary to stop this from happening and to provide relief to veterans who have already been deported. And as you've heard from Representative Lofgren, the guardrails are actually very, very strong. The truth is that this bill shouldn't be necessary. The idea of deporting individuals who enlisted in the military, who are ready to put their lives on the line to defend the American people and our democracy, is just wrong. And, you know, it's tragic when a service member comes home suffering from PTSD, makes a mistake, and is banished from the country that they fought to defend without any consideration for their services. Now, some of my colleagues on the other side would have you believe that many of these service members should not be granted legal status because of interaction with the criminal justice system. But we know that 11 to 30% of veterans have PTSD or have experienced some form of it from that very act of defending our country. And we also know that people suffering from PTSD are 60% more likely to become entangled in the criminal justice system. When people have suffered trauma, especially, but certainly when it's in service to this country, we should be responding with treatment and help. not handcuffs and jail. And for immigrant veterans, we have to ensure that they're not deported from the country that they risk their lives for. Immigration and Customs Enforcement is supposed to consider veteran services to this country when making removal decisions, but a 2019 GAO study found that ICE attorneys, quote, did not consistently follow its policies involving veterans who were placed in removal proceedings, in part because ICE officials were unaware of the policies. That's a direct quote. We can't leave this to chance. Even one deported veteran is too many. And when people sign up to defend this country, we should be helping them to become U.S. citizens as quickly as possible. And that's exactly what the bill.
Would the gentlelady yield? Would the
I would.
gentlelady? I want to thank you for pointing that out, that the ICE prosecutors didn't realize that they should consider the veteran status. And that's the major reason for this advisory committee, to at least heighten the awareness of the prosecutors that here's a vet, and that needs to be part of the consideration. They don't have a say. They shouldn't have a say. That's going to be, the prosecutor, and maybe there'll be a defense counsel and the judge, but at least they'll know this is a vet, and that's a real reason why we put the advisory committee in there, and I thank the gentlelady for yielding.
Very, very important point. Thank you, Representative Lofgren. We're also talking about a very limited number of individuals. Estimates put the number of deported veterans in the hundreds. DHS has already demonstrated that it's highly capable to help facilitate the return of deported veterans through the Immigrant Military Members and Veterans Initiative. As of June, the IMMVI team has received 60 requests for relief and return from veterans and their family members. So far, the team has granted 16 of those requests and denied 8. So these numbers just refute the fear-mongering from the other side. This program to return deported veterans to their families and communities is working. The individuals are carefully vetted and denied when warranted. I'm proud that President Biden has taken action to prevent and address deported veterans early in his administration, but now Congress needs to do our part. And that starts with passing this bill. I urge my colleagues to vote yes on the underlying bill and no on the amendment. I yield back, Madam Chair.
The gentlelady yields back. We have 2 votes on the House floor. Therefore, the committee will stand in recess until immediately after the conclusion of those 2 votes. The committee stands in recess.
So the Judiciary Committee will come to order after our brief recess for votes on the floor. It's my understanding that Mr. McClintock would like to strike the last word.
No,
You're
actually, I'd like to
recognized for 5
speak on the amendment under the
Correct.
5-minute rule. Thank you, Madam Chairman. I just wanted to begin by offering a few translations of the bureaucraties and gobbledygook that we've heard in description of this bill. One description was, well, we thank our veterans for their service by deporting them. Well, no, we deport them because they committed crimes and were ordered removed by a court of law. We're told, well, the bill's very narrow. Well, except for one thing, it presumes that any alien, not just someone who served in the military, any alien by virtue of lawful permanent residence is presumed to have established good moral character. But the best was, well, they just messed up. What that means is they committed crimes. Now, what Mr. Biggs' amendment says is that the victims of their crimes ought to have a say before they're admitted back into the country, or at least the convicted criminal should be required to pay the fines that they were assessed for their crimes before they're allowed back into the country. This provision extends far beyond just the foreign veteran who committed crimes and was deported. This bill includes family members who've been ordered deported, and it extends to any person with a green card the automatic presumption that they've proven good moral character. Now, one member said, well, we don't have a private justice system, and that is absolutely true. We have a public justice system based upon due process of law. Now, what the bill says is that after you've had due process and it's run its course, and after an immigration judge orders removal, then Ali Mayorkas and his committee can overturn that judgment, ignore the law, and reverse that decision and ignore the victims. This bill says, well, Mayorkas can ignore the entire judicial process, but he can't ignore the victims. Yeah, at least we should ask the victims of these crimes to have a say in whether the criminal who impacted their lives should be left back in the country, and to place the few criminals who served in the military alongside the many law-abiding immigrants who served in the military is a remarkable insult and injustice to our law-abiding veterans. It said well, the bill puts people over politics. No, it puts criminals over victims. And I'll yield bounce
Would the gentleman?
I'll yield bounce my time to Mr.
Would the gentleman
Biggs, if he'd
yield?
like.
Thank you. I thank the gentleman for yielding to me. I want to put this in context, and I think Mr. McClintock has done a great job putting it in context. First of all, the current state of law is a non-citizen serving in the military is going to gain status. Second of all, this bill focuses on criminals. That's what it's focusing on, criminals. Criminals who've had their day in court, they've had due process, as Mr. McClintock pointed out. It also goes to their family members. This bill says if you've been removed from the country as a criminal with certain having been convicted of committing certain crimes after receiving due process both in the immigration courts and the criminal courts, that you cannot, the Secretary cannot not allow you back in, doesn't have the ability to waive those things. But if you have not yet been removed, the committee is under no such constraint. They can provide a recommendation that you remain in the country. And while that's maybe non-binding, the Secretary is still required to report back to that committee, that advisory committee, on what the Secretary has done vis-a-vis that recommendation. Now, let's consider, because the argument has been made, well, the victims are accounted for because the Secretary is constrained, but that's only post-removal after the veteran has been convicted and had due process under immigration laws. So here's the way it works. Aggravated felony. These are the only aggravated felonies that bind the Secretary. Murder, rape, sexual abuse of a minor, child pornography, and in some sexual trafficking cases. But it doesn't preclude the Secretary from allowing in people who have committed a crime of violence for which the term of imprisonment is at least 1 year. No, that's an aggravated felony. Nor does it proscribe or constrain the Secretary on any of the other aggravated felonies listed in the title. That is the problem. And the one group of people that are not considered at all are the victims. I'm just saying, why don't we consider the victims? Let them have their say. Let them participate. That's what I'm saying here. And with that, I'll yield back to the gentleman from California.
Thank you. I'll yield to my friend from California in the remaining moments.
Thank you, Mr. McClintock. I believe it's clear that the section on page 14, the provision relative to clarification is only about veteran non-citizens, but if the gentleman is concerned that that is not clear, we'd be happy to ask unanimous consent to make it clearer that it's veterans non-citizens, that
I
it's not
appreciate that,
intended.
because our analysis is pretty clear on the point. It involves any alien. So if
Well,
you're willing to amend the bill.
I don't think
to
it does,
make
but
that-
we do not want any uncertainty on it, and so we will ask unanimous consent to insert veteran non-citizens in
Thank
the
you for making a
appropriate
terrible
sections.
bill a bad bill.
So without objection, that amendment will be adopted, and I now recognize Ms. Escobar to strike the last word. You're recognized for 5 minutes.
Thank you, Madam Chair, and I'd first like to express my strong support for this bill, which I think is an act of patriotism to recognize the women and men who have so selflessly served on behalf of our nation. It honors our veterans, it honors our commitment to veterans, and I cannot imagine that anyone in the U.S. Congress would vote against our veterans. Having said that, I would like to yield the remainder of my time to the distinguished gentleman from California who has been a champion for all veterans, but especially deported veterans, Mr. Correa.
Thank you, Ms. Escobar. Just wanted to say and remind folks that due process does not guarantee justice. So we have veterans that are convicted, do their time, pay their price, pay their crime, restitution, and then they're deported. So they pay twice for a crime. In America today, we hold veterans to a higher position in our society. We appreciate their sacrifices for our country. And that's why we have what are called veterans courts. Veterans courts recognize that veterans do run into the law. They have troubles. But if you're a veteran and you enter a veterans court, for drug offenses, for other offenses, you have a different track to follow, to be rehabilitated, to again address those invisible wounds that you may have brought back from the battlefield. We want to get you back on your feet. I've had the opportunity to visit deported veterans in Tijuana, Mexico a few times. It's interesting to see what they've done out there. They've gotten together, they built what's called a bunker where they live, big American flag, and this is their place. I've had the opportunity to talk to a number of them. I remember one individual struck up a conversation, told me he had done 8 tours of duty in Afghanistan. And I said, so what happened? He said, one day I woke up, was choking my wife in the middle of the night. Was convicted and deported. All these individuals, all these deported veterans are honorably discharged. They have followed the laws, have served our country with honor. Then something happens in their lives. Most of these convictions are, of course, for drug and other offenses. But they are veterans. And I think we have to remember that they are veterans. They took an oath to defend our Constitution, our nation, and took a pledge of allegiance to our flag. Not to a foreign flag, not to the flag of their birth, but to the American flag. And for that, we are not recognizing their sacrifices. Most of these veterans, deported veterans, are from the Philippines because of the active participations of Filipinos in our military. I just ask this committee, our members, we can nitpick this bill to death, but we ought to talk about how to make this good legislation that'll honor the service, the sacrifice, our immigrant veterans, their contribution to this great country. Thank you very much, and I yield the remainder of the time to Ms. Escobar.
Thank you, Mr. Correa. Madam Chair, I yield back.
The lady yields back. Does anyone wish to be recognized further? Hearing no one, then the question occurs on the amendment made by Mr. Biggs. All those in favor will say aye. All those opposed will say no. No. In the opinion of the chair, the noes have it, and a roll call is requested. Clerk will call the roll, please.
Mr. Nadler? Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Raskin? No. Mr. Raskin votes no. Ms. Stripal? Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean? Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Shabbat? Mr. Gomert?
Yeah, that's aye.
Mr. Gomert votes aye. Mr. Issa? Mr. Issa votes yes. Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates?
Aye.
Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Stube?
Yes.
Mr. Stube votes yes. Mr. Tiffany?
Tiffany, aye.
Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach?
Yes.
Ms. Fishbach votes yes. Ms. Sparts? Mr. Fitzgerald? Mr. Benz?
Mr. Benz votes yes.
Mr. Benz votes yes. Mr. Owens? Mr. Owens votes aye.
How is Swallow recorded?
Mr. Swallow, you're not recorded.
No.
Mr. Swallow votes no. Mr. Nadler, you are not recorded.
I vote no.
Mr. Nadler votes no.
Madam Speaker, how am I recorded? Hank Johnson.
Mr. Johnson, you are not recorded.
Vote no, and I've got Sheila Jackson Lee on this line.
Madam Clerk, how am I recorded?
Ms. Jackson Lee, you are not recorded.
I vote no.
Ms. Jackson Lee votes no. Mr. Johnson of Georgia votes no.
Mr. Chairman, how am I recorded?
Ms. McBath, you are not recorded.
McBath votes no.
How is
Ms.
Mr.
McBath
Shabbat recorded?
Mr. Shabbat, you are not recorded. Mr. Shabbat votes aye.
How am I recorded, Mr. Chairman?
Mr. Deutsch, you are not recorded.
No.
Mr. Deutsch votes no.
Clerk will report.
Madam Chair, there are 15 ayes and 16 noes.
The amendment is not adopted. Are there any further amendments to the bill?
Madam Chair,
Mr. Biggs,
I have an amendment at the desk.
clerk will report, and a point of order is reserved by Mr. Correa.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Biggs of Arizona. Page 14, line 20, strike quote 3 and insert quote 36E, quote, page 14, beginning on line 23, strike quote or K, quote, and insert quote K or N, quote.
The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Madam Chair. Again, I just want to clarify, if the current state of the law is a non-citizen serving in the military gains legal status by virtue of service, or a change in status potentially. But this bill is focusing on what happens when someone is ordered removed, and has been ordered to be removed, or is in that process. And for the vast majority of these, we've heard repeatedly, is for criminals. These people have committed crimes. The Secretary cannot waive the removal and entertain repatriation for certain criminal conduct. The advisory committee is not so constrained. But the Secretary must report on how the Secretary has responded to that advice. The advisory committee deals with the pre-removal process and not the repatriation necessarily. So this amendment is interesting because I've in previous markup, some Democrats expressed a desire to work with me to address human smuggling. And I was told that while they understood that we must address human smuggling, that bill was not the appropriate bill at that time to address the issue. Well, today I'm offering an amendment to ensure that aliens who engage in smuggling activities are not eligible for the benefits of this bill. And I hope my colleagues still agree that we must address the issue of human smuggling and will support my amendment. The law is clear, says any alien who at any time knowingly has encouraged, induced, assisted, abetted, or aided any other alien to enter or to try to enter the United States in violation of law is inadmissible. That sounds a lot like potentially dealing with the cartels. As drafted, however, the bill allows the Secretary to specifically waive this ground of inadmissibility. I don't know why the majority chose to allow smugglers to benefit from this bill, but I hope that they will recognize that this should not be allowed and will support my amendment. This amendment won't necessarily stop smugglers, but it will perhaps be a deterrent, and it certainly will prevent rewarding human smugglers. I urge the adoption of this amendment, and I'll yield back.
The gentleman yields back. The gentleman from California does not insist on his point of order, I'm sure, since the amendment is germane. And I will recognize myself in opposition to the amendment. I would note that the underlying bill already includes, as a prohibition for consideration by the Secretary, 212A2H, which is significant traffickers and persons. The sections that the gentleman seeks to include as non-waivable includes offenses that in some cases can be minor. Let me give you a real-life example of someone who I actually know who fell into this category. This person, I'll call him Juan, was a legal permanent resident of the United States, and he had a birthday, and he and his girlfriend went to Tijuana, and they really had a great party, and he became inebriated. And because he didn't want to drive drunk, he had his girlfriend drive his truck back across the border. Well, Juan was a legal permanent resident of the United States, but unfortunately, his girlfriend was not. And so when they attempted to re-enter, he was charged with alien smuggling because it was his truck and she was driving, and she was undocumented. Obviously, because she was undocumented, she was not going to be admitted, but that is a real-life circumstance that I happen to deal with as an immigration lawyer, where, you know, the Secretary, if Juan were a veteran of the United States and did several tours of duty in Afghanistan, you might want to consider whether or not that was an extreme enough offense to require that veteran to be deported to another country. This is discretionary only, and we do want to make sure that people who are in the cartels, people who are involved in significant alien smuggling may not be considered for relief, but I think the gentleman's amendments would preclude consideration of potentially meritorious cases. Obviously, this is limited to veterans, and as we know from the track record so far, about half of the applicants have been rejected by the Secretary. The fact that you can at least be considered doesn't mean that you're going to receive approval. So I would urge, I'm sure that the gentleman's intentions are the best, but I think the amendment is unnecessary and would urge its defeat. And with that, I would yield back my time. Do other members wish to be heard on this amendment? If not, then the question occurs on the amendment. All those in favor will say aye. All those opposed will say no. 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 In the opinion of the chair, the noes, and Mr. McClintock asked for a roll call, so the clerk will please call the roll.
Mr. Nadler?
Spearhead that, and even when they got to the Senate,
Please mute.
Ms. Lofgren?
No.
Ms. Lofgren votes no.
I'm going to move quickly.
Ms. Jackson Lee?
Ms. Bush, you need to mute. Ms. Bush?
No.
Ms. Jackson Lee votes no.
And if not, we will.
Ms. Bush, please
Mr.
mute.
Cohen?
No.
Mr. Cohen votes no.
No.
Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu? Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
Dean votes no.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes.
Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert?
Aye.
Mr. Gomert votes aye. Mr.
Thank you.
Issa? Mr. Issa votes aye. Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stube?
Yes.
Mr. Stube votes yes. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Sparts? Mr. Fitzgerald?
Aye.
Mr. Fitzgerald votes aye. Mr. Benz?
Aye. Mr. Benz votes aye.
Mr. Benz votes aye. Mr. Owens? Mr. Owens votes aye.
How is the chairman recorded?
Mr. Nadler is not recorded.
I vote aye. I vote no.
Mr. Nadler votes no.
Adler votes no.
Mr. Johnson? How is Mr. Johnson?
Mr. Johnson of Georgia is not recorded.
How am I recorded?
Mr. Deutsch, you are not recorded.
No.
Mr. Johnson, you need to unmute in order to vote.
Mr. Deutsch votes no.
Mr. Chairman, how am I recorded? This is Mr. Neguse.
Mr. Neguse, you are not recorded.
Neguse votes no.
Mr. Neguse votes no.
Madam Chair, how am I recorded?
Mr. Liu, you are not recorded.
Lou votes no.
Mr. Liu votes no.
How is
Madam Chair, this is Congressman Jeffries.
How am I recorded?
Mr. Jeffries, you are not recorded.
Jeffries votes no.
Mr. Jeffries votes no.
How is Mr. Johnson recorded?
Madam Speaker, how am I recorded?
Mr. Johnson, you are not recorded.
No.
Mr. Johnson of Georgia votes no.
That's right. Okay. You know what my situation is?
Are there any other members wishing to record their vote or to change their vote? If not, then the clerk will please report.
Madam Chair, Congressman Tiffany.
Oh, before the clerk reports, Mr. Tiffany, how are you?
Mr. Johnson needs to vote, just.
Tiffany, aye. Thank you very much, Madam Chair.
Mr. Tiffany votes aye.
Ms. Jackson Lee, how would you wish to vote?
Aye. And Mr. Johnson got disconnected. I was trying to help him.
Mr. Johnson has voted no. How would you like to
All right,
vote, Ms.
great.
Jackson Lee?
No.
Ms. Jackson Lee votes no.
Mr. Chairman, how am I recorded?
Ms. McBath, you are not recorded.
McBath votes no.
Ms. McBath votes no.
Do additional members wish to be recorded? If not, the clerk will report now.
Madam Chair, there are 16 ayes and 22 noes.
And the amendment is not agreed to. I would like to recognize myself for a unanimous consent request to address the issue that Mr. McClintock raised that we thought was covered, but we want to make it abundantly clear. We would insert by unanimous consent on page 15, line 21, strike non-citizens and insert non-citizen veteran status under this section. And it's my understanding this language has been worked out between the council for both the Republican and the Democratic side, making this abundantly clear. So without objection, that will be adopted. Are there additional members wishing to be recognized?
Madam Chair, I have an amendment at the desk.
Gentlemen, clerk will distribute the amendment, and Mr. Correa reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Biggs of Arizona, page 14, line 20. Strike quote 3, quote, and insert quote 310D, quote.
Gentleman is recognized for 5 minutes to explain his amendment.
Thank you very much, Madam Chair. Again, I want to remind everybody that's here, those who may be watching now or in the future, is that the current state of the law is that non-citizens serving in the military are protected. But this bill, the underlying bill, focuses on those who have been removed because they've been convicted of criminal conduct or are in the process of being having their status adjudicated because they've committed and been convicted of a crime. The Secretary cannot waive and bring people back into the country if they've committed certain limited crimes. The advisory committee is not so constrained and can recommend prior to removal that somebody who has committed a crime, including aggravated felonies under the statutes, that they be allowed to remain in the country. The Secretary is required to report to the advisory committee the Secretary's performance vis-a-vis the advisory committee's recommendations. I suggested that maybe the victims of these crimes should be heard before a change in status one way or the other, either by the advisory committee or by the Secretary. The majority rejected hearing from
Would the gentleman
victim.
suspend for just an inquiry? Because
Yes, I'll suspend.
I think you are discussing a different amendment than what was passed out. Yeah, 10D.
Yeah, I'm getting there. Let's just call it the warm-up.
Okay, I'm sorry. I just wanted to make sure we were all on the
I
same
may be taking a little bit longer in the warm-up than you anticipated, Madam Chair.
Okay, that's fine. We'll make sure you're
I'm
not.
trying to provide context for this.
All right, we'll make sure you're not shorted on your time. Thank you.
That's fair enough, thank you. So the first point being, I brought up, victims should be heard before you either remove or return, right? So that'd be the first thing. And then I followed that up by saying, well, if you're a human smuggler, you should not be able to be brought back into the country, or that should not be waived as well. That should be considered. So, and I didn't get anywhere with those two. So I thought maybe what you're interested in is something that I hope wouldn't be as controversial. And so this amendment adds unlawful voting as a ground of inadmissibility that cannot be waived by the Secretary. So I didn't think that would be controversial, but I'm probably wrong. I hope that we all agree that individuals who voted illegally should not be rewarded. As currently drafted, this bill allows the Secretary to allow individuals who voted illegally to receive the benefits of this bill. And the other bill that we're going to consider today specifically prevents the Secretary from providing relief to aliens who voted illegally for some reason. This bill omitted that provision. And my amendment will make the two bills consistent in this regard. I urge the support, and I'll yield back. And I think I finally got around to that, what the amendment's about,
Okay.
Madam Chair.
All right, and the gentleman yields back. I recognize myself, Mr. Correa withdraws his point of order. His amendment is germane, and I recognize myself in opposition to the amendment. The prohibition on voting, unlawful voters, is one that does not actually have a knowledge requirement. And, well, I'll give you an example of someone, an individual who would be excluded from benefit. A veteran, his name is Paul Canton. When he joined the military, his recollection is that the recruiter promised him that he would automatically become a U.S. citizen if he served 4 years and had an honorable discharge. So he served 4 years, he received an honorable discharge, and then he re-upped for 4 more years on inactive reserves, and during his time in the U.S. Marine Corps, he was awarded a National Defense Medal, a letter of appreciation, a service employment ribbon, a good conduct medal, and a rifle marksman badge. Now, following the completion of his military service, he believed, and he was incorrect, that he was automatically a U.S. citizen, and believing that he was eligible, he voted in several elections. He is married to a United States citizen. He has 2 teenage sons, one of whom is planning to follow in his father's footsteps and join the United States Marine Corps. But because his mistaken belief that he was a U.S. citizen is no excuse for his unlawful voting, he is at risk of being deported. Now, I think that we need to have a case-by-case review of these circumstances. I will say also this, that although some have suggested that there's widespread voter fraud, there's really almost no evidence to support that suggestion. A 2014 Harvard study found that the likely percent of non-citizen voters in recent U.S. elections is 0. The 2017 Brennan Center analysis found that non-citizen voting is vanishingly rare. If you take a look at the code, the only exception in terms of a knowledge situation is a mix-up with an adoptee. I'll give you another real-life example. This is someone, again, from my immigration background, a woman who she was orphaned And her older brother told her that she was born in San Diego. And they were actually in the circus business, and they would go back and forth across the border very frequently. And he told her this because he didn't want her to say she wasn't a U.S. citizen. She grew up believing she was a U.S. citizen. And it wasn't until she was in her 50s and she and her U.S. citizen husband went to go get their passports that she found out that her brother had lied to her, and she wasn't, in fact, a U.S. citizen. She lived her all her life, married a U.S. citizen, had her children, and couldn't get her passport. She had been a voter because she thought it was her responsibility. She never in a million years dreamed that it was illegal. So this happens from time to time, not often, and we need to have at least the capacity to consider the facts. This would remove that capacity, and therefore I think it would be a mistake to adopt this amendment. With that, I would yield back my time. What purpose does Mr. Shabbat seek recognition?
Move to strike the last word,
And the
Madam
gentleman's
Chair.
recognized for 5 minutes.
Thank you, Madam Chair. I support Mr. Biggs' amendment and commend him for offering it. I'd like to address my comments to the bill overall. One of the most rewarding parts of this job, I find, is working with veterans and recognizing and honoring the sacrifices that so many of them have made for our country. Every community in this nation is blessed to have men and women who have bravely placed themselves in harm's way to defend our values and our freedoms. We must never forget their sacrifices or the debt that we owe to veterans of all ages and all backgrounds. This Congress, this particular Congress, and those in the past, I've taken a number of steps along with my colleagues on issues that impact veterans' care and benefits, and I'm going to continue to do and support those things that do support the veterans community, such as helping some veterans to overcome addiction, which is often coupled with post-traumatic stress disorder. In my district in Cincinnati, for example, the Joseph House is leading the way on that front, and they and the veterans that they serve need and deserve our support. I've been there many times over the years, and they improve their services on an ongoing basis, and they're really a great organization. Organizations like the Joseph House are critical in providing additional resources outside the VA so that all veterans have access to the help that they need, regardless of where they live. My concern with this legislation is principally twofold. First, it authorizes the Secretary of Homeland Security to issue a green card to alien veterans who have committed removal offenses, been afforded due process in an immigration court, and ordered removed by an immigration judge. These individuals have already had their day in court. Second, it would also allow the Secretary of Homeland Security to prevent the removal of an alien who previously served in the military, but who would otherwise be subject to removal for committing a serious crime, like drug trafficking or assault with a deadly weapon or trafficking in weapons and a number of other major crimes. So they've committed a crime. Veterans and service members are already provided with special avenues towards naturalization. In fact, during the last 5 fiscal years, USCIS naturalized nearly 30,000 service members. Most importantly, though, before considering legislation like the one before us today, we ought to focus our efforts on securing our southern border. The truth is that the situation at that border is an unmitigated disaster. And unfortunately, the massive influx of illegal border crossings that we're currently experiencing allows human trafficking networks to flourish. They're making a tremendous amount of money on the backs of the people that they're exploiting. The legislation before us today, unfortunately, is not at its core really about service members and veterans who have fought on behalf of this country, but instead is just another attempt to weaken U.S. immigration law rather than secure our border. Our border is something that makes us a country. Unfortunately, the Biden administration has reversed all the policies that were actually working in the previous administration. They've ended the building of the wall. Those materials are laying rusting out there, and the American taxpayers paid for those things. The people come into this country, they're put by the administration on a plane or on a bus. They're shipped all over the country, and members of Congress continue to be refused when they've asked for information about where these folks are going. The administration keeps that secret away from members of Congress as well as away from the press. It's an absolute, I think, an abomination of what the administration has been doing for quite some time, and it's getting worse. So I would strongly urge this committee to focus on legislation that would benefit veterans and ensure the safety and security of all Americans. We can do both of those things. We can help veterans, but we can also help the public overall by making sure that we have a secure southern border, which we certainly do not have now. And I yield back.
Gentleman yields back. Do additional members wish to be heard on this amendment? If not, then Mr. McClintock?
If I could just add one thought, and that is
Gentleman's recognized for 5 minutes.
we keep hearing this notion that, well, this is just going to be applied on a case-by-case basis. Yet this administration has a record of granting blanket paroles or refusing to enforce the laws by claiming prosecutorial discretion, not on a case-by-case basis, but rather across the board on the basis of membership in an entire class. So asking to extend a power to an administration that has amply demonstrated a willingness, in fact, an eagerness to abuse the authority to make case-by-case decisions, I think is asking for too much. You know, a judge or a jury already can take individual personal considerations into account without giving Ali Mayorkas the power to override these decisions made in our courts by substituting his and his advisory committee's judgment for that of this process. So with that, I'll yield back.
Gentleman yields back. The question occurs on the amendment. All those in favor will say aye. Aye. All those opposed will say no. No. In the opinion of the chair, the noes have it. A recorded vote has been requested. The clerk will please call the roll.
Mr. Nadler. Ms. Lofgren.
No.
Ms. Lofgren votes no. Ms. Jackson Lee.
No.
Ms. Jackson Lee votes no. Mr. Cohen. Mr. Johnson of Georgia. Mr. Deutsch. Ms. Bass. Mr. Jeffries. Mr. Cicilline. Mr. Cicilline votes no. Mr. Swalwell. Mr. Liu.
Lou votes no.
Mr. Liu votes no. Mr. Raskin. Ms. Drypal. Ms. Stimmings. Ms. Stimmings votes no. Mr. Correa.
No.
Mr. Correa votes no. Ms. Scanlon.
No.
Ms. Scanlon votes no. Ms. Garcia.
No.
Ms. Garcia votes no. Mr. Neguse. Ms. McBath.
McBath votes no.
Ms. McBath votes no. Mr. Stanton.
No.
Mr. Stanton votes no. Ms. Dean?
Dean votes no.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert?
Aye.
Mr. Gomert votes aye. Mr. Issa?
Congressman Issa votes yes.
Mr. Issa votes yes. Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach? Ms. Fishbach votes yes. Ms. Spartz? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz?
Mr. Benz votes yes.
Mr. Benz votes yes. Mr. Owens? Mr. Owens votes aye.
Nadler votes no.
Mr. Nadler votes no.
Swalwell is no.
Ms. Jayapal?
Jayapal votes no.
Ms. Jayapal votes no.
Mr. Raskin?
Mr. Swalwell votes no.
Mr. Swallow votes no.
Mr. Cohen votes no.
Mr. Cohen votes no.
Johnson of Georgia votes no.
Mr. Johnson of Georgia votes no.
How is Mr. Raskin recorded?
Mr. Raskin votes no.
We weren't sure how.
Are there additional, are there additional members wishing to cast or change their vote? Mr. Jeffries, you need to unmute so we can hear you.
Sorry, Madam Chair. How am I recorded?
Mr. Jeffries, you are not recorded.
Jeffries votes no.
Mr. Jeffries votes no.
Thank you.
Are there additional members wishing to vote or to change their vote? If not, the clerk will report, please.
Madam Chair, there are 15 ayes and 20 noes.
And the amendment is not agreed to. Are there additional members wishing recognition to be recognized at this time? Mr. Johnson?
Madam Speaker, I have an amendment at the desk.
Clerk will report, and a point of order is reserved by Ms. Escobar.
Madam Chair, I reserve a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 7496, offered by Mr. Johnson of Louisiana. Strike Section 7.
The gentleman is recognized for 5 minutes in support of his amendment, and the point of order is not insisted on since this is obviously germane. Mr. Johnson.
Thank you, Madam Chair. This amendment would eliminate all of Section 7 of the bill, and that section allows those veterans who have already been removed or given a final order of removal to both return and be granted lawful permanent residency, which is the most important step on the path to citizenship, as we know. But here's the problem. It gives the Secretary of Homeland Security carte blanche authority, unilateral authority to waive nearly any ground for inadmissibility for these non-citizen veterans. It gives the Secretary total discretion to give this lawful permanent residency This is a problem because under this section, veterans who are removed at any time in the past can return even if they've been living for decades in another country. There's nothing in this bill that requires the Secretary to review their actions while in that other country, such as whether they may be enlisted in another military force, maybe an opposition force to our country, or worked for a government that is unfriendly to the U.S. And these veterans had plenty of opportunity, of course, to apply for citizenship during their service or within 6 months of departing from the U.S. Armed Forces. They, for whatever reason, chose not to. All these veterans who were removed were afforded due process through immigration removal proceedings. There are about 300 alien veterans in this section would apply to. We're talking about 300 individuals. Only 144 of them have applied for relief thus far. Representative Biggs introduced amendments that would address this section, such as allowing non-citizen veterans who smuggled people into the country or illegally voted in U.S. elections to return. Representative Fitzgerald introduced an amendment that would make non-citizen veterans who engaged in drug trafficking ineligible for return. But this amendment, instead of taking a piecemeal approach like that, would just strike the entire section and remove the ability of these veterans who were properly removed from returning. In summary, I would just say that this could really apply to anybody, any non-citizen veteran who committed multiple crimes, trafficked in drugs, smuggled humans across the border, engaged in international child abduction, and illegally voted in U.S. elections. There's no limit to it. It's not a parade of horribles. These are all possibilities, and it gives one person, the Secretary of Homeland Security, the authority to review and make the decision on the matter. I just think it's too weighty. I don't think it's right. I think it's fraught for abuse and risk, and for that reason, I ask my colleagues to support the amendment. I yield back.
Gentleman yields back. I recognize myself in opposition to the amendment. First, there is an online portal using parole authority that we have discussed at our hearing on the subject of deported veterans. The gentleman asserts that there have been 144 requests for repatriation. Actually, that is requests for assistance. And if the veterans were discharged honorably, they do have a right to veterans benefits. And so some of these are pursuing the veterans benefits that they earned through their service. There have, according to the report that we received during our hearing, there have been 60 applications for relief and to repatriation to the United States from veterans and their family members. Of these requests, 16 have been granted and 8 have been denied, and the rest are pending. The gentleman's amendment would essentially gut the bill, and I must note that it is not correct that the Secretary has complete discretion. In fact, as we discussed earlier on our first amendment, the bill prohibits the Secretary from granting relief if there are reasonable grounds to believe the applicant is a risk to national security, if the applicant has committed or conspired to commit significant human trafficking offenses, if the applicant has been convicted of any of the following aggravated felonies: murder, rape, sexual abuse of a minor, crimes related to the operation of a prostitution ring and related human trafficking, or crimes related to the production, sale, or possession of child pornography. I would note also that individuals who have been removed have not always been removed because of criminal convictions. For example, of the individuals who applied for relief with the Department of Homeland Security under the administrative program, there were crimes of violence, 38, sale or distribution of drugs and related offenses, 43, drug possession, 12, sexual offense, 14, nonviolent offense, 19, no convictions, 10. So I assume that, but we can certainly find out, that the 8 that were denied were in the category not of no convictions. The age of the criminal convictions is also of interest because 2 of them were between 0 and 4 years old, 16 were between 5 and 9 years old, but 53 were between 10 and 19 years old, and 55 were over 20 years old. These individuals have served both in the war on terrorism, but also they're Vietnam War vets, as well as Persian Gulf conflict members. The bulk of them served honorably, or else they would not be considered. So I think this amendment, I understand the gentleman may not support the bill and may vote against it, but this amendment would simply gut the bill, and I would urge that we reject the amendment. And with that, I yield back. Are there other individuals wishing to be? Mr. Issa.
Thank you, Madam Chair. I'll be voting no on the underlying bill. I'll be voting yes on this amendment. And I just want to, and I do not intend to talk long and hard on these bills. These bills are inherently wrong-minded and represent the worst of what the majority is trying to do to this country. I'll take up the particular of striking the paragraph 7. I'm a veteran, and for those who are not, I hold no special status, but perhaps I hold a special understanding. This reckless bill does not require that these people being considered were honorably discharged. Their crimes could have in fact been within the military. Their discharges were not because they ceased to be a veteran. If you're discharged dishonorably, you're still a veteran. But if you're discharged other than honorably, how dare anyone consider the government or the military service as grounds to have them come back? That is exactly what you don't want to have. This bill ultimately is about people who have given up their rightful request to get the benefit of American citizenship because of their actions. Whether it's a small crime or a big crime, it's a crime. And I'm personally offended as a veteran that it includes special treatment for those who have potentially committed crimes. And I know the gentlelady, rightfully so, said the vast majority might be honorable or general. That's probably true. But the fact that you took no care to exclude those who have
Would the gentleman yield?
I will in a moment, other than honorably, offends me. So I'll be voting no, but even if this were not there, even if you struck this, gutted the bill, as you said, there's still the basic question of, we have over 2 million people this year that will come here and be granted admittance here. I have been to the border and I've seen this wholesale crossing of the border. Those people aren't going home. A very few people will be adjudicated and removed. And what you want to do is make sure that those who have been adjudicated and removed are able to come back. Those who go through this long and laborious process, those who we hunt down after they don't show up, and you want to bring them back. Now, I'm going to just close my statement with, I've had constituents who, by the way, were registered to vote, but illegal. They didn't happen to vote. And the gentleman was an executive with, he'd worked his way up through the ranks of the cable company, but he was discovered after more than 20 years. He and his wife had both come here just after the 1980s amnesty, and they'd been here. They'd had children here that were American citizens who knew no other country. And I not just sympathized with them, but I looked for every legal way to find an exception that would allow that family to remain here. Because it did seem like we had had a broken system for a very long time, and they had simply played into our broken system, and yet they had committed no other crimes. They had lived a wonderful life. She was active in the church, and he had worked his way up through the ranks. I have those examples in my district every day, as all of us in California and around the country mostly do. We should be focusing on real immigration reform and trying to figure out a way to fix a broken system, to send the right message to the right people. But today, as we look at second chances for those who were rightfully removed because, quote, we want to bring them back, I'm sorry, Madam Chair, but it's wrong-minded. This legislation is just wrong-minded. You'll have me as a partner for sensible legislation. You'll have me for sensible enforcement. You not only don't have me today, but you have me absolutely almost beyond words, and I'd yield to the lady.
I thank the gentleman for yielding. On page 20, the term veteran is defined in Section 101, Title 38 of the U.S. Code. Section 38 of the U.S. Code 101(2) says the term veteran means a person who served in the active military, naval, air, or space service and who is discharged or released therefrom under conditions other than dishonorable. These are individuals who are eligible for benefits.
Quickly retain my time just to respond. Other than dishonorable leaves bad conduct, general, in addition to honorable. There are others. You can commit a crime, you can be tried and convicted under the UCMJ and not dishonorably discharged.
I just wanted to make it clear.
I appreciate it, but you could have made it those who served honorably, and you should have if you wanted to even be
These are
considered for my vote.
individuals who are eligible for VA benefits, and I thank the gentleman for yielding. And does Mr. Bishop wish to be recognized?
I do. Thank you.
Gentleman, his strikes the last word.
I will say that I think the point that Mr. Issa was making is quite palpable, and I had another iteration of some of the contrast that comes to mind. There's a young man that I've known since he was a Cub Scout, lives in my district that I currently serve. He has had a very promising career in the Navy as a young E3, a seaman, and had been accepted for SEAL training until the military decided to destroy his career in the military because he declined to take the vaccine that we were told by science, by the public health establishment, would keep people from being infected. He is virtually, the risk to him is non-existent. He's a 22-year-old young man. But he had been accepted into SEAL training, so he was removed from SEAL training last October. And since October, he has been kept stagnant, nothing to do, no responsibilities, cannot get out of the Navy until until the processing occurs on their own sweet time. This 22-year-old has been held for 9 months. And I recently, it took me going to 4 members of Congress to intercede with the Personnel Command to get his damn paper signed so that he can get out of the military and get on with his life. We also saw in the NDAA last year the provision on extremism in the military, with the declining to define what extremism was, but allowing the Secretary of Defense to define it any way he chose, and to root people out of the military across the board on the premise that there's some widespread extremism in their midst.
Good.
This is from the same party that in this bill suggests that this bill in which you want to give special treatment to criminals because they were non-American citizens who served in the military at some point in time and not even necessarily honorably discharged, to the point of the gentleman from California. It's mystifying to me. And I thought about not bringing it up, but it just doesn't add up. And I think it provides context for this bill. I cannot understand why the President of the United States and the Democratic Party has wreaked the destruction on young men and women in our military service at the beginning of their careers or in the midst of careers with extraordinarily expensive training having been paid for by the American people. But you've done it blithely, without any apparent concern. You've even been reluctant to make any adjustment to, the best they could do is keep them from having dishonorable discharges. So spare me to, use the phraseology from and I won't finish the phraseology from the gentleman from Rhode Island in a recent hearing, spare me the assertion that the concern is for veterans of the United States, military, because you're not treating the veterans in the United States and you're not treating the current members of the military with any respect whatsoever. You're destroying their lives. And with that,
Will the gentleman yield?
Yield to the gentleman from Texas.
I would just ask the gentleman from North Carolina that young man who is 22 years old, did he receive a general discharge or an honorable discharge?
You know, candidly, I think it's a general discharge.
That is my understanding. That is a general discharge and not an honorable discharge,
And to this
which
day,
raises the whole point.
I wish I could name him out loud in front of America because he still isn't out of the military.
Right.
I've gotten the order signed finally by jumping up and down and pulling everything I could to get it done. And then you can't get his command promptly to transmit the order and get the young man out. It's like these are the most contemptuous individuals I've ever seen. And that's what the treatment is that is routinely being visited upon our members of the military. So spare me, as I say, that the pressing need for this to come before this committee is so illegal aliens who are have been in the United States military at some point in time and have been removed for criminal conduct. That's who the priority is. I yield back.
Gentleman yields back. Who seeks recognition? This gentleman from Florida is recognized to strike the last word.
Thank you, Madam Chair. I yield to the gentleman from Louisiana, Mr. Johnson.
I thank my friend, the gentleman from Florida. Listen, regarding what you gentlemen were just talking about here, I just pulled this up. Examples of actions that could lead to an other than honorable discharge include security violations, use of violence, conviction by a civilian court with a sentence including prison time, or being found guilty of adultery in a divorce hearing. That's not a definitive list. Those are only examples. But here's the irony, I think, that sticks out in all this. Today, we are hearing articulated this new zeal to allow extra measures of respect and deference to veterans, which everybody on this side of the aisle obviously agrees with. But it's really ironic because it was just last week, just a number of days ago, my amendment to do that in the context of the Cicilline gun control bill was flatly, even vehemently denied by every Democrat on this committee. They insisted that veterans who honorably served the country and know how to handle a firearm, who are specifically trained in that, could not be trusted to be exempted as a category like law enforcement officials in their big gun control bill. But the section of the bill that we're talking about here, Section 7, is really something, because what we're saying here, and for people back home who are watching this, look, the Secretary of Homeland Security has total discretion under the bill to give lawful permanent residency to a veteran, even if that non-citizen veteran committed multiple crimes, trafficked in drugs, smuggled humans across the border, engaged in international child abduction, illegally voted in U.S. elections, you name it. So here's the question, and I mean, this is a good faith question. I'm asking the chair if she would entertain it. You said, effectively in your comments, what I took from that is you said, well, yeah, okay, don't worry. The Secretary has total discretion, but the Secretary of DHH is going to watch that. Don't worry, you know. Why would we allow even the discretion for these categories? I do not understand it. It is madness to me. Why would we not just put it in your bill and say these categories are not allowed? Why would you allow the DHS Secretary to even determine that? It doesn't make any sense. Do you have an answer to that question, Madam Chair?
If the gentleman would yield, if you would read the bill, there are several sections that remove discretion, I've mentioned them before, from the Secretary in terms of applicants who are risk to national security, applicants who have committed or conspired to commit significant human trafficking offenses, an applicant who's been convicted of any of the following aggravated felonies: murder, rape, sexual abuse of a minor, crimes related to the operation of a prostitution ring, and related human trafficking, crimes related to the production, sale, or possession of child pornography. And I would just note further that the general discharge, I would presume that the young man that Mr. Bishop knows who declined the vaccine, that he would not have a dishonorable discharge, that he would have a general discharge, just as someone who has committed adultery would get a general discharge, not a dishonorable discharge. And I hope that clarifies this for you, Mr. Johnson. I yield back.
I thank you for your response. I would say it doesn't clarify it, but because I just don't know why we would even allow for this to be a gray area at all. I yield back to the gentleman from Florida.
I take some umbrage with the chair's comparison of refusing an experimental vaccine to committing adultery and suggesting that those ought to be treated the same way in our military. And I think of how many constituents I have who, by virtue of their faith, which is the value set for many of their marriages that they hold so precious, they are having to separate from a military in a country that desperately need them. And I often meet with the spouses.
Gentlemen, yield.
Yes.
I certainly did not indicate that the adultery and vaccine refusal were the same. I just noted they would both be a cause for general discharge.
Well, I guess my point is I appreciate that. Someone should not be treated the same way for both of those two things because both of those things should not be punished, right? Adultery in the military, perhaps, our standard is to punish that with this type of a discharge. We should not be doing that with people who refuse the vaccine, especially because I see so many of my constituents who are refusing the vaccine, and I see the pain and the challenge that it puts upon their marriages and upon their families, but they're sticking to their faith nonetheless. So I would make that note, and I'd yield back the balance of my time.
Gentleman yields back. If there is no further request from Mr. Roy, you are recognized to strike the last word.
I thank the chair. I will not use all the time here in this window because I still have not spoken directly on the underlying bill. And I know we're on the amendment, but I do have to at least just interject and respond. Obviously, I engaged in a very brief colloquy with the gentleman from North Carolina, but it is absolutely extraordinary to me, notwithstanding, I think, the reasonable debate about ensuring that those who serve in our military do so honorably, do so following our laws, and serve that they're able to get status or maintain status, and that, of course, being the existing law. But then this question here about then when there's a violation of our criminal codes, what happens to those who served in the military and what happens to their status? I mean, some of those conversations are at least reasonable to have, as the gentleman from California, who I don't think remains in the room anymore, was raising himself. But literally we're here spending time bending over as far as we can bend, for individuals who have gone through, had due process, and engaged in some criminal conduct. And I realize the gentlelady is going to say there's all these exceptions for these horrible crimes. There's been a back and forth about whether or not the advisory committee would essentially allow an end run to that. We've debated that. I won't repeat it. But we're sitting here bending over backwards. And to the point of the gentleman from Florida, and the gentleman from Louisiana, the gentleman from North Carolina, we have individuals, some 60,000 that are sitting on the chopping block right now, who are serving their country honorably and are facing general discharge, a 19-year service member, a major in my office, reduced to the point of emotion, tears, because he's being forced out of the military.
Would the gentleman yield?
Briefly, out of respect for the gentlelady.
As you're well aware, the Judiciary Committee doesn't have jurisdiction over those policies. That's the Armed Services Committee.
I am aware, and reclaiming my time, I am aware, but this policy is being driven solely and entirely by my Democratic colleagues. That it is being driven by the Democratic leadership of this administration, the appointees of the Department of Defense, and by the Democratic leadership in this body literally refusing to engage in any legislation we want to try to offer to be able to protect our service members from being discharged, not even honorably, for failing to take a vaccine that even if we just objectively look at it, can all agree is a politicized question. When the CDC director herself, hardly a bastion of what I would consider objective production of public health for the American people, has raised all of the questions about the benefit of the vaccine with respect to transmission. Say, well, and they reduced to, it's beneficial for the member. Well, then let the member decide. And so again, we're looking at a population of 300 people. And again, I don't mind having the conversation, but I oppose the legislation for a variety of reasons. I'll get into it more in a minute. I think the gentleman's amendment is well taken. I think this is another one of these amendments that we're simply trying to say, is there any limit to which my colleagues on the other side of the aisle won't reach to find some path and be able to allow for the discretion of the secretary. And we're not even getting to the bill that's coming up on the docket here later, which is absolutely freaking deranged, to give the kind of absurd flexibility to this secretary who can't even acknowledge that we have a crisis at our border, and he looks at us and lies, straight up lies to the American people, to us, that we have operational control of the border. We'll get to that bill in a minute, but all of this is in context. All of it. It's all in the context of the fact that we have an administration literally refuses to acknowledge the situation at the border and does not give a whit about what it does to the people, and is perfectly content giving as much flexibility to the secretary to ignore the laws of the United States, to have wide open borders to the damage of the people. And here we are again, extending and bending backwards. So with that, I will yield back my time.
Gentleman yields back. If there are no further requests for time, the question is on the amendment. All those who are in favor will say aye.
Aye.
All those who are opposed will say no. No. In the opinion of the chair, the noes have it. A roll call is requested. The clerk will please call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass?
Right, this is what I'm looking at. She's calling the,
Someone needs to mute. Thank you.
Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
no.
Mr. Liu votes no. Mr. Raskin? Ms. Drypal? Ms. Drypal votes no. Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr.
Mr.
Jordan?
Cohen votes no.
Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat? Aye. Mr. Shabbat votes aye. Mr. Gomert? Aye. Mr. Gomert votes aye. Mr. Issa? Mr. Issa?
Mr. Issa votes aye.
Mr. Issa votes aye. Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Aye. Mr. Johnson of Louisiana votes aye. Mr. Biggs?
You're right there.
Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stube?
Yes.
Mr. Stube votes yes. Mr. Tiffany?
Tiffany, aye.
Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes aye. Mr. Owens? Mr. Owens votes aye.
Mr.
Baz here.
Yes,
And to revise section 2 according to Barnaby.
How is Mr. Cohen recorded?
Mr. Cohen, you are not recorded.
I'd like to be recorded as no.
Mr. Cohen.
How is Jackson Lee recorded? You got to stop
Am I recorded?
unmuting me so I can't
Jackson Lee is recognized.
Yeah. I vote no.
Ms. Jackson Lee
Is that
votes
the-
no.
Ms. Bass.
Bass votes no.
Ms. Bass votes no.
recorded?
Mr. Deutsch, you are not recorded.
No.
Mr. Deutsch votes no.
Has Ms. McBath been recorded? Are there other members who wish to be recorded or who wish to change their vote? If not, the clerk will report.
Madam Chair, there are 18 ayes and 19 noes.
And the amendment is not agreed to. Are there additional amendments to be offered?
Madam Chair, I have an amendment at the desk.
Gentleman has an amendment, and a point of order is reserved by Ms. Escobar. Clerk will report the amendment, please.
Madam Chair, reserve a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Fitzgerald of Wisconsin. Page 8, insert after line 25 the following. For disqualifying violations, in conducting each case review under paragraph 1, the advisory committee shall consider as factors precluding a recommendation under paragraph 1A, the commission of a violation described in section 212A2A12 of the Immigration and Nationality Act, or conviction described in section 237A2B1 of such act. Page 14, line 23, insert after subparagraph A the following B.
The gentleman is recognized to explain his amendment for 5 minutes. Mr. Fitzgerald.
Thank you, Madam Chair. This kind of goes in line with some of the other amendments that we've already considered here this afternoon. So obviously what's happening down at the border is at a crisis point, has been for some time. But along with that is obviously the opioid epidemic. And I know that many members, when you've been down there, specifically if you talk to Homeland Security, I mean, they can tell you just how many drugs are coming across. But I introduced a bill last year that would designate fentanyl as a Schedule I drug, which in my estimation closes the loophole in current law. And as most of us do, we have a strong record on veterans issues. But it seems that the bill continues to target kind of sympathetic populations. And what this would ultimately do is erode the ability for law enforcement to get a handle on immigration, right? So this part, and I just wanted to go back to something that we were talking about earlier, because I think there was a question as to, how do non-citizens end up in the military? So to join the U.S. military, non-citizens must be living permanently and legally in the United States. Non-citizens must also have permission to work in the United States, which means you possess an I-551 permanent residence card, and you have to have a high school diploma, and you have to speak English. I think all those requirements are up to date. So there's kind of this group that's been carved out, I think, and we're going back to kind of, should Secretary Mayorkas have this magic wand and suddenly say that those otherwise that would be removed for obvious reasons, because they've committed some type of crime, and specifically the one that this amendment addresses is trafficking fentanyl, that there would not be a way for them to simply say, just ignore all that and move forward. So this amendment would prevent both the advisory committee from blocking removal of these convicted of drug crimes, as well as granting green cards to illegal aliens. So let me summarize even further. So the amendment, quote, the illicit trafficking in a controlled substance, what you'd be doing is adding this to the list of crimes for which a deported veteran cannot receive a green card from the DHS secretary, and preclude the advisory committee from making a recommendation for an exercise of discretion from the advisory committee for the same offense. The other thing I just want to mention is, because I think honorable discharge and general discharge have been thrown around a lot today as well. You know, for somebody that's been discharged because they would not take the vaccine, for them to get a general discharge, the only other place that it's commonly used that I'm aware of is if you've got somebody a kid that signs up and joins the Army, and then within a 2-week, 3-week period, they realize that suddenly it's not a good fit. This kid's not a good fit for the Army agrees this kid's not a good fit, and they just give a general discharge because, you know, no harm, no fault, everybody just kind of goes on their own way. But when you take a veteran, you take somebody that served honorably for, like Mr. Roy said, example, 19 years. I mean, high ranking, and has probably been deployed. And then you simply say to them, oh, by the way, we're going to give you a general discharge. That is a slap in the face. It's a slap in the face. I don't care how you frame it up. It's something that obviously should never happen. And I think that's what's really, sorry, I'm getting off of the topic of the amendment a little bit, but that's what's really irritating, I think, to many of these individuals that have served honorably, as well as their families, is that you literally have left them out in the cold. And it's something that needs to be addressed. My office is inundated still with emails from these individuals that are currently being separated as we sit here today. And it's something that should be addressed. And I wish the majority would take it more seriously. So, and I yield back.
Gentleman yields back. The point of order is not insisted on because the amendment is germane, and I recognize myself in opposition to the amendment. Here's why this amendment should not be supported. In the first part of the amendment, the advisory committee shall consider, they can consider anything, but this would preclude a recommendation if there was a offense that was a moral turpitude, which is anything from petty theft to something serious. And I think that would limit the ability of the advisory committee to really raise the issue that here's a veteran in removal proceedings. Here's what the advisory committee is to consider the following positive factors. If the individual was an enlisted member or officer of the armed forces, if they received a medal or decoration, if they were deployed, if they were evaluated for merit in their service and the like, if they've contributed to their local community during their service in the armed forces. It is assumed, I think correctly, that it is the prosecutor who will raise the issues that are negative about the individual before us. As to the second part of the amendment, in 1996, we amended the act so that aggravated felony was expanded beyond its traditional understanding. It's not, you think convicted drug trafficker, it could be El Chapo. Well, that's a guy who should not get, who's a thug and a murderer. But under our immigration laws, selling $10 worth of marijuana is also, under the law, an aggravated felony. And there's no distinction made between outrageous drug traffickers and somebody who grew a marijuana plant in their backyard. I do think that a veteran who served honorably, who was a legal permanent resident of the United States, but didn't obtain his citizenship, should not be precluded from consideration for repatriation for a marijuana plant in his backyard. And so I don't think this amendment is well taken. I would urge that I'd be happy to yield.
Thank you, Madam Chair. I guess going back just a little bit, you had talked a little bit about what the advisory committee can consider, and you said they can consider whatever they want. And as I look at the language on page 7 and 8, it looks very prescriptive, and so if I'm missing where it says they can consider anything they want, I would love to know.
Well, if reclaiming my time, they shall consider this. It doesn't preclude them from considering other matters. To be honest, if the amendment did not include, I'm trying to find this. If we struck on line 3 as factors precluding a recommendation under paragraph 1A, I wouldn't have a problem with the first part of this amendment. It's the preclusion provision that I could not accept, and then, of course, page 14, I've described why that couldn't be acceptable.
Would the chair yield?
I'd be happy to yield.
Thank you, Madam Chair. I guess I am reading this a little bit differently because it does say the advisory committee shall consider.
Yes.
And then it goes through with respect to the member of the armed forces, and it goes through things. It does not say and other items they may find.
It does not preclude consideration of other items.
Well, shall is a pretty strong
Yeah,
word.
they can't, reclaiming my time, omit to look at these items. But it's advisory in any case. I'm hoping that we can get a vote on this amendment because we do have a classified briefing at 2 o'clock, and I think members wish to attend that classified briefing, and we might
thank you, Madam.
recess. Unless there's further debate on the amendment, the question is on the amendment. All those in favor will say aye. Aye. All those opposed will say no. No. In the opinion of the chair, the noes have it.
Roll call.
A roll call is requested. Clerk will call the roll.
Mr. Nadler. Ms. Sofgren.
No.
Ms. Sofgren votes no. Ms. Jackson-Lee. Mr. Cohen. Mr. Johnson of Georgia. Mr. Deutsch. Ms. Bass.
I wonder if I may interrupt. I am going to ask that we recess now and continue the vote, because otherwise members here will not be able to get to the classified briefing, which is in the Capitol basement, in time for the beginning. And I think that's unfair to members.
Would that also mean that this amendment? I think we have to.
Or do we have to finish the parliamentary? We have to finish this now, because all the members are going to miss the start of the classified briefing. I think we'll withdraw the request for the If you'll withdraw the request, and we will recognize you as soon as we reconvene to reinstate your request for a recorded vote.
Madam Chair, I would hope we could finish the roll call first.
All right, then members are going to miss the start of the classified briefing. The clerk will continue.
Ms. Bass? Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline? Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa?
Excuse me, no.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Issa?
Aye. Aye.
Mr. Issa votes aye. Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Aye. Mr. McClintock votes aye. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany?
Tiffany, aye.
Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Spartz? Ms. Spartz votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes yes. Mr. Owens? Mr. Owens votes aye.
Nadler votes no.
Mr. Nadler votes no.
Madam Clerk, Cicilline votes no.
Mr. Cicilline votes no.
Are there additional members wishing to?
Madam Speaker, how am I recorded?
Mr. Johnson, you need to turn on your camera to vote. Meanwhile, Mr. Cohen has his camera on. How is Mr. Cohen recorded?
In the negative.
Mr. Cohen votes no.
Thank you.
Ms. Jackson Lee?
How am I recorded?
Ms. Jackson Lee, you are not recorded.
How am I recorded?
Ms. Jackson Lee, you are not recorded.
Ms. Jackson Lee, do you wish to vote no or yes?
How am I recorded? Hello?
You're not recorded. Vote no or yes.
What is this? Sorry.
The chair voted no.
Jackson Lee votes no.
Ms. Jackson Lee votes no.
You have it on?
Yeah.
Okay.
Yeah, you have to do this.
Mr. Johnson, are you able to turn on your camera? Oh, Mr. Johnson, how do you vote?
Just speak.
No.
Mr. Johnson of Georgia votes no.
Are there additional members wishing to vote? or change their vote? If not, then the clerk will report.
Madam Chair, there are 19 ayes and 21 noes.
And the amendment is not agreed to. The committee will be in recess until after the classified briefing. Members will then please return to the committee room promptly after that. We're in recess. So the Judiciary Committee will reconvene. Our classified briefing has concluded. We are returning to the bill that we were discussing. I understand, Mr. Tiffany, that you wish to be recognized to offer an amendment.
Yes, Madam Chair, I have an amendment at the desk.
Clerk will please report, and Mr. Johnson reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Tiffany of Wisconsin. Page 8, after line 25, insert the following. 4, precluding factor. In conducting each case review under paragraph 1, the advisory committee shall consider as a factor requiring a recommendation under paragraph 1B whether the member of the armed forces, veteran, or covered family member has been convicted of a crime of domestic violence as defined in 237A2E1 of the Immigration and Nationality Act. Page 14, line 21, strike or. Page 14, line 24, insert or any conviction of a crime of domestic violence as defined in 237A2E1 of such act before if.
Mr. Johnson withdraws his point of order since the amendment is germane, and Mr. Tiffany, you are recognized to explain your amendment.
Yeah, thank you very much, Madam Chair. So someone that's convicted of domestic abuse would be precluded from being able to use this process to be able to come legally into the country. The majority has often asserted how they embrace victims of crime. Well, this is one of the more heinous crimes that can be committed. My amendment would complement that sentiment by disqualifying those veterans who have been deported for or are removable for acts of domestic violence to be considered for a second bite at the apple. Since the majority voted down the amendment notifying victims, surely you will want to retain or bring back people who may reoffend or re-victimize the victims of domestic violence. It also prohibits the advisory committee from considering or advising the secretary on exercising discretion such as deferred action or other forms of immigration relief for convicted offenders of domestic violence. I think this is a good change to this bill to make sure that those people that would commit domestic violence or who have been convicted of it, that they not be allowed to come back into this country. I mean, we've seen such an uptick in crime, and some of it is coming as a result of allowing, of our open borders policy, and this just makes sense not to allow somebody like that that is been convicted of such an offense. And I yield back.
The gentleman yields back, and I recognize myself in opposition to the amendment. Domestic violence is indeed a serious issue. And actually, in terms of the first part of the amendment, having a consideration of this as an advisory to secretary in removal proceedings, I think is not unacceptable. However, to make a complete bar for DV, I think is a mistake. And I don't know that Mr. Correa is here, but he was describing an individual who had done 4 tours of duty in Afghanistan, who he was meeting with who's been removed and is in Tijuana hoping to rejoin his family. And the description he gave of that veteran was a guy who clearly was suffering from PTSD. He woke up in the middle of the night and found himself assaulting his wife. Obviously, that's a terrible thing, but it's also a result, most likely, of post-traumatic stress disorder. He didn't even realize what he was doing. So while the discretionary review may in fact and should exclude individuals who have committed egregious acts of domestic violence, to preclude consideration at all, I think would be a mistake.
Were the gentleman
And-
yield?
In a minute.
Okay.
I do think that, 60% of those who have PTSD are going to get involved in the criminal justice system, according to the statistics that we have been advised of. And that a recent study found that PTSD in veterans is linked very strongly with domestic violence. Between 2006 and 2014, military calls to the National Domestic Violence Hotline more than tripled, signaling really a public health crisis that is really devastating to military families. It's important that we keep in mind, as the former president did when he announced the Second Chance Month, that people can and do turn their lives around from time to time. And I think to say that someone who has stepped forward to put their lives on the line to protect our country should not be given an opportunity for a second chance if they've turned their lives around, if they've managed to get the treatment they need for PTSD, that would never be a possibility. I just think that is a mistake, and that's why I think the amendment is a mistake, and now I'd be happy to yield to the gentleman.
I thank the chairman for yielding, and I just wanted to, because I was not here, or I was attending to something else when Mr. Correa spoke. Did you say that the facts as he rendered them were that a veteran was beating his wife?
No, he woke up and found...
He woke up and found himself beating his wife?
No, not beating his wife, that he had grabbed her and in his sleep. And I don't want to, it was Mr. Correa's story, so I don't want to get too far down the line. But let me just go to my own point, which is that DV is connected with PTSD, and that if people get treatment, they can recover and they can have a second chance at life. And that's something that we've had a bipartisan celebration of in the last, during the last president's term, when he had the Second Chance Month and highlighted the opportunity for people to be able to improve. And Mr. Buck, did you want me to yield? Okay, with that then, I yield back my time. Who else seeks recognition on this amendment? Mr. Buck, you are recognized.
I thank the chair. Madam Chair, with all due respect, when someone beats their wife, they should not be allowed in the country, and or their girlfriend or significant other. I understand that there is a relationship between PTSD and domestic violence. I also understand that the victim of domestic violence doesn't really care. When someone's getting the tar beat out of them, they don't have a whole lot of sympathy for what the person is going through. Now, a judge can take that into account and probably will. If a person with PTSD wakes up and is in fact grabbing or assaulting in some way, that goes to the mental state that is required to prove the conduct in a domestic violence case. But to suggest that somehow in the tens of thousands of cases where men are abusing women, we should not pass this very good common sense amendment because there are instances of PTSD where someone might be convicted. It just seems to me we have to protect a group of people, and this amendment from Mr. Tiffany makes a lot of sense. It is an amendment that, frankly, I hope we get a positive vote for. We are either going to stand with victims of crime and we are going to make this country more secure, or we're going to continue to see the crime rates in this country go up. The idea that we can use sociologists and psychiatrists and others to
work our way out of crime is a serious mistake. I prosecuted for 25 years. I know what the root causes of crime are, and I know there are some programs that can reduce crime, but the most important crime prevention program is to make sure that those who commit crimes have a consequence, and this would give a consequence. And with that, I yield to my friend from Wisconsin.
Yeah, thank you. Madam Chair, I'm not sure your example holds up, because for that person that wakes up, doesn't realize that they're doing this, that is not intentional. And I'm not so sure that that would be a removable situation if someone proved that it was unintentional what they were doing. So I'm not sure that your example holds up in that instance, because it does have to be intentional. From my understanding, in a court of law, it has to be intentional in order for you to be charged. I yield to the gentleman from Colorado.
Well, and I appreciate that. It absolutely does. The mental state, you can't by accident assault someone. You have to intentionally assault. And so you have to have intention to pass the required mental state. Waking up in a situation does not meet the test that is required for conviction in a crime like that. I yield to the gentleman from Wisconsin.
So with that being said, I think it makes the case for this amendment even that much stronger after the discussion that we've had. Someone is doing this, they've been convicted. Obviously, it's intentional what they have done. There should not be discretion. They should not be allowed back into the country if they have done this in an intentional manner. I stand by this amendment even stronger now, and I urge everyone to support it. It makes sense.
Reclaiming my time, I think it's also important to recognize that it's rare that the first instance of domestic violence is reported at all. An individual committing domestic violence typically commits a number of instances of domestic violence against a number of victims before they're ever caught. And so now you've got a serial domestic violence perpetrator who is coming into this country, and that's just not appropriate. And so I think this is a great amendment, well thought through amendment, and I appreciate the gentleman from Wisconsin offering the amendment. And with that, I yield back.
Gentleman yields back. Ms. Dean?
Thank you. I seek to strike the last word.
Recognized.
Thank you very, very much. I associate myself with the words of our chair just now. They were eloquent and spot on. And I have to admit, as I look at this amendment, I rise in opposition to the amendment. Sadly, I wish those on the other side of the aisle had lifted up the issue of domestic violence in the hearings and markups that we have recently held, the scourge of domestic violence. Most recently in the markup around gun violence. We couldn't find on the other side of the aisle those who wanted to protect the victims of domestic violence. They wanted to protect the gun owners. So let me speak in—
Will the gentlelady yield on that point?
No, I will not.
I'm not surprised.
Let me speak in favor of the bill. As I was saying earlier, I think so often in terms of military service of the expression of the absence of shared sacrifice of our military servicemen and women. It's been waning over the years. In 1973, active duty military represented about 1% of the population. Now there are about 1.3 million active duty personnel, or less than 1/2%. As I said, I'm the proud sister of two brothers who were in the Navy during the Vietnam War. Brother Bob Dean served on hospital ships and destroyers in Vietnam, 2 tours of duty. My brother Harry Dean served stateside during the Vietnam War. I have been in awe of their service and their sacrifice ever since. My grandfather having served in World War I, also in the Navy. I've never served. And so know that I come from a lens that says those who serve our country, citizens and non-citizens, need to be lifted up, admired, and left in that place of admiration with our thanks. You know, in the aftermath of World War II, the GI Bill helped create America's middle class. Despite discrimination in its implementation, some black families were able to gain upward mobility through military service. However, for some immigrants who have served, they have suffered discrimination and the risk of deportation. Hundreds of thousands of immigrants pledged to defend the United States with their lives. Think of all the different conflicts and wars, the Civil War, both world wars, Korea, Vietnam, Gulf War, Afghanistan, Iraq. Research shows that approximately 700,000 foreign-born veterans, many of whom are now U.S. citizens, live in the U.S. today. So what happens to those veterans who struggle to parse through our broken immigration system? Sadly, too many face the prospect of deportation, separating them from the very country they fought to defend. So although the Biden administration has directed immigration and customs enforcement agents to generally refrain from seeking deportation of U.S. military, veterans, or service members and their immediate families, we must do more. That's why I am delighted to stand and support H.R. 7946, the Veterans Service Recognition Act of 2022. A non-citizen who takes the oath of enlistment, just as my brothers did, promise to support and defend the Constitution of the United States against all enemies, foreign and domestic. They promise to participate in its shared sacrifice for all of us. These veterans deserve, at a minimum, protection from deportation, at a minimum, protection. I urge my colleagues to support this bill, and with that, I yield back to the chair.
Madam Chair.
Gentlelady yields to the chair. I would just note that for the veterans who are have been removed, one of the important...
On whose time, Madam Chairman?
She has returned, oh, I thought there was
yielded back.
a minute and 26 seconds that she had yielded to me. Yes, she did yield to me, but for some reason, okay, a minute. I just note that access to the VA is really an important thing. And for, the veterans, hospitals and clinics are experts in treating PTSD. And to the extent that there may be someone who is able to be repatriated and they're able to get the medical care that the VA has to have, that would be a very important thing. And I thank the gentlelady for yielding back. And I yield back. And Mr. Jordan, have you asked to strike the last word?
Thank you, Madam Chair. Yeah, I want to strike the last word. I want to talk about a number of things. First of all, I support the gentleman's amendment from Wisconsin. It's a good amendment. Second, to the previous speaker, the Republicans offered an amendment to protect victims of domestic violence twice. We offered it, Mr. Massey offered it 2 months ago to the red flag bill that the majority passed, and then he offered it again last week on the so-called assault weapons ban that the majority passed. So we've talked about that extensively, and the Democrats voted it down both times. But my main reason for seeking some time was actually to engage in a question for the chair, if I could. I raised this with Chairman Nadler a week ago. We had, during the assault weapons ban markup, during that hearing, we had a gentleman from the audience disrupt the proceedings of the hearing. And I asked Mr. Nadler at the time, who invited this individual, who met him at the door, escorted him to the committee room, who did that? And he didn't give me an answer. And I was wondering if the majority may have an answer for the minority. We know no one from our side met this individual, no one's office met this individual at the door and escorted him into the committee room. And I was wondering if the majority had an answer to that question today.
Mr. Jordan, I don't know.
Are you in the process of figuring that out, Madam Chair?
I have no idea, so I am unable to answer your question.
Madam Chair, who chairs the House Administration Committee that has these rules and is responsible for how things operate here on Capitol Hill?
As you know, individual staffers from all 435 offices can and do escort visitors in. I do not know who escorted that person in.
Is that something that the House if the Judiciary Committee is not going to figure it out, if the majority of the Judiciary Committee is not going to figure it out, would the majority on the House Administration Committee figure out who in fact invited? This individual came in here, disrupted an official proceeding of the committee, disrupted, if I remember correctly, Congressman Biggs' presentation during that markup. And we'd like to know. In fact, I asked not once, but twice during the hearing, the 12-hour hearing we had last week. We would still like to have an answer to that question. And it seems appropriate to me that the chair of the House Administration Committee is the person who should be able to get that information for the committee.
Well, I don't believe that the House Administration Committee is charged with investigating the various offices.
Simple question. It's simple to find out.
Let me just say, in the past, unfortunately, over the decades, there have been occasions when the committee proceedings have been disrupted by disorderly individuals who are then removed, as this individual was.
But those are different.
I have strong objection to anybody who would come in and disrupt
So do I.
proceedings of the committee. If that happens, they will be removed.
But in the past, there wasn't the process in place that is in place now. Individuals do not get into a committee room now unless they are being met at the door of the Rayburn building by some official staff member from someone's staff and then escorted to the committee room. All we're asking is, who did that?
If I knew, I would be very pleased to tell you.
Well, we know you don't know because you haven't told us the answer to that, but we want you to find out.
Well,
I mean,
I appreciate your question, Mr. Jordan.
with all due respect, Madam Chair, your committee used official resources to put together a dossier on every single Republican social media post who happened to object to the electors on January 6th, even though Democrats objected every single time a Republican was elected president this century. If you can use official staff to do that on 100 and some members of Congress, we think you could find out the answer to a simple question. Who escorted this individual into this committee room who disrupted the committee?
As I said, I don't know who that person is.
Well, we hope we get an answer soon. This is the third time I've had to ask. And it's been a full week, and we get the same darn answer first from the chairman of the Judiciary Committee, now from the acting chair of the Judiciary Committee, who also happens to chair the House Administration Committee, and we get nothing but, we don't know. I would yield to the gentleman from North Carolina.
I appreciate the ranking member's courtesy in the way the gentleman has posed this question multiple times. And it has not resulted in an answer to the question. But it's really quite clear. All it would take is for the chairman now, or the actual chairman of the committee, to ask Democrats who let David Hogg into the committee room to disrupt. And the implication is quite clear of the fact that first Mr. Nadler and then now Ms. Lofgren have said, I don't know. They don't want to know. It's willful lack of knowledge. They don't care. And because it would be revealing as to how they're operating the committee.
Gentleman's time has expired. Who else seeks recognition?
I do.
Mr. Johnson.
Thank you, Madam Chair. I move to strike the last word.
Gentleman is recognized.
I am tickled pink with the suspicions and questions that my colleagues on the other side of the aisle have about a visitor who came to the Rayburn office building. But we've got a lot of questions about who came to Capitol on January 6th of 2021 and who was it that participated in the run-up to January 6th. And that's being handled by the January 6th committee, which my friends on the other side of the aisle deny has any legitimacy whatsoever to ask any questions about what happened. So
Will the gentleman yield?
I find it strange, no, I won't at this time, find it strange that
I could help you.
they are so righteously indignant about some individual who came in and who was it that let the individual in.
Just want an answer.
But Madam Chair, our country's military is composed of brave men and women who volunteer their time, strength, and intelligence in service to our nation. And among these volunteers are several thousand non-citizens of the United States, people who love this country so much that they would risk their lives for it, even though it is not the place of their birth, and even though we have people in this country who will accept their toil and labor on behalf of the country and then spit them out like worthless objects. As a nation, we owe these non-citizen soldiers the same respect and the same opportunities and the same forgiveness and forbearance that we grant to our own citizens. After all, they volunteered to pay the highest price for this country, and having done so, they deserve some forbearance on our part and some equal treatment and equal dignity. And so that's why I opposed the amendment that has been offered. From the first day that these individuals begin basic training, these non-citizen recruits have proven that they are dedicated to our nation. It is in this moment that we must recognize their dedication and offer them the opportunity that we would offer a citizen in the event that that citizen has been failed by a domestic violence incident in their past. It's widely known that post-traumatic stress disorder remains a problem for our veterans, including those who are not citizens. Why shouldn't we have some mercy and compassion for them? In fact, PTSD and other mental health disorders resulting from time spent in the military protecting us are the leading cause of crimes committed by veterans. Many of these crimes are petty, not resulting in loss of life or significant damage to persons or property. Rather than providing the necessary help and resources to these non-citizens veterans, we want to ship them away or exclude them or keep them out of our country for making that mistake. How do we justify not helping those who defended this nation with their lives? It's not reflective of American values to cast away those who volunteered to defend this nation. This country is just as much theirs as it is ours, they having given their toil in the U.S. military to support the freedom that we all enjoy and many of us apparently take for granted. So I support this bill, which takes an important step towards protecting and assisting our non-citizen veterans and their families, and I oppose the amendment, which is hard-hearted, and this country was founded by immigrants. We have had non-citizen soldiers in our military for every war since the Revolutionary War. And these soldiers have stood with us since our founding. And it is time that we allow them and their families to become citizens and/or legal permanent residents of this country. That's the least that we can do. And with that, I yield back.
Gentleman yields back. Are there additional members who wish to be heard on the amendment that's before us?
Yes. I'd like to strike the last word.
Mr. Gomer?
I just wanted to respond real quickly.
Oh,
Good.
go ahead. I'm sorry.
Yeah, I wanted to respond just so briefly to my friend from Georgia. In terms of why we are asking for some answers, I think America's just tired of chaos. We like order. We like to have answers. And we've come to a point where the leaders on the other side of the aisle seem to not know and don't care about so much. They don't care about the chaos on the border, the chaos in the cities, the chaos of the last 2 years where billions of dollars of damage to business owners, people of all backgrounds just trying to build their dreams, burned to the ground and nobody's asking questions of why. 26 Americans have died over the last 2 years of chaos and nobody asked the question why. So no, what happened here in this chamber should not be happening without somebody getting to the core of the question, why? How can a man come in here, disrupt our doing business, and nobody seems to care about it? So Americans want order, my friends. We are a society that's based on rule of law, order, so we can predict exactly what's going to happen. If somebody decides to disrupt, like they're right now doing all over the place, they're attacking any place that supports women and women's choices to give life. They're causing chaos, and guess what's happening? Once again with this administration, no answers. They don't know and they don't care. So no, what happened here is an indication of what's going on in this country, and Americans are sick and tired of it. So I would hope that the leadership here will find out who was that young man who came into this chamber.
On January 6th?
Well, you know what? That's
Gentleman has
chaos
the time,
too,
Mr.
by the way.
Johnson.
That is chaos also. And we're going to find out as we take control of how it's done the right way, the fair way, where American people can trust the process and not look at this as political theater. So I'm excited about getting order, law and order back again, and respect for the rule of law and respect for the process. And November will be a great time of our country to turn that corner and make sure we're getting back on in case. You want to,
Go ahead, Dan. So if the gentleman, and I appreciate him
Yes, please
yielding,
do.
I mean, on that point, in terms of order and talking about this proceeding being interrupted, and clearly a political individual clearly got in here on purpose. I mean, there's zero question about that, but there's no indication that the majority cares a whit about.
Would the gentleman yield?
Happen. I'll yield brief. It's not my time to yield.
I'm sorry.
Yeah. So, but let me just finish on that point. But clearly a political individual, clearly purposely led into the building. And we're talking about, my colleagues like to bring up January 6th. My friend from Utah appropriately says that was chaos and that is a problem as well. And we're all concerned about that. But we're the House Judiciary Committee. We have not had a single hearing, to the best of my knowledge, about Americans incarcerated as a result of January 6th, the conditions in which they're held, the results of some of them committing suicide or dying, and some of the concerns that have been raised, conditions that have been made public that they're held under, the charges that they face, why that those charges were applied, whether those charges are applied equally. And look, let me be clear, and I said on the floor of the House, I prosecute to the fullest extent of the law those who violated the law. But there are real questions. How can the House Judiciary Committee not have a hearing about incarcerated Americans that are sitting in prison across this country? I mean, I just, for the life of me, my colleagues keep bringing up January 6th. Well, then let's bring in the Department of Justice and let's walk through it. Let's understand it. You know, we've got some of my colleagues, like the gentleman from Texas, Mr. Gomer, and others that have gone down to the jails here in D.C. People that are really hurting and suffering according to some of the stories that we see. And the ranking member is simply asking to know, how did that guy get into our proceeding? We ought to know. I think we ought to know. I yield back to the gentleman from Utah.
thank you.
Yeah, how did he get in? I think the gentleman for yielding, just like how did the folks from the Colbert Show get in? Somebody let him in. Somebody let him in. Imagine that. And the gentleman's was so, but both were so on target. The chaos that is unfolding in every one of our urban areas as we speak, the violence that's out of control, the chaos in the summer of 2020, the chaos at 50 pro-life pregnancy centers and churches over the last 12 weeks, the chaos in front of Supreme Court justices' homes for weeks, and the Speaker of the House waited 4 weeks to give protection to their families. And we asked a simple question: how did the guy get in here? I bet there's videotape that the chairman of the House Administration Committee can look at and figure out who met the individual at the door and escorted him in. We'd like to know that.
Sergeant Schultz knows nothing.
Gentleman's time has expired.
You're back.
Mr. Gomer, did you wish to be heard on the amendment itself? Gentleman's recognized.
Thank you, Madam Chair. The question was asked by my friend from Georgia, who came into the Capitol on January 6th. Well, the FBI obviously has had access to all the footage, but a lot of us would like to know the answer to that question. And as my friend from Ohio mentioned, the chairman of the Administrative Committee has complete access and can authorize complete access to all of that footage. That would answer every question on both sides of the aisle, and it's a question I think this committee should have had hearings on, because defendants have been denied their right that the Supreme Court has made clear is there to see any potentially exonerating evidence. Any first-year law student knows that, and yet the Department of Justice needs to be hauled in here and answer questions why they have not provided it. And I've seen the information that some of the defendants in the D.C. jail had, where the prosecution designated this section, this section, this section of footage of videotape, but they were saying, I believe that's where this happened, and the thing that exonerates me is right in this section that they are not going to use. And I need access to that section. The Justice Department won't provide it. The administrative committee could provide it, and they refuse, and this committee will not have hearings on it. So I do appreciate the sentiment that somebody who serves, we should lift up and thank. I got to tell you, as somebody that served, and we weren't in combat in my 4 years, but it was 78 to 82 was a very unpleasant time to be in the Army. You didn't get a bunch of lift up and thanks. And it wasn't until after 9/11 people started saying, hey, you were in the service, weren't you? Thank you for your service. Because most of the time, we were even ordered not to wear uniforms off post many times because of violence against members in the service. It wasn't just spitting. So there's a number of things that ought to be done. The comments that we didn't care about domestic violence, as my friend from Ohio pointed out, we've had amendments to deal with that. But on the one hand, normally domestic violence is, that's a state crime. And one of our strong positions is we should not, as a federal government, swoop in and usurp all the state control over state laws. And that's one of the things that the Supreme Court recently pointed out. But I also want to say, from personal experience with prosecuting domestic violence, the point was made that, often the first or second or so act of domestic violence against a woman is not reported. I can tell you many times when they finally come in and report, they're all set to prosecute, and we made clear, look, you understand you don't have a right to withdraw it. What was done was horrible, and we are going to prosecute even if you come in later and say, I don't want you to. And that would happen. So when somebody actually gets convicted of domestic violence, oftentimes not only have there been events gone unreported, but there were some that were reported and then backed off of. It is tough because, and you try to explain, look, this is not your fault. What happened to you is not your fault. But anyway, there's some of us that feel very strongly about that. But let's come back to the amendment. It needs to be adopted. One other thing I got to say, the comment about VA care is very important. Yeah, well, tell that to the hundreds and hundreds and hundreds of people who served for years in our armed forces, and then we're told, look, yeah, we know there's a lot of reports of a lot of terrible things happening to people that got the vaccination or the booster, including my father over a year ago, got the booster, got dizzy, fell, and he never recovered. But you know what? If you don't take the vaccine, then we're going to say goodbye to your 19 years of service and throw you out. So that is something we ought to pay attention to. I yield back.
Gentleman's time has expired unless there are further. Mr. Bishop, do you wish to be recognized?
I do. I thought you're not going? Okay. Yeah, I do. Madam Chairman, I will speak on the amendment. Am I recognized to do that?
Yes, you are.
I did want to further the comments that the ranking member made first on the subject that the gentlelady from Pennsylvania remarkably suggested, that if she could find concern for domestic victims' rights on this side of the aisle, she would be relieved. And of course, this amendment is about concern for victims of domestic violence. That's the premise of it's the very core of the amendment. But last week, I guess it was last week, I lose track, the Democrats defeated an amendment from Mr. Massey to permit victims of domestic violence a special dispensation from otherwise what was going to be a ban on classes of weapons in common use, mostly semi-automatic center-fired rifles. And Mr. Massey had an amendment to allow, well, let's let domestic violence victims have that dispensation. Of course, that was rejected. Remember, the chairman memorably spoke to it, said he didn't think that it was good for anybody to be able to defend themselves from domestic violence with such a weapon. And then 2 weeks ago, or maybe 3, there was the Democrats' grab bag of gun control, gun grab measures, and one of those was a new straw purchase provision.
Mr. Massey offered an amendment for an exception to that also, so that if a neighbor taking pity on a battered wife were to buy a gun for her, give it to her, and if she were to receive it, they would both be criminals under the Democrats' law. He offered an amendment to at least take those poor victims out, and all those that wear the concern for domestic violence victims on their sleeves couldn't do that. So I'm not sure that the gentlelady is looking in the right direction when she finds the absence of concern for victims of domestic violence. But let me also speak to something else that this amendment brings to the fore. And I got a chance briefly to ask the chairman, Ms. Lofgren, about so remember the hypothetical is the non-citizen former member of the military who's been convicted of domestic violence for beating his wife, but he found that he was beating his wife when he woke up. He found himself, I think he said he woke up to find himself beating his wife, or assaulting his wife. Now, okay, and Mr. Tiffany appropriately pointed out, if it were an involuntary act for real, then he's not guilty. And Mr. Buck confirmed that. I'd say something else. I don't believe him. I'd put it that way. I'm sorry if I'm offending anybody, stepping on anybody's toes about PTSD. I don't believe you choke your wife while you're asleep when you got domestic violence. But I got to say this. One of the principles of a system of justice is finality. And so what we build discretion into the process, and then at some point in time, you've had your bite at the apple, there's finality. It works both ways. You can't be held in double jeopardy for a crime, be convicted or prosecuted multiple times. It works the other. If you bring a lawsuit, your claim is precluded. You got to bring everything in one lawsuit, or your claim is precluded. Well, here there are multiple stages for the exercise of discretion. First, the victim, who he probably told that he didn't know he was choking her, but he was having PTSD, and she didn't believe him, apparently. That's why she brought him in. She exercised discretion. And then a prosecutor exercised discretion and said, no, we're prosecuting you. And he was convicted. And then there was another stage for discretion to be exercised, because there was an immigration judge that entered a removal order. And the United States, the Attorney General was represented in that process, and that Attorney General's representative could exercise discretion. Discretion was exercised again, and they decided to remove that person from the United States. And so now, what is proposed is a new measure to allow discretion to be exercised again. And all Mr. Tiffany's asking in this amendment is say, well, maybe before he gets discretion exercised in his favor a fourth time, the victim ought to be considered the first time. That's all this amendment does. And I cannot imagine anyone who would have the brass to sit over there and say there's no concern for domestic violence victims here and vote this amendment down. Let's watch. Yield back.
Gentleman yields back to additional individuals. I think we have had a series of votes called on the House floor. If there's additional members who wish to debate this amendment, I think we'll have to recess and return after votes. House is in recess and stands in recess until the conclusion of the votes on the floor.
Zach Zubia.
The Judiciary Committee was to reconvene right after votes, and I do think we'll give members another 5 minutes to arrive from the floor. The vote's been over for, 15, 20 minutes. We have a quorum. I don't want to proceed. We all agree. So the Judiciary Committee is now has reconvened after our recess. We have a number of members, I believe, who are in the back room and a number of members who are present online. We were in the process of discussing the amendment offered by Mr. Fitzgerald of Wisconsin. Are there additional members who wish to be heard on the Fitzgerald amendment? The Tiffany amendment, pardon me. Mr. Gates, do you wish to be heard?
Is this the precluding factor amendment? Is this the right amendment?
This is here it is. Do you wish to be heard, Mr. Gates? Okay.
No, I wouldn't.
All right. I think Mr. Buck has already been heard on this amendment, and are there any other members who wish to be heard on this amendment, including members who are participating remotely? Raise your virtual hand if so. Hearing no one, then, the question is on the amendment before us. All in favor will say aye. All opposed will say no. No. And in the opinion of the chair, the noes have it. There is a request to have a recorded vote on this amendment, so the clerk will please call the roll.
Mr. Nadler? Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee?
Who knows what we're voting on? I don't know what we're voting on. Oops.
Mr. Cohen?
You're in the picture,
Mr.
baby.
Johnson of Georgia? Mr. Deutsch? Ms. Bass?
How's the chair voting?
The chair
Hello?
votes no.
Well, Ms. Bass votes no then.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin? Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Dimmings? Mr. Correa? Mr. Correa?
Correa votes no.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse? Ms. McBath?
It's okay. I tried
Mr. Stanton?
calling to tell you it's the second floor. Because
Mr. Stanton?
Yes.
Mr. Stanton votes yes. Ms. Dean? Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Shabbat? Mr. Gomert?
Aye.
Mr. Gomert votes aye. Mr. Isa?
Mr. Isa votes yes.
Mr. Isa votes yes. Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stubbe? Mr. Tiffany?
Tiffany, aye.
Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Bishop?
Aye.
Mr. Bishop votes aye. Ms. Fishbach? Ms. Sparts? Mr. Fitzgerald? Mr. Benz?
Mr. Benz votes aye.
Mr. Benz votes aye. Mr. Owens?
Owens, aye.
Mr. Owens votes aye.
Nadler, aye.
Mr.
Nadler, no.
Mr. Nadler votes no.
Shabbat, aye.
Mr. Shabbat votes aye.
Cicilline, no.
Mr. Cicilline votes no. Ms. Jackson Lee, you are not recorded.
Georgia votes no.
Ms. Jackson Lee votes no. Mr. Johnson of Georgia votes no.
Deutsch votes no.
Madam Chair,
Mr. Raskin votes no.
Fishbach votes aye.
Ms. Fishbach votes aye.
How's Mr. Deutsch recorded? You're muted, Mr. Deutsch.
No.
Mr. Deutsch votes no.
How is Mr. Raskin recorded?
Mr. Raskin is recorded as no.
How is Mr. Jordan recorded?
Mr. Jordan votes yes.
How is Swallow recorded?
Mr. Swallow, you are not recorded.
No.
Mr. Swallow votes no.
Are there additional members wishing to vote or to change their votes? Who are we waiting for? Okay.
Madam Chair, have I missed the vote? It's Dean. How am I recorded?
How is Ms. Dean recorded?
Ms. Dean, you are not recorded.
I'm a no.
Ms. Dean votes no.
Any other member wishing to vote or to change their vote? I think so.
How is Ms. Demings recorded?
Ms. Demings, you are not recorded.
Demings votes no.
Ms. Demings votes no.
There are additional members wishing to cast their votes? If not, then the clerk will please report.
Madam Chair, there are 15 ayes and 18 noes.
And the amendment is not agreed to. Are there additional, Ms.
Madam
Fishbach? Yes?
Madam Chair, I have an amendment at the desk.
The clerk will report the amendment, and Ms. Escobar reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Ms. Fishbach, Minnesota. Page 10, after line 2, insert the following. H, limitation of eligibility for case review. An individual who is inadmissible based on a conviction of an aggravated felony described in subparagraph A of section 101A43 of the Immigration and Nationality Act shall be ineligible for a case review under this section.
Pardon me, the gentlelady is recognized to speak on her amendment.
Thank you, Madam Chair. And I'm offering an amendment today that should be easy for everyone to agree to and vote in favor of. My amendment is simple. It clarifies that those who are being deported for committing the most heinous crimes are not given a review by the advisory committee established under Section 4 of this bill. This advisory committee is directed not only review the cases of veterans or members of the armed forces, but it is expanded to review the cases of covered family members that include their family, spouses, and children as well. Non-citizens who commit murder, rape, and sexual abuse of minors do not deserve the privilege of remaining in this country. There is no reason to review and delay the deportation of these most violent offenders. As soon as these violent offenders and criminals have served their prison sentences, these individuals should be removed from our country immediately. They should not be given the ability to appeal to the advisory committee. Their removal proceedings should not be deferred or terminated. I ask for support on this amendment to protect Americans from these violent criminals. Thank you, Madam Chair, and I yield back.
The gentlelady yields back, and the gentlelady from Texas does not insist on her point of order because the amendment is germane, and I recognize myself in opposition to the amendment. I was here in 1996 when Henry Hyde chaired the committee and Lamar Smith was the chair of the, I believe, the Immigration Subcommittee. He and Mr. Lamar Smith, I believe, was the one who came up with a redefinition of what is an aggravated felony, and it's a highly misleading term. crimes do not need to be aggravated, nor do they need to be felonies to be considered an aggravated felony under immigration law. There are over 20 categories of aggravated felonies encompassing more than 30 different crimes. Some are, in fact, serious matters, such as rape and murder, and as we know, those crimes are already excluded from consideration. Also included as a so-called aggravated felony is shoplifting, selling $10 worth of marijuana, filing a false tax return. In addition, certain foreign convictions can be considered under the Immigration Act aggregated felonies if they occurred within the last 10 years, even though we might not think of them as serious matters. Once a crime has been designated as an aggravated felony, the definition applies retroactively, and that means that even if a crime was not considered an aggravated felony under the changes made in the '96 Act when it was committed, being convicted of such a crime could render an individual removable because the law was changed subsequent to that. I think that the conviction of an aggravated felony is immense, and it makes one subject to removal, also makes one subject to mandatory detention, and in some cases allows for removal without even a hearing. Individuals convicted of aggravated felonies are ineligible for asylum, cancellation of removal, voluntary departure, and certain other inadmissibility waivers. I do think that the serious crimes that we would agree with are already covered in the bill. And
Would the chair yield?
I would be happy to.
Could you show me exactly where they are exempted from the, appearing in front of the advisory committee? Because I do not see where this advisory committee is.
Reclaiming my time, I misspoke, and I apologize, because this is related to the advisory committee.
So they are not exempted from this.
But it's just a review. It's not reclaiming my time. The real point that I'm trying to make here is that an aggravated felony is not what it sounds like. It is not aggravated, and it's in many cases not a felony. It was a product of a process where then Chairman Lamar Smith wanted to tighten up these removals. Elton Gallagly, who was a member from California, was in agreement with Mr. Smith, and the law was changed, and in a way that I think, in some ways, although I would certainly not accuse either one of those gentlemen of attempting to mislead, but in fact, the term is rather misleading. And I would urge that we not adopt this amendment because—
Generally, to yield on that point for a moment.
I'd be happy to yield, sir.
So I remember when Secretary Mayorkas testified before us. No. I guess that was in Homeland Security. No. But he made a big deal of the fact that there was they had a lot more aggravated felony things that they had. I'm trying to remember what the usage of it was. But what you're saying is that's a crock. And when he was proclaiming how they had made all this progress on aggravated felonies and the number of felonies that had been charged, they could have been $10 a shoplift?
Reclaiming my time, I don't recall that testimony, and so I'm not in a position to comment on it.
But you are telling me that the term is misleading.
I think it is misleading because I don't think—
Fascinating, because he really made a big deal of it.
I don't know. There are some serious offenses that are caught up in the term, and there are also some offenses that are not as serious. I'm not saying I'm in favor of shoplifting. I'm not. But I don't consider it the heinous crime of murder and rape and
in San Francisco,
items.
they're really good with shoplifting. It's not punished at all.
We've got a new law and order DA that's going to fix that. So with that, my time has expired, and the ranking member, Mr. Jordan, is now recognized.
Thank you, Madam Chair. I guess what's not misleading is the intent is the amendment itself. The amendment itself says rape and murder are not misleading. Those are terrible crimes, and there are some crimes so bad you shouldn't even get it shot in front of this advisory review board, and that's what the amendment does, and it seems to make sense. So you can say aggravated felony is a term that's sounds worse than it is, but she's talking about specific aggravated felonies. If you got someone who's murder, rape, and they shouldn't get in front of this advisory board to get to stay in the country. That's the focus of the amendment, real simple, and why we wouldn't. And if it needs clarifying, I'm sure the gentlelady from Minnesota is open to clarifying that. But that's what it's about. Some crimes are so bad you don't want to go, and we don't even want the opportunity to go in front of this advisory board. And I would yield to the gentleman from North Carolina.
I thank the gentleman, and I guess the colloquy I was just having with the chairman, if the term aggravated felony has some inappropriately modest crimes included within it, if it also has really serious crimes, then the point of the amendment is well taken. I thought so on the previous amendment about domestic violence victims, but it does seem to me you got somebody that's raped a 10-year-old child. Should that person? So let's say that person that we've seen in the news lately that raped a 10-year-old child. Let's say that should turn out to be a veteran. He's an illegal alien, but at this point, but he's a veteran. Should he be exempted from the process of being removed from the country? Categorically? No, you're putting the category in the right place. Categorically, it ought to be ineligible for review.
Would the gentleman yield?
I will.
Because I think there's been a misreading of the amendment on our part, and I would like to note that it's section 101, subparagraph A of section 101A43, which is limited to murder, rape, or sexual abuse of a minor. And exactly, except that we had overlooked the A, and so I want to acknowledge that. And
So, Madam Chair, would that mean you would?
they're not eligible anyhow, but I don't have a problem with specifying that because I think it's already covered in the bill. But so I'd ask unanimous consent that we accept this amendment so we don't have to do a roll call, and we can see if there are other, all in favor are saying aye, unanimous consent, no one objects. Are there, please. It's, rape and murder is already excluded in the underlying bill. So,
What is on? Okay, I'm sorry. This is a very good example of when we are allowed to offer amendments and to have a discussion, and that we do improve the bill.
Well,
and this is something that doesn't always happen.
if the gentlelady would yield, I actually think it's redundant, but because it's redundant, I don't object. So,
I appreciate the chair's opinion, but I do not think it's redundant. And I think that it is an important part that we make it clear that we do not want murderers, rapists, and those who abuse children sexually to remain.
so unless, without objection, that amendment is I know we're doing it by unanimous consent. Are there additional members who wish to offer, hearing no objection, are there additional amendments that would? Yes.
Yeah.
Correct. Are there additional amendments? If not,
Yeah, we're good. That amendment's in. Mr. Biggs.
Mr. Biggs, do you have another amendment you're trying to offer?
No, Madam Chair, I just want to make sure that you said that by unanimous consent that
Correct.
the amendment is
It's adopted, and there was no
adopted. Okay, very
objection.
good. Thank you.
Correct. Are there additional amendments? Mr. Buck has an amendment at the desk. Clerk will report, and Ms. Escobar reserves a point of order. The clerk said, does the clerk have an amendment?
I'm going remote. I'll be back.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Buck of Colorado, page 14, beginning on line 23. Strike quote or K quote and insert quote K or S quote.
The gentleman is recognized to explain his amendment.
I thank the chair for recognizing. Madam Chair, this is a very simple amendment. What it does is it just adds obstruction of justice as a factor. And I think it's obvious that folks who have lied, who have obstructed justice, are not people who we want to fit under this underlying bill. The idea that someone would obstruct justice is offensive. It is that kind of misleading conduct. If they're going to lie in this situation, will they lie when they present evidence to an immigration judge? Will they lie in other circumstances? And so the act of lying, I think, is the kind of offense that we want to take seriously. It is clearly germane, and in this case, I think that we have a conviction for lying, for obstruction of justice, and now we're asking someone to fill out paperwork that would qualify them to be in the country, and it is the kind of conduct and underlying activity that we should take seriously as members of Congress, and with that, I would yield back.
The gentleman yields back, and the gentlelady from Texas does not insist on her point of order because the amendment is germane. I recognize myself in opposition to the amendment. You know, I recall, maybe I don't know, Mr. Gomert is still on, but I remember a constituent case of Mr. Gomert's a number of years ago where he had a businessman in his district who had, as I recall, he'll correct me if my recollection is incorrect, had to apply for a liquor license. I think it was a store that he had, and he had signed under penalty of perjury that he was an American citizen, but he did it by mistake because he also added his alien registration number on the form. So clearly, he wasn't trying to say that he was a U.S. citizen when he added his alien registration number. And what we found out was that although that was perjury, there was also no excuse for a false claim of citizenship. And Mr. Gomert felt at the time that it was really an injustice to this constituent of his. There are all kinds of situations of that nature that might at least be given consideration. As I note, of the 60 applicants for the current administrative program, only 16 have been approved, 8 have been denied, and I think to cut off the opportunity to at least be considered is not the right approach. I appreciate the gentleman's amendment. I'm no doubt that it's offered in good faith, but I would urge opposition to the amendment and yield back. Are there further? Mr. Biggs, do you want to be heard on this?
Yes, Madam Chair. Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you so much. I first of all want to commend the chair on her openness on the Fischbach amendment. I thought that was well done, and I give you thanks. Now, on this particular amendment, again, I'll get back to my litany that I've been talking about all day, and that is, under the current state of law, non-citizens serving the militaries are going to be protected. What we're talking about here are those who have committed a crime. Not just that they've committed a crime, but that they've been convicted of a crime. And as Mr. Bishop pointed out, there are at least four points of review. But the one he didn't count in his points of review here was that a judge or a jury has found the person guilty of the crime as well. So again, the Secretary can't waive for certain that this certainly cannot waive criminal conduct if somebody's already been removed. But the advisory committee is not so constrained. They don't have to take any of this stuff into account if the person's not yet been removed. So in this particular amendment, the reason I think this is important is because I want to expand on it, because it doesn't just talk about obstruction of justice, which, by the way, is an incredibly serious problem. But it talks about perjury, subornation of perjury, or bribery of a witness, for which the term of imprisonment is at least 1 year. So we're in the aggravated criminal statute, and we're talking about far more than just obstruction of justice. We're talking about any one of a series of very disquieting interferences with due process. I think those are serious offenses, and I'm perfectly content with including those as part of what you're doing in the limitation on the waivers. And Mr. Buck's amendment actually links it with subparagraph K, which is basically dealing again with human sex trafficking. So I think that's really important, and I think it's necessary. I think it's something that should be presented and approved, and I would encourage everyone to vote yes. And I didn't get a chance. I made it back to the committee just a tad too late to talk about the domestic violence amendment. So I want to mention that briefly before I yield back. And this notion that we shouldn't include domestic violence crimes as precluding someone from staying in the country or coming back to the country is so important. I literally prosecuted hundreds of domestic violence cases. And I rode along with police officers to domestic violence situations. I think it's a really serious crime. I think it's something that should not be treated lightly. And it has such enormous mental, emotional, and sometimes very serious physical ramifications for the victim, and in cases where families are there, every member of that family. It is detrimental to our society, and I think it's really important, and I wish we would have included that. And I wish that we wouldn't politicize it and have some people say, well, this side of the aisle doesn't care about domestic violence victims. Well, I had the opportunity to present cases dealing with domestic violence, and they're very serious, and I wish that we would have adopted that, and I hope that now we'll adopt Mr. Buck's amendment. And with that, Madam Chair, thank you so much, and I yield back.
Gentleman yields back. Do additional members wish to be heard on this amendment? Mr. Massey.
Wish to speak on the amendment?
They are recognized.
And I yield time to Mr. Buck from Colorado.
I thank the gentleman for yielding, and I just want to point something out to the chair. First of all, I really appreciated Mr. Bishop and his description of the kind of discretion that is apparent and allowed at each stage of the proceeding. And I wanted to add a couple of discretionary actors in this process, not only for domestic violence, but for all these crimes that are listed here. And it really starts with the victim. The victim of domestic violence, the victim of any offense, can decide to call the police or not call the police. And then the next group are the police. And then the police present their case to a prosecutor who has discretion. The prosecutor then charges a case and moves forward with the case, and the next group are the citizens and the jury. So a jury has discretion over whether to hear a case or not hear a case, or whether to convict or not convict. And finally, the judge has discretion, not only at sentencing, but the judge can also rule and overrule a jury's verdict if the judge finds that it's not based on sufficient evidence. And so there is a number of areas of discretion in the system built in right there. But then in addition to the trial proceeding, then you've got the appellate proceedings, where you've got an appellate court that can rule on the underlying facts. And then it's presented to an immigration judge to determine whether that particular offense fits in with the statutory scheme for the immigration authorities. And so I think that's really important. But Madam Chair, I just wanted to read a little bit of this statute so we could get a feel for exactly what subsection S says. It says an offense relating to obstruction of justice, perjury, subornation of perjury, or bribery of a witness for which the term of imprisonment is at least 1 year. Of course, that only indicates that it is a felony, the term of imprisonment being at least 1 year. But the idea that this is not just obstruction of justice, but it is perjury, subornation of perjury, or bribery of a witness is really important. But when you look at the statute as a whole, you can see the significance that Congress placed in choosing subsection S. Subsection A is what we just allowed as an amendment to this bill: murder, rape, sexual abuse of a minor. Subsection B, illicit trafficking in a controlled substance. Subsection C, illicit trafficking in firearms or destructive devices. Subsection D, an offense described in Section 1956, money laundering, and 1957. This whole list of offenses that Congress has previously listed are serious offenses, and offenses that I think we should take seriously. And we get to this subsection S, which is the offense relating to obstruction of justice, perjury, subornation of perjury, or bribery of a witness. I think when you look at subsection S in the totality of this statute, you realize just how important our colleagues in the past have recognized this offense, and it is something that we should recognize as a serious offense also. And I would ask for support for this amendment. I yield back to my good friend from Kentucky.
I yield back, balance of my time.
Gentleman yields back. The gentlelady from Texas is recognized.
I thank the gentlelady from California, Chair, and let me try this one. Thank the gentlelady from California for yielding, and I spent time listening either as I was called to other meetings, continued to listen to the debate, participated in it earlier, and here I am, now we're here again. Let me recognize the unanimity of the past amendment, the rape, murder, abuse of a child that has been included. And I want to get back to the original premise of this legislation, and that is that veterans who are put in removal proceedings will have their whole cases reviewed. And it may include any number of circumstances. As indicated earlier by the gentlelady, I work extensively on post-traumatic stress disorder funding and also deal with veterans who have PTSD in my community, in my district. So we know that that is something that looms very large and now recognizable. Years ago, it was not. And I don't think we get anywhere by ignoring what the bill does, that there is a review process. And again, I'll use the term in quotes. My friends on the other side are wanting to ignore double jeopardy, which is they are being prosecuted, maybe convicted for whatever the allegation is, and they have already been such. Then you provide what for many would be a death knell, because I too think this is a great country of freedom, And these veterans put on the uniform because they believe that as well. Their families are here. There is no doubt in this committee we have recognized that people can be rehabilitated, restored. So if this is something, I put quotes around it for whoever is mumbling over there. But in any event, those who understand the metaphor will understand the point that I'm making. In any event, I just think this long litany of what about this, what about this, what about this, completely ignores the basis of the bill. Someone who has been a veteran, someone who's served in the United States military, someone who's bled, who's wounded, who did 4 tours, 1 tour, was in a war, who served 20 years or served 5 years, and now comes upon circumstances where that they are a permanent resident, but they're not a citizen, and that it is the swap of deportation. And they might be in the midst of rehabilitation. I just think that the crux of the bill has a very important merit. It is very meritorious. It is the right thing to do. These individuals being reviewed may not be protected from being deported, but they will have the right to have this review, and that their veteran or their military service will count for whether or not it would be superior to whatever the incident is or the action that they participated in. I think that is the appropriate way to go. I mentioned in closing earlier a gentleman who was a firefighter, and he received a letter in the mail that he was to be deported. We were trying to track down why he had this letter and didn't have the ability for relief. And in the midst, it caused a family crisis. This is very emotional. They have been contributing to our community. We need firefighters. We need public safety officers. We need the public safety community, and we need the work that veterans can do when they return home from their service. Why deport if this commission can review and determine otherwise? So I oppose the amendment and the series of amendments that have occurred, including some previous ones that I'll speak about later, but in any event, and support the underlying bill. I yield back.
Gentlelady yields back unless there are additional members wishing to be heard.
Madam Chair.
Gentlelady is recognized.
Madam Chair, I move to strike the last word, and I would yield my time to Mr. Buck.
I thank the gentlelady for yielding, and I just wanted to address with my friend the issue of double jeopardy. I think that when you look at the issue of double jeopardy, certainly someone who has committed a bank robbery and then applies for a gun permit is not only punished for the bank robbery, but then is punished a second time by not being able to purchase and possess a firearm. And I don't think any of us would disagree that that is appropriate, and Congress can, in fact, legislate in that way. When the gentlelady says that someone who has bribed a witness or committed perjury is punished a second time by not being admitted to the country, I don't believe that fits within the definition of double jeopardy. I don't think that's what it's intended by double jeopardy. Double jeopardy is being prosecuted for the same crime, for the same conduct in separate occasions. This is a penalty that is that flows from the original conviction, and I think in this case it is an appropriate penalty that flows from that conviction. I'd be glad to yield to the gentleman from Texas for further constitutional analysis, or the gentleman from Arizona.
Question is, would you be happy to yield to me? Because
Oh, I would be happy to yield to you, absolutely.
You're speaking, this is the gentlelady's time
Oh, I'm
here, I
sorry.
think. Will the gentlelady yield to me for a moment? I'm sorry.
Did Mr. Roy?
No, you're going to yield to her? She's going to, okay.
I would yield to the gentlelady from Texas.
Thank you very much. I appreciate the gentleman's gentlemanly definition. I happen to disagree. Again, let me say that I use it as a characterization, not the precise definition of double jeopardy. So I would simply say that you punish the person twice in the instance of them being a veteran. So we are trying to accept out veterans who wear the uniform, who have fought in a war, who have served admirably, and now are subject to deportation. In the instance of that veteran having an offense, and we have listed, you've had a number of amendments here, and we have a number of exceptions, but there are a number of amendments to add this and add that. To the extent that those particular offenses that you tried to get in had gotten in, that veteran more than likely might be incarcerated, might have already been in jail, might be out now, and then you add punishment by deporting them. So that's what I believe sort of uses the characterization of double jeopardy as opposed to its strict legal interpretation. You hit them twice, and they're a veteran, and I don't believe that they should be hit twice. I'll yield back.
Madam Chair, I yield my time to Mr. Roy from Texas.
I appreciated listening to the gentlelady from Texas, and I think, I'm certain my colleagues on this side of the aisle are, supportive of and, of the belief that we should ensure that veterans who served honorably, who are here legally, are able to avail themselves of continued legal status, and that is current law. Again, everything we're talking about here has to do with those who are criminals. And while I think I understand what the gentlelady is suggesting with respect to a concept of double jeopardy, is decidedly not, as my colleague from Colorado was pointing out, the legal definition of double jeopardy. The fact is, and he walked through it, and my friend from North Carolina, Mr. Bishop, walked through it, the due process, all of the redundancies in our legal system you go through. In the due process, you've been convicted in a court of law, you're a criminal, and the question here then is your status, and should you stay here? And these questions, now we're talking about obstruction of justice. We're trying to figure out which things is it, that we believe, merit ensuring the people who stay in the United States or have legal permanent residence are those who are deserving. And that's simply the question. We've already acknowledged that there are some that aren't. Right? So, that's the whole point here. We're having a debate here about, categories because we recognize there are some categories that are not deserving of staying in the United States. And I think that's what we're trying to flush out. And I'd yield back since I'm over my time.
Gentleman yields back, and the time has expired. Unless there are further members, and I think everybody who's asked has already asked to speak, the question occurs on the amendment that has been offered. All who favor the amendment will indicate by saying aye. Opposed will indicate by saying no. No.
No.
In the opinion of the chair, the noes have it, and a recorded vote has been requested. Clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen?
Just take a minute.
Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
Bass votes no.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu? Mr. Raskin? Mr. Raskin?
I guess I'm copying.
Smart way to.
Mr. Raskin, did you unmute? Mr. Raskin?
Well, I have a question about.
Florida House on Capitol Hill.
Ms. Jayapal?
Jayapal votes no.
Ms. Jayapal votes no. Ms. Stimmings? Ms. Stimmings?
No.
Ms. Stimmings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Shabbat? Mr. Shabbat?
Aye.
Mr. Shabbat votes
Aye.
aye. Mr. Gomert?
Aye.
Aye.
Mr. Gomert votes aye. Mr. Issa? Mr. Buck? Mr. Buck votes aye. Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stube? Mr. Tiffany?
Tiffany, aye.
Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye. Mr. Roy?
Just made it.
Mr. Roy votes aye. Mr. Bishop?
Aye.
Mr. Bishop votes aye. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz?
Aye. Mr. Benz votes aye.
Mr. Benz votes aye. Mr. Owens? Mr. Owens votes aye.
How is Mr. Jordan recorded?
Mr. Jordan is not recorded.
Yes.
Mr. Jordan votes yes.
Mr. Issa votes yes.
Mr. Issa votes yes.
Is that Mr. Deutsch?
Deutsch votes no.
Mr. Deutsch votes no.
Mr. Liu votes no.
Mr. Liu votes no.
Mr. Raskin votes no.
Mr. Raskin votes no.
Are there additional members wishing to cast their vote or to change their vote? If not, then the clerk will report, please. Clerk will report. Oh, is Mr. Gates trying to log on? Okay.
Madam Chair, there are 15 ayes and 20 noes.
And the amendment is not agreed to. For what purpose does Mr. Roy seek recognition?
to speak on the underlying bill.
Gentleman is recognized to strike the last word.
I thank the chair. One of the issues that I think a few of my colleagues have addressed is, one of the reasons why we're zeroing in on the specificity of this legislation is just frankly a fundamental lack of trust of the Department of Homeland Security, or frankly any of our federal departments. I just don't trust the Secretary. It's that simple. And I don't know why I would. The Secretary of Homeland Security sat at that table, looked at me in the face of a statute defining operational control, and said to me and to this committee and all Americans watching that this administration has operational control of our border. And it's a flat lie. Even just today, Saint Beto O'Rourke in Texas was out on the campaign trail and was asked that question. And he said, yeah, I don't see how that could be the case. He was asked the question whether we have operational control of the border, whether it was secure. And Saint Beto said he did not see how that could be the case based on all of the conversations he was having and all of his observations. Now, how could that be? How does that fit with the narrative? I'll just tell you why I don't trust the Secretary to do any of this, in addition to the fact that he lied to me, lied to America, lied to everyone on this committee. It's accusing Border Patrol agents of whipping human beings that was also a flat-out lie, not apologizing for it, and running a scam procedure to then give them some administrative punishment. Why would I trust that secretary? Why would I trust a secretary that that puts out a memo saying it's not enough to be here illegally for ICE to then go remove them? Why would I trust a secretary that isn't detaining anybody at all, but releasing them into the United States under parole and under notice to appear, and not in fact doing any asylum proceedings? No, it is true. It is true. Speak to the people at the border where they've got the proceedings where they're literally running them into tent facilities and releasing people under notice to appear and parole, skipping right over doing any credible fear asylum claims. They'll tell you that right at the border. They're not doing it. They're flat releasing them under parole and giving them notice to appear. Why would I trust a secretary or an administration or my colleagues that go down in white pantsuits and cry looking across bars, all for effect, all bogus? The entire story was made up. Why would I trust? Why would I trust a secretary who now has the lowest ICE removal numbers in DHS history? Why would I trust that secretary? Why would I trust the secretary to use this discretion, even if it's for veterans? But I remind you, veteran criminals who've gone through due process and convicted of a crime. Why would I trust the secretary to make a good decision? It's simply just not possible for me to talk to the people on the border, talk to people involved at the Department of Homeland Security today, knowing precisely what this administration is doing purposefully, to use every possible tool in the book. And by the way, we're about to take up a bill to grant even more discretion, to provide even more avenues for the secretary to say, you can be released into the United States. Literally. It's like, oh, it's not enough. 2 million's not enough. 850,000 gotaways is not enough. Over 50 terrorist affiliates, not enough. Not enough gang members, robbers, and rapists that are getting caught coming in our country, not enough. We got to provide every tool in the book. So I'm going to oppose this bill. Not because I don't support veterans who serve honorably, but because I don't support an administration that I can't trust. I yield back.
Gentleman yields back unless there are additional.
I'll talk.
Gentleman from Ohio, the ranking member is recognized.
Thank you, Madam Chair. Just picking up where my friend from Texas was. You know why we don't have operational control? Because they don't want it. They don't want control of the border. This is intentional. We talked about this when we had the secretary here. Month after month after month, we set records for illegal migrants coming into the country. Month after month. Never forget what the secretary said when he first took the job. He said, we are executing our plan. Month after month of record numbers, the secretary says we are executing our plan. Their plan, it's intentional, deliberate, premeditated to not have operational control of the border. And of course we don't trust this guy. The gentleman's point is so well taken. Why would we give more discretion, more power, more authority to someone we do not trust and who is intentionally not following the law, intentionally opening up the border? How can we trust someone who came in front of this committee, as the gentleman pointed out, sat at that table right there, and we asked him a question about the 42 people who came across the border who were on the terrorist watch list, and we asked him a simple question. Now remember, this is the Secretary of Homeland Security, whose job is to make sure the country is secure as possible. We asked him a question about the 42 individuals who came across the border who were on the terrorist watch list. We said, what is their status? Anyone remember what his answer was? I don't know. The Secretary of Homeland Security said, I don't know. Now, you're coming in front of the Judiciary Committee for the first time since you've been Secretary of Homeland Security, and it's been reported that 42 individuals come across the border and on the terrorist watch list. You would think he would have done his homework and could at least tell us the status of those individuals, but he couldn't. We didn't know the status of those individuals until the following Sunday on one of the Sunday shows where he told us, because he got asked by someone, I forget what show he was on that Sunday. So the gentleman from Texas is right, and it's where Republicans are on this bill. Why would we support that? Why would we give more discretion, more authority to folks with the kind of track record we have seen where we actually, folks from Texas know this, we no longer have a border. It is complete chaos. There is no border. And we've set record after record after record, month after month after month. And I would yield to the gentleman for Texas if he has further comments on the legislation.
I think the gentleman from Ohio, I do want to go back to this revelation today that the current gubernatorial candidate, Democrat Beto O'Rourke, asked today, is the border secure and do we have operational control? And he said, effectively, no. Why would that be? Why would the Democratic candidate for governor in Texas have to answer the question that way? Could it be because he's in a race for governor and he's trying to appeal to the people of Texas and the people of Texas know the truth? Is that what it could be? I think it speaks for itself. I think we know exactly why that's the case. And stay tuned for him to change his sentiment tomorrow when he's speaking to a different audience. But the fact of the matter is, we know precisely what this administration is doing. It is to advance, and the words of the Deputy Press Secretary of the White House in the United States, a liberal world order. Wide open borders, no sovereignty, no respect for the rule of law, no belief in the American exceptionalism and greatness that is built on the rule of law and a secure border. And this is an extension of that, and the legislation coming is an extension of that. And every bill that is being offered in this committee regarding this issue is an extension of that, and a complete abomination and undoing of the rule of law. I yield back to the gentleman from Ohio.
I yield back.
Gentleman yields back. Unless there is an additional, Mr. Fitzgerald, do you have an amendment?
Madam Chair, I have an amendment at the desk.
The clerk will report the amendment, and the gentlelady from Texas reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Fitzgerald of Wisconsin. Page 14, line 23, insert quote C, quote after quote A, quote.
Gentlelady does not insist on a point of order since this is germane, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Madam Chair. I'll be brief. We should honor those who have served, but those who have been given due process after committing dangerous crimes should not subsequently be allowed to be given a green card. It's pretty simple. This administration certainly hasn't earned the benefit of the doubt when it comes to the border issues, as we've discussed back and forth here in this committee. Certainly, there are many questions. Those trafficking firearms are often involved in drug and human trafficking or smuggling as well. This amendment simply would prevent the granting of a green card to an illegal alien who has been convicted of trafficking firearms. I would just simply ask the committee to support the amendment, very similar to what we've seen earlier this evening. But again, I think highlights the idea that there are specific individuals that should not be given the benefit of the doubt. And I would urge my colleagues to vote for the amendment. Yield back.
Gentleman yields back. I recognize myself in opposition to the amendment. I would note that the exclusion already, I'm looking for my notes here, includes individuals who pose a threat to national security. That's in the underlying bill. If someone had an offense that was 10 years old or 20 years old and was a veteran, I think having the opportunity to at least make their case is a reasonable one. But if there is a current belief that the applicant is a risk to national security, then they're excluded from consideration. I think that covers what needs to be covered, and I would hope that we can move forward and vote on this amendment and hopefully the underlying bill. And with that, I yield back. Anyone else wish to be? Mr. Biggs, you're recognized.
Thank you so much, Madam Chair. And I would just say there's been a common theme of the amendments that we've tried to go for, and that is, if you're convicted of an aggravated felony, after all the due process that you've had, you probably shouldn't be allowed to be brought back into the country. You probably should be removed. I mean, you're going to have a separate hearing on that anyway, but trafficking in firearms or destructive devices or in explosive materials, I'm finding it hard to understand why we'd say, well, you know what, we can waive that. We can waive that if you've been convicted of that. And I appreciate my friend from Texas who was talking earlier about double jeopardy, and I do think she was talking about it as a metaphor. But there is no reality to that double jeopardy or collateral estoppel type of argument. I mean, because that wouldn't go. Now, I wanted to address something else which I didn't get a chance to talk about earlier because I hadn't come back from voting yet. And that is something that the ranking member had talked about earlier today, and that is the gentleman who came in and disrupted our proceeding a week or so ago. The institution that we have today is really very different than it was just a few short years ago. That individual, he didn't just walk in like it used to be. He didn't walk in. He had to be let in. Somebody let him in. And oddly enough, we have videotape of it. We don't. The chair does. The chair has access to it and can get that. And so someone knowingly escorted somebody in. And our institution looks very, very different today, both in the House rules, the interactions that we have. And that's one reason Madam Chair, I commended you earlier today for accepting that amendment, because that has become unique and very different, and I appreciate it very much. But if we took Mr. Johnson of Georgia's logic to its conclusion, because he said, well, we seek answers about January 6th. I would wonder if he was suggesting that the question about Mr. Hogg's presence, who brought him in, his outburst, it was obvious. There's anybody here that didn't think at some point that was going to happen because he has a track record in history. So I would wonder if Mr. Johnson of Georgia is suggesting that we have a separate committee formed to investigate, and if that's the case, is that committee going to be made up of 8 Democrats and 5 Republicans that were actually chosen by the Democrats? We're going to see doctored videos, leaked selected testimony, etc. I don't know. But I do know one thing. We have a real sense of two-tiered justice in the world today. We have recently revealed that it looks like the whistleblowers have indicated that the Department of Justice and the FBI were actually downplaying and not fully investigating the computer of Hunter Biden. We have stock trades that are eerily timed to make millions of dollars for members of Congress. So there's some unique aspects to all of this, and I think that to put this to rest, I would urge the leaders of this committee to please get the video, look at it, find out who let the individual in. Let's get there. But then getting back to the amendment, which I think is an appropriate amendment, I find it intriguing that the argument would be made that for whatever reason, somebody who is trafficking in firearms and explosive materials is going to be given a pass with regard to an extraordinary benefit. And it isn't like they're just merely accused. They're convicted of it. That's what I find so intriguing about saying, well, we're not going to worry about that. These people are dangerous, obviously dangerous. That's the crime. With that, I urge us to adopt the Fitzgerald Amendment, and I'll yield back.
Gentleman yields back. Hearing no additional members asking to speak, the question is on the amendment. All in favor will say aye.
Aye.
All those opposed will say no. No.
No.
In the opinion of the chair, the noes have it,
Roll call.
and a roll call vote is requested. The clerk will please call the roll.
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Stimmings?
No.
Ms. Stimmings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath?
McBath votes no.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Shabbat? Mr. Shabbat?
You're muted, Mr. Shabbat. Mr. Shabbat, you need to unmute to vote.
Not unmuted.
Am I recorded?
Mr. Shabbat?
How's this recorded?
How is Mr. Shabbat recorded?
Mr. Shabbat is not recorded.
You need to unmute, Mr. Shabbat.
Steve, you're for a yes.
Aye. Shabbat votes aye. Aye.
Mr. Shabbat votes aye. Mr. Gomert?
Aye.
Mr. Gomert votes aye. Mr. Isa?
Aye.
Mr. Isa votes aye. Mr. Buck?
The question is now on the Untitled ANS as amended.
Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye.
Could members on the remote please mute if you're not speaking? Thank you.
Mr. Stubbe?
As amended. Ordering it to
Mr. Tiffany?
Tiffany, aye.
Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Bishop?
Aye.
Mr. Bishop votes aye. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz?
Benz votes aye.
Mr. Benz votes aye. Mr. Owens? Mr. Owens votes aye.
House Swallow recorded?
Mr. Swalwell, you are not recorded.
No.
Mr. Swalwell votes no.
How am I recorded?
Mr. Deutsch, you are not recorded.
No.
Mr. Deutsch votes no.
Are there additional members wishing to cast or change their votes? If not, the clerk will report.
Madam Chair, there are 14 ayes and 19 noes.
And the amendment is not agreed to. Unless there are additional, Mr. Owens, did you want, are you seeking recognition?
Yes, Madam Chair, I have an amendment at the desk.
The clerk will report the amendment, and the gentlelady from Texas, Ms. Escobar, reserves a point of order.
Thank you. This amendment would simply prohibit the Secretary from waiving inadmissibility.
The clerk needs to report the amendment first. Excuse me for interrupting.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Owens of Utah, page 14, line 20, strike 3, and insert 310C.
Thank you.
The gentleman is recognized to explain his amendment.
Thank you. This amendment would simply prohibit the Secretary from waiving inadmissibility based on international child abduction in order to give green card to a veteran who's been deported or has been ordered removed from the United States. This is a simple amendment. I have nothing but respect for our veterans and come from a long line of military service. International child abduction is a serious problem. Children are the most vulnerable among us, and individuals who are convicted of abducting a child and taking them across international borders, whether their own or others, simply do not deserve an exemption to the rule. I appreciate that individuals who serve are at risk of PTSD and other potential issues, but let's let the proper committees focus on mental health care of our veterans. I ask you to join me in supporting this amendment and stand up for justice for children and their families, especially those who suffer so much at the hands of someone who would violate their safety by kidnapping them and moving across borders. I'll yield back.
The gentlelady does not insist on her point of order because the amendment is germane, and I recognize myself in opposition to the amendment. I think it's worth noting that the exception specified in the amendment is not necessarily a criminal case, but a conduct case. These, I think many of us have been involved in some of these terrific, really, they're generally custody disputes, and they can be really very terrible. Where am I looking? I think we do need to look at this on a case-by-case basis, and I would expect that in an egregious case, the individual seeking relief would be denied that relief. But these messy custody disputes can sometimes be resolved in a way that is acceptable to the individuals who are fighting over their children, and to make the case that a person, a veteran, involved in that custody dispute would not at least have an opportunity to seek relief, I think would be mistaken, and understanding that having been involved in trying to settle some of these matters, and I think many of us have been over the years, it is a serious matter, but it is possible sometimes to satisfactorily resolve them, this issue. So I would urge no vote on the amendment, but agree with the author, Mr. Owens, that this is, in fact, a very distressing situation when it does occur.
Madam Chair, may I have a question, please?
I would certainly yield to the gentleman.
Would striking or making it, striking there's a portion that says their child, theirs or others. If it's not their child, would this then apply? If it's other children that have been abducted, not their own?
Well, you can't, with this amendment, it would not be germane to amend the Immigration and Nationality Act. It would be beyond the scope. I mean, if you incorporate a provision of the act, it was germane, but to amend the underlying statute would not be, it'd be beyond the scope of these proceedings, unfortunately.
All right, let me see if I understand then. It says whether their own or others. So if I were to strike whether their own, and just said taking them across international borders, others, taking others across international borders, simply does not deserve exemption. Would that change?
Reclaiming my time, I don't think that fixes the problem, and as you know, we have already human trafficking is already explicitly denied as an offense that would allow for application for relief. So I think what you're describing is a human trafficking situation, not a custody dispute, and that's already prohibited. So at this point, I would yield back my time and see if there are additional members wishing to be heard on the amendment. If not, then the question occurs on the amendment. All those in favor will say aye.
Aye. Aye.
All those opposed will say no. No.
No.
In the opinion of the chair, the noes have it.
Roll call.
And a roll call is requested. The clerk will please call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch?
Oh, you gotta go?
Ms. Bass?
I think
No.
Mr. Johnson,
Bass votes no.
Mr. Johnson was trying to be heard, I believe.
Yesterday, he wanted
Ms.
to
Bass
go.
votes no.
Clerk will continue.
Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu? Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal? Ms. Stimmings?
No.
Ms. Stimmings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath?
McBath votes no.
Ms. McBath votes no. Mr. Stanton?
Jayapal votes no. Oh, sorry.
No.
Mr. Stanton votes no. Ms. Dean?
Dean votes no.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert? Mr. Isa?
Aye.
Mr. Isa votes aye. Mr. Buck? Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stube? Mr. Tiffany?
Tiffany, I.
Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Bishop?
Yes.
Mr. Bishop votes yes. Ms. Fishbach? Ms. Fishbach votes yes. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes aye. Mr. Owens? Mr. Owens votes aye.
Hang on, hang on. How is Jayapal recorded?
Ms. Jayapal, you are not recorded.
Jayapal votes no.
Ms. Jayapal votes no.
Are there additional members seeking? Seeking recognition to vote or change their vote? Ms. Jackson Lee, do you wish to cast your vote? Well, I guess Ms. Jackson Lee is not here. We'll have the clerk report.
Ms. Jackson Lee, you are not recorded. Ms. Jackson Lee votes no.
It performs so well.
If a Republican member asked to be recognized now, I would do the same thing. Clerk will report.
Madam Chair, there are 13 ayes and 18 noes.
And the amendment is not agreed to. For what purposes, Mr. Johnson, seek recognition?
Madam Speaker, Madam Chairman, Madam Chair, I have a amendment at the desk. I'm sorry it's late.
Clerk will report the amendment, and Ms. Escobar reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Johnson of Louisiana. Page 8, after line 25, insert the following. 4, precluding factor. In conducting each case review under paragraph 1, the advisory committee shall consider as a factor requiring a recommendation under paragraph 1B whether the member of the armed forces, veteran, or covered family member has been convicted of 2 offenses for driving while intoxicated, including a conviction for driving while under the influence of or impaired by alcohol or drugs. Page 14, line 21, strike or. Page 14, line 24, insert or 2 convictions for driving while intoxicated, including a conviction for driving while under the influence of or impaired by alcohol or drugs before if.
The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Madam Chair. This is an important one. We've heard a lot about the bill and its intention today, but the language of this amendment is very simple, and I think it addresses a very serious problem. This is not a joke. This is a very serious problem that every member of this committee at one point or another, even in recent years, has lamented. DUI fatalities on our roadways. And as was just explained here, it simply says that we would add as a precluding factor for this advisory committee that they have to consider, they must consider as a factor requiring recommendation for removal, whether the individual involved has been convicted, not just charged, convicted of 2 offenses for driving while intoxicated. That would include under the influence of impaired by alcohol or drugs. So we've got a serial drunk driver who is involved in a matter of great import. So everybody on this committee will remember back in September last fall, we had a markup on a number of immigration bills, and I introduced several amendments that would prevent illegal alien drunk drivers from securing a green card. There was great opposition from the Democrat authors of the bills and everybody on this committee, all the Democrats on this committee, and during the discussion of my amendments, Chairman Nadler said he was fine with illegal aliens with 6 or 10 or 20 or, quote, any number of convictions for DUI, unquote, getting green cards. Let me give you a few tragic examples of illegal immigrants who were killed, who have killed American citizens in a DUI. In 2010, Carlos Martinelli Montano, an illegal alien with multiple DUI convictions, killed a nun who was on her way to a religious retreat. He was charged with yet another DUI. In 2019, Heriberto Perez Velasquez, an illegal alien and repeat immigration violator, was arrested for DUI. In 2020, Ernesto Lopez Morales, an illegal immigrant from Guatemala, killed a 5-year-old girl when he hit her with his car while driving drunk. He then fled the scene to go get more alcoholic beverages. So the question is, what is the majority going to do with this one? Surely we should agree that some people are so dangerous that they merit removal. Is the majority okay with individuals like the ones that I just addressed in those examples remaining in this country just because they were members of the armed services at one point? Remember, the veterans in question under this bill did not file for or complete their citizenship process, even though they had ample opportunity to do so immediately upon signing up for the military. I just think that there is a line over which we should not cross. And there are issues that transcend party politics. There are issues about the public safety of law-abiding citizens in this country, and this is one that I think everyone should logically agree with. So, let's go for it. Convicted of 2 or more offenses for DUI, should they be precluded or not? I yield back. Balance my time.
The point of order is withdrawn since the amendment is germane, and I will recognize myself in opposition to the amendment. No one will disagree that driving under the influence is a very serious issue, and no one wants to see individuals who are true threats to public safety get relief under this bill. The bill accomplishes that by barring applicants convicted of a serious offense and by authorizing the Secretary to deny those who pose a current threat to public safety. It's worth taking a look at the role of alcohol in the lives of our veterans and our armed forces. Alcohol abuse is a problem that is extraordinarily prevalent among veterans. Recent military studies have estimated that about 25% of service members abuse alcohol after they return from deployment. Of the veterans who enter substance abuse treatment programs, 65% report that alcohol is their primary substance of abuse. There's an increased likelihood of alcoholism among veterans, and of course, that can lead to drinking and driving, which is a terrible crime. It's been reported that veterans of Afghanistan and Iraq have a 75% higher rate of fatal accidents on the road compared to civilians, in part because of increased prevalence of drunk driving. Now, this bill takes all of that into account and would allow the Secretary to waive this when there are certain old crimes and it's appropriate. I think probably most of us know someone, either in our neighborhood or in our church or in our family, who's had an addiction to alcohol. And hopefully, some of us have seen such an individual actually recover. Recovery is possible. It's worth noting that the crimes, taking the sample of those who applied under the administrative program, of the those who asked for relief, the 60 requests, the vast majority of them are over 10 years old, and in 53, and 55 of them are over 20 years old. It is possible, and I know, and I think we probably all know individuals who had one or, if you have 2 DUIs, it's almost a certainty that you're an alcoholic. And the good news is that alcoholics can get treatment, and they can recover, and they can never do it again. And so I would, we have the tools for the Secretary to deny relief to people who are a current threat. That would be people with recent convictions or people who are not who have not recovered. But I would say this, that we should leave open the opportunity for somebody who had 2 DUI convictions 10 or 15 or 20 years ago, that they might be eligible for this discretionary relief. And that's why I think this amendment should not be approved. And I think we are thoroughly protected from those who are a current threat because of the underlying provisions in the bill. And with that, I would yield back.
Madam Chair.
Gentleman from Ohio, the ranking member is recognized.
Thank you, Madam Chair. I want to speak on the amendment. I appreciate the gentleman's amendment. And I feel like we've been down this road before. In fact, I was a few months ago, and I think the gentleman from Louisiana offered a similar amendment, and we were hoping that the Democrats had seen the light and were willing to do the right thing here, but based on the chairman's comments, it looks like that's not the case. But I would yield to the gentleman from Louisiana for further explanation on why this is so darn important.
I thank the gentleman, and it is very important. And you know, I don't disagree with much of what the chair has said. I mean, alcohol abuse is a terrible plague on society. I mean, it does affect individuals and families and whole communities, and it's a terrible thing. And we all pray for those who are adversely affected by it. Certainly, our veterans, for the tragedy and the trauma that many of them have been through. They're driven to alcohol, and that is, I completely agree, it's a terrible thing. But here's the important point. When that is taken to the roadway, it is a crime because it then jeopardizes public safety. And that's a different issue. It risks the lives of others. That is what makes it an issue of such great public concern. And of course, we cheer for the recovery of addicts. Obviously, we pray for, we help those. We believe and fully support redemption for those who are struggling with the disease of alcoholism or substance abuse. But again, that is a different issue. The question is, are we going to allow persons who have been identified, and again, convicted, not charged, convicted of multiple DUIs, at least 2 here, should not that be one of the preclusions, one of the precluding factors? I can't imagine that it's not something that we would carefully consider and add to the bill, because we have a track record of illegal aliens driving under the influence and killing law-abiding American citizens. I mean, that's enough. That should be enough. And so for that reason, I just urge my colleagues to very thoughtfully consider this amendment. I believe we ought to support it. I think it makes really good sense. I yield back to the gentleman from Ohio.
I yield back.
Gentleman yields back. Unless there are further, gentleman is recognized. Arizona.
Thank you, Madam Chair, and I appreciate this amendment, and I support the amendment. It was just a little over 8 years ago that Mesa Police Sergeant Brandon Mendoza was driving on a suburban freeway in the Phoenix metro area. He was hit head-on by an SUV driven by Raul Silva Corona. Mendoza was riding his police motorcycle. Mr. Silva Corona had a blood alcohol content of 0.238. 0.238. Just about 3 times the legal limit. He is also high on methamphetamine. 10 years ago, the number of people who were killed by drunk drivers exceeded 10,000. 6 years ago, it was about the same, over 10,000. I appreciate, I'm not suggesting in any way that anyone in this committee doesn't appreciate the gravity and seriousness of driving while impaired due to alcohol, DUIs. Data from CDC, estimates by CDC is that before somebody is ever even caught for DUI, they have driven impaired multiple times. And what I think the gentleman from Louisiana is suggesting by this is, at least what my takeaway is, two convictions for a very serious offense like driving under the influence indicates that that person, as the chair has said, probably has an alcohol problem. And quite frankly, we should not be facilitating that dangerous habit. And I again have to go through this litany that I keep going through. The current state of the law says a non-citizen serving the military gains status. But the bill is focusing on criminal activity, people who've been convicted of crimes. This amendment is focusing on individuals who've been convicted of 2 DUIs. Seems to me that is has a certain imperative when we see that. And with that, I would say this, like so many of the other amendments offered today, this should be supported. I would hope it would be supported and adopted. And with that, I'm going to yield. Do you need to yield back to the chair?
Gentleman yields back, unless there's further requests for time, and I see none. The question is on the amendment. All those in favor will say aye.
Aye.
All those opposed will say no. No. In the opinion of the chair, the noes have it.
Recorded vote.
A recorded vote has been requested. The clerk will please call the roll.
Mr. Nadler? Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee?
No.
Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia?
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch? Ms. Bass?
No.
Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Raskin?
No.
Mr. Raskin votes no. Ms. Jayapal?
No.
Ms. Jayapal votes no. Ms. Dimmings?
No.
Ms. Dimmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath?
McBath votes no.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
Dean votes no.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert? Mr. Isa?
Aye.
Mr. Isa votes aye. Mr. Buck? Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Stubbe? Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Bishop?
I'm on my way back from the night shift. I vote aye.
Mr. Bishop votes aye. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes aye. Mr. Owens? Mr. Owens votes aye.
Nadler votes aye. Votes no.
Mr. Nadler votes no. Mr. Swalwell, you are not recorded.
No.
Mr. Swalwell votes no.
Is that Mr. Gomert? You need to unmute to vote, Mr. Gomert. We can't hear you, Mr. Gomert. How's Mr. Raskin?
Mr. Raskin is recorded as no.
Votes aye.
Mr. Gomert votes aye.
There we go. I think
Raskin is a no.
Mr. Raskin votes no.
Does any other member seek to vote or to change their vote? If not, the clerk will please report.
Madam Chair, there are 14 ayes and 18 noes.
And the amendment is not agreed to. Mr. Johnson, do you have an amendment?
I do, Madam Chair. I have an amendment at the desk.
Clerk will report, and Ms. Escobar reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Johnson of Louisiana. Page 8, after line 25, insert the following. 4, precluding factor. In conducting each case review under paragraph 1, the advisory committee shall consider as a factor requiring a recommendation under paragraph 1B whether the member of the armed forces, veteran, or covered family member has been convicted of 5 offenses for driving while intoxicated, including a conviction for driving while under...
I ask unanimous consent that the amendment be considered as read, and the gentleman from Louisiana is recognized for 5 minutes. On behalf of his amendment, and the gentlelady from Texas withdraws her point of order.
Thank you, Madam Chair, and we're right to dispense with the reading. This is exactly an identical amendment to the one we just discussed, except for the change in line 6. And we are going to change that to a person who has been convicted of 5 offenses for driving while intoxicated. Now, let me do just a reset quickly here, because I think we're in a late hour of this hearing, and many people may have lost sight of the underlying bill and what we're doing here. H.R. 7946 is the Democrats' latest attempt to target sympathetic populations to slowly erode enforcement of U.S. immigration laws. H.R. 7946 continues this effort by focusing on persons in this bill who have served at some point in the military. So here's what it does. The bill establishes a bureaucratic advisory committee filled with members appointed by DHS Secretary Mayorkas. They have input on whether an alien who served or has served in the U.S. military at some point, or their alien spouse or child, should be removed from the country pursuant to our plain, well-written immigration law. Except that under this bill, Secretary Mayorkas would have the authority to prevent that removal of the alien, maybe who served in the military decades ago, but who would otherwise be removable under the law based on convictions for serious crimes, and that would include a DUI, or trafficking in firearms or explosive devices, or any of the other issues that we've talked about today, the other crimes. Congress should be focused on pressuring this administration to enforce our U.S. immigration laws, to secure our border, to ensure the safety and sovereignty and security of our nation and its people, and make U.S. immigration system, make that system work on behalf of law-abiding citizens. But instead, the Democrats on this committee are wasting time considering bills that do nothing to secure the border. In fact, as in this case, they make the situation much more dangerous because they would reward persons who have broken our laws and exacerbate the Biden border crisis. So in rejecting my previous amendment that I brought, opposing my previous amendment, the chair said, and I would quote you, Madam Chair, I mean, you said, I oppose this amendment because, quote, 2 DUI convictions, 10 or 15 or maybe 20 years ago, unquote, should not be a precluding factor. So not just to illustrate the absurdity of where this might go, but really to determine if there is any end to the insatiable appetite to water down our immigration laws. I wonder if 5 convictions for DUI offenses might be enough. Simply put, that's what the amendment does. So with that, I yield back the remainder of my time, and I hope and urge that my colleagues will support this common sense amendment.
Gentleman yields back. I recognize myself in opposition to the amendment. And I noticed earlier that the point of order had been withdrawn. Just taking a look at the data that we got from DHS for those who've applied for administrative relief, I think it's worth noting that 40 of them are over 60, 70 are between the years 70 and 79 years old, and the age of the criminal conviction, more than half are more than 20 years old. As I said with the prior amendment, if you have multiple DUI convictions, 2 or certainly 5, you're an alcoholic. You got a serious problem. And we know that there are many veterans who do have a serious problem with alcohol. As I mentioned in the prior amendment, the good news is that alcoholics can actually recover and stop abusing alcohol and stop being a threat to others. So if you had 1, 2, or yes, even 5 convictions 20 years ago, and you're no longer an alcoholic, and you're 79 years old, I don't think that's a current threat to the United States. At least you ought to have the opportunity to have your case reviewed. We have ample opportunity for the Secretary to deny any application if there's a current threat to the public safety, which would be the case if you had someone who had not recovered. So I think the possibility for recovery for alcoholics, if there's an old conviction, I think at least that case, if they're a veteran, should at least be reviewed by the Secretary. And with that,
Would the gentlelady yield?
I would be happy to yield.
I hear you, and I know your heart, and I believe that you operate in good faith. I respect you as a legislator, but respectfully, I would say that the argument you're making in opposition really doesn't, in this case, just doesn't make a lot of sense. We believe in compassion and redemption and recovery for those persons who have this disease of addiction to alcohol and substance and abuse and the rest. But here's the thing: you just said in this case, more than half the convictions are more than 20 years old, and you said, if somebody's 79 years old and they were convicted of 5 DUIs 20 years ago, they should be given special attention, or they should not be automatically precluded. But what if the convicted criminal is not 79 years old? What if they're 29 years old? What if it happened last year and not 20 years ago? I mean, that's a realistic application of the law. So maybe
Reclaiming my time.
Sure.
This is, the bill structure allows for a case-by-case review. And that's the whole point, that if you've got someone who got 5 DUIs last year, that person is not going to get the benefit. But if
How do we know? How do we know?
Because we have, the Secretary is charged with making sure that someone who is a threat to the public safety is not granted relief. So I realize that, members on the other side of the aisle have expressed concern that, or actually lack of confidence in the Secretary of Homeland Security. I would point out that a very large percentage of those who've applied under the administrative procedure have been denied. So the idea that there's going to be some automatic approval is not supported by the evidence accumulated to date. I do know, honestly, if you want to talk about 5 DUIs or 3 DUIs or 1, if you've got multiple DUIs, I think someone said probably you've been driving drunk before you got caught. I think that's definitely the case. You got 5 DUIs. It's really, it could have been 10 times that you were driving drunk, but the cop was only there for 5 of those offenses. This is an alcoholic, someone who's got a problem and who's a threat if they're in a car until they get recovery, until they get that past them. And I just think if someone recovers and through God's grace can find a way forward free of the disease of alcoholism and not pose a threat, the conviction was a long time ago, at least they ought to have a chance to have their case considered. You and I may disagree, but I don't think this is irrational. And with that, I yield back.
Madam Chairman.
I think Mr. Shabbat is next, and then Mr. McClintock. Mr. Shabbat.
Thank you. Move to strike last word.
The gentleman's recognized.
Thank you, Madam Chair. What the chairman has just said here today is that we should trust the Secretary of Homeland Security to make the call on this. Well, I certainly don't trust this Secretary of Homeland Security to make the call on this or virtually anything else. This is the same Secretary of Homeland Security that said that they've got the border under control. That's right. I mean, that is just laughable. It would be laughable if it wasn't such a serious matter, because we got folks streaming across that border, some of them getting killed, drowning in the Rio Grande, or getting here into this country. A minority, not the majority, commit crimes, but some do, and American citizens, for the most part, are going to be the victims of those crimes, whether they're property crimes or whether they're crimes to the person, such as assault or rape, or in some cases, unfortunately, even murder. So that's what we're talking about, is trusting this Homeland Security Secretary, who has shown time and time again that he cannot be trusted or even believed. That's the person that we're trusting. And the gentleman from Louisiana offered a perfectly legitimate amendment, saying not just if this person has a DUI that they ought to not be able to stay in this country, but 2 DUIs. The Democrats, to a person, voted that down. They said, no, 2 DUIs is just fine. So the gentleman from Louisiana said, okay, how about 5? I mean, think of that, 5 DUIs, 5. Now, statistics will show, and I practiced law for quite some time and know this area pretty well. And if a person is convicted of a DUI, statistics will show you that they've actually driven while under the influence of alcohol and putting at risk the public probably dozens of times. That's for each one of those times. But we're talking about 5 times. Now, the Democrats say, well, that's okay. We'll let those folks stay in this country and not be deported. That's just nuts. So many people in this country over the years have been injured, maimed, killed by DUI drivers. I mean, it's horrific if it's an American citizen that does that. But we're talking about people that came here illegally and allowing them to stay and not be deported, even though they've committed crimes. I mean, it's just absolutely incredible. I mean, think you can be driving down a highway in your own town or on one of the streets. You got the kids in the back of the car. Everybody's minding their own business. You got the music on. You're thinking about what you're going to have for dinner or whatever it might be. And you've got some person who's blasted out of their mind because they've drank incredible amounts of alcohol sometimes. When somebody really is addicted to alcohol, it's incredible how high the alcohol content in that person can be in their blood or in a breathalyzer test or an toxicologizer, whichever one that particular state uses. But you're driving down the road, you got this person who's just blasted out of their mind and either falls asleep or doesn't pay attention. They come across the center line. If you're alone, they take you out, and that's it. But oftentimes it's an entire family. And if they're not killed, they're maimed for life. And to say that, well, we're going to take that risk with your family, with people that have multiple DUIs that came into this country illegally, 5 DUIs, and the Democrats are saying, that's just fine. That's okay. That's okay with us. Because we trust Mayorkas, the head of the Homeland Security Department, the guy that says, hey, we got the border under control. Everything's fine. Nobody's coming in. Look the other way. You know, don't believe your lying eyes. We got it under control. We know what chaos it is down there, but we're going to trust this guy that his decision to let folks come in here and maybe take out your whole family. It's just unconscionable. We all ought to vote for this gentleman's amendment. 5 DUIs, just remember that. Those that vote yes say absolutely not. You know, it ought to be 2, but 5, of course. But the Democrats, let's see how they vote this next time. They said 2 is enough. Let's see if 5 is too many for them. We'll see. And I yield back.
Gentleman yields back. For what purpose does the gentleman from California seek recognition?
Move to strike the last word. Oh, the other gentleman.
The other gentleman.
There are so many gentlemen from the great state of California.
Mr. Correa.
I would yield to the other gentleman from California.
Thank you, the chairman and the gentleman from California. I just wanted to, as I listened to my colleagues debate this amendment in this bill, I also wanted to remind people who and what we're talking about today. We're not talking about undocumented serving in our nation. We're talking about legal residents that have served our country honorably, have been honorably discharged, and for whatever reason have gotten in trouble with the law, and because of those convictions have essentially lost the ability to live in the country that they've known as their home, to live in the country they have fought for on numerous occasions, but because of that conviction, they are deported. Essentially, this bill says, give a case-by-case review, look at the facts, because as my colleagues have said, what ifs, what ifs. The world is full of what ifs, and that's why you have essentially discretion here to determine whether an individual that committed a crime, spent time in jail, once he got out of jail, paid a second price, which is the loss of the ability to legally live in this country. This is what this legislation is about. We keep talking about the border, we keep talking about many what ifs, but this is about dealing with soldiers that have been honorably discharged, have served this nation honorably, and have lost the ability to stay in this nation. That's what the issue is about. We're not saying they should or should not stay based on the severity of the crime, but rather give them discretion, give judicial discretion here to determine whether they should stay or not. It's interesting, Mr. Chair and members, that these individuals at present can only return to the United States once they die, because having served and having been honorably discharged, they have earned the opportunity to be buried in a national cemetery where veterans are buried.
Will the gentleman yield for a question?
No, I will not. So at the end of their life, they are deported, but they can return once they're gone. And again, this is not the way we treat our soldiers. If this was an issue specifically about veterans, but actually this is an issue dealing with veterans. And we're talking about veterans that have been deported because they have been convicted. It's not automatic. We're not talking about automatic readmission to the United States. We're talking about a case-by-case determination whether these individuals should have stayed or not. I'm reminded again of a gentleman, a young man, 21-year-old in my district, Jose Angel Garibay. He was the first casualty, a Marine, out of Orange County in the Iraq War. A dreamer, lost his life in defense of this great nation. And once he lost his life, thank goodness Congress saw it fit to bestow upon him posthumously American citizenship. Those are the kinds of individuals we're talking about today. People that served with honor, served with bravery, pledged allegiance to the flag of the United States, pledged allegiance to this great country, pledged allegiance to this country above and beyond any other nation, including that where they might have been born. Mr. Chairman, I yield. Thank you very much.
Chairman yields back. For what purpose does the other gentleman from California, or one of the other gentlemen from California, seek recognition?
One of the so many gentlemen and ladies from California moved to strike the last word.
Gentleman is recognized.
Thank you. I yield time to my colleague from Louisiana.
Thank you. I have great respect for my colleague, Mr. Correa, but I'm not sure that's exactly what the bill says. It's not just honorably discharged veterans. It is those who have not dishonorably discharged, not been dishonorably discharged. In other words, there are other categories. There are, as we talked about earlier in the day, this includes other than honorable discharge for security violations, use of violence, conviction by a civilian court with a sentence including prison time, being found guilty of various things. So I'm not diminishing in any way what you said, and understand your heart, and of course we honor our veterans. We spend all of our time on this side talking about that, how important that is. I mean, I agree with you 100%. The question with this amendment,
Gentleman,
asks,
yield.
in just a moment, but just let's focus on what this specific issue is. All we're saying is there any limit at all on one who should be given this special consideration. I mean, 5 convictions, as everybody acknowledges, that means somebody is driving around drunk a lot, often, and putting the lives of people, like in your state and mine, in jeopardy. So is there any limit to the insatiable appetite here for just allowing everybody to be in? And we, as said, we do not trust the Secretary. I yield back to the gentleman from California.
Thank you. And I'm going to add on to this a couple of short thoughts. My good friend from California, Mr. Correa, and we are good friends, made some factual errors here when he talked about those who had fought for our country, those who served honorably. As Ms. Johnson said, that's not what the bill says.
Will you yield, sir?
I will in just a moment. The bill has not been written in a way that it passes what I would call the Chevron test. The test that, given this to not just this secretary, but to all future secretaries, that the discretion is tight enough that the intent be recognized. If the intent of this bill is that those who have served honorably shall be considered if they have not committed violent offenses, if they are not a current risk, then work with us to rewrite this, as we've been trying to do all day, to say that. But each and every amendment, including this particular one, has been shot down, and it's clear from the gentlelady who was chairing at the time that if we were to offer an amendment for, let's say, 10 DUIs, it would simply emphasize that now you're a drug addict, you're an alcoholic, therefore you should get special dispensation. So, to be honest, would the Menendez brothers, I'm sorry, it was Menendez, they killed their parents, would they be able to claim orphans if they were being deported?
Gentleman yield.
Would the gentleman yield?
And I only say that if not this, are there any exceptions
Menendez veterans?
to bad conduct? Okay? Bad conduct, if you are not a native-born citizen, can get you deported. The mafia were deported after their sentences, even if they served in the military. But in this case, we're talking about people who did not necessarily serve honorably and have now committed multiple violations. And I would only ask, and I'll yield you time, I would only ask, if this is not good enough, are you willing to work to set some limits of what is good enough, or shall it be essentially trust for every administration in perpetuity? And I'd yield to the gentleman.
Thank you. And my good friend from California, if we're talking about intent here, sir, we need to go down to Tijuana and visit that center with the deported veterans so we can talk to some of those individuals that have been deported, look at them in their different circumstances, which calls out a case-by-case examination of the facts.
And reclaiming my time for just a moment, normally we do this kind of legislation after we've had private bills that have repeatedly found valid exceptions, and then we write into the law those exceptions so they not have to be private bills. We're not doing that. I would more than willing to find that honorably discharged individual who is not a current threat and work with the gentleman on a private bill.
Gentlemen, yield.
I
The
of course
last
yield.
10 seconds, I would say, I'd like to invite you to come with me to Tijuana, south of the border, and talk to some of those individuals so we can get a flavor of what this bill is trying to address.
Representing 88 miles of the border, I will be happy when you come down to my border anytime.
Buy you lunch in Tijuana, thank you.
Deal.
Gentleman's
Go back.
time has expired. Who seeks recognition? For what purposes does Mr. McClintock seek recognition?
To speak on the amendment.
Gentleman is recognized.
Thank you. Mr. Chairman, first of all, just to address the question, whether we should go and talk to these veterans who've committed crimes, maybe we also ought to go talk to their victims. Oh, that's right. You just voted against that. We can't talk to the victims. Wow. I think Mr. Shabbat's right. The current DHS secretary has repeatedly and brazenly abused his authority by granting blanket paroles, by making sweeping claims of prosecutorial discretion,
He's repeatedly and brazenly told us that the border is secure. When we're told, oh, you should trust his discretion on these issues, do you realize how absurd that sounds to those who have watched him abuse his authority from the very day he took office? You know, in a sense, I think this is a microcosm of the larger policy debate that the left has imposed on our major cities. This complete focus on the lawbreaker and this complete lack of concern for that lawbreaker's law-abiding victims.
Yes.
You know, they keep telling us that criminals can be rehabilitated if we just forgive them, forget them, stop enforcing our laws, give them a second, third, fourth chance, and a few of them do rehabilitate. But the odds are against it. Most of them don't. And the victim tally in our cities that are being run by the left is now skyrocketing as a result. Yes, these are veterans that pledged allegiance to our Constitution, to protect our people. These are also veterans who broke that pledge by committing crimes against our country and preying on the very citizens that they were supposed to protect. You know, I think people are getting a little sick and tired of the attitude of the left and the impact that that's having on our society. We can watch it tearing our cities apart. We can watch it victimizing law-abiding citizens throughout the country. I think people are getting a belly full of this nonsense, and I think you're going to find that out very clearly in the upcoming election. I yield back.
Would you yield to?
I'll yield to Mr. Tiffany.
Thank you. Thank you very much. So let me give you an what if. Let's say somebody has a 5th DUI. Secretary Mayorkas brings them into this country at discretion, and they commit a 6th DUI, and they kill a family. That's a what if also. They kill another family. And you talk about discretion. If this secretary was using his discretion, he'd understand that the 100,000 drug poisonings that have went on now in America is unacceptable. And you wonder why. It repeats the point that the gentleman from California just made. We don't trust them. You want to give all this discretion to an agency. First of all, we disagree with that to begin with. You should write a more precise bill. And the second thing is you're giving it to the secretary who the Border Patrol is telling the American people he's lying to you. And if anybody would know, it's them. And by the way, this is the administration that wanted to take dollars from veterans' resources and move it to the border. They wanted to serve people coming into our country illegally and take it out of veterans' services. And they only stopped when it became public. That's when they stopped, is when it became public. This bill is not thought out well at all. And the person that you think is going to enforce this in a responsible manner, the American people do not trust him for good reasons. I yield to the gentleman from California.
The gentleman yields back who seeks recognition. For what purposes does Mr. Ben seek recognition?
Strike the last word.
Gentleman is recognized.
Thank you, Mr. Chair. So the part of the bill that is of greatest interest to me is the part that the amendment applies to. I'm going to talk about it in general and looking at the case review portion of the bill. And it's extraordinarily interesting if you read it carefully, and I have, the bias reflected in the language. The bias is of the procedure set forth is to assure that whoever applies will receive the types of reliefs set forth under sub C1A. And that would be termination of removal proceedings, parole, deferred action, stay of removal, administrative closure or authorization to apply for any other form of relief. The reason it's set up this way is if you follow on to the next page, you'll see that the procedures say nothing about who's going to come up with the reasons why the person shouldn't get the relief. Nothing. All it does is list all of the things you should show up with to get the relief. One would wonder who it is that's going to defend the United States of America in trying to determine who should get the relief. Nobody is set forth here as to come into the other side and say, you know, maybe this person has 5 DUIs, or maybe this person has done other bad things. And by the way, the constant reference to veteran, well, hooray for that, except if you got to go right below the word, it says a covered family member. That would be the spouse or the child or children. So why do we keep referencing back to this person who indeed may have earned the bias, at least a part of it, and ignore the rest of the family? And why, when this was it written so clearly to achieve the outcome of having every veteran who happens to not be a citizen admitted into the country without further review? Why? And the answer goes because it's a bias bill, and to quote Mr. Tiffany, it's poorly thought out and poorly constructed. At the very least, the bill should, and these amendments that we've been hearing have been trying to put some sort of sidebars into the bill, because there sure aren't any in it now. And so the question becomes, why not? And the answer is because it's a device to allow everybody who happens to fit into the veteran or covered family member or member of the military service space into the country without further review. It's amazing. And I want to make sure before I leave this issue, because I think it's super important, that we look carefully at what it is that the covered family member has to do. They have to show that they supported a member of the armed forces, including through financial support, emotional support, or caregiving. Well, what's emotional support? Going to, sharing Christmas? I mean, what is it? Or contributed to his or her local community during or after the military service of the member or veteran. What kind of standards are those? The answer is they are none. And so if we want this bill to actually work in a way that protects the United States from those that we don't want as citizens, please, let's look at these amendments that we've been hearing and actually give them some thought. And by the way, as why I still have have a minute left, I note in the amendment, just to speak to it for a moment, that we're debating, it reads, in conducting each case review under the paragraph 1, the advisory committee shall consider, and you probably have spoken about this when I was not here earlier, since I was attending another markup. You may have noted that the advisory committee shall consider. It doesn't say shall decide. It doesn't say shall immediately determine. It says shall consider. So I do not understand why people are saying that to add the 5 offenses would immediately disqualify the person. Perhaps I haven't read the bill carefully enough, and I haven't been benefited by the 4 or 5 or 6 or 8 hours of previous debate. But it seems to me that since the word is consider, it would be a good idea to consider 5 offenses. Maybe indeed they have recovered, and maybe they have not. But at the very least, should recover. We should consider these types of difficulties, and also at the very least, this bill should be even further amended to at least put someone in charge of defending the interests of the United States. With that, Mr. Chair, I yield back.
Gentleman yields back to who seeks recognition.
I do.
In case nobody seeks recognition.
I do.
For what purpose does the gentleman seek recognition?
To speak on the amendment.
Gentleman is recognized.
I've returned for the second shift. Spouses put up with a lot. Members in Congress, my wife's in town this week, and I went away and got dinner with her and participated and listened into the debate that's occurred on this amendment, of which there have been a number of amendments proposed on this bill, all of which I think, with save one, accepted by unanimous consent, have been rejected. And the first thing that I note is the notion that I could be in a restaurant and participate in this hearing is a ridiculous idea, and I look forward to the day when this is gone and we debate bills here and amendments here in this committee or not at all. But there is one perspective that becomes clear stepping away from this room and listening in to the debate. And that is one, it's almost like being an American watching this committee, if you were forced to, if you had some punishment maybe administered by a judge for some, local crime that you needed to do community service for, so you had to watch. And you would watch and you would actually come to the conclusion that the Judiciary Committee of the House of Representatives is actually poised to reject the idea that someone with 5 convictions for driving intoxicated should be barred from special consideration to return to the United States after being deported. I have that right. Is that basically right? I know I've been a little absent. I apologize. But that's where we are. And I think being absent from the committee, at least in physical presence for a time, and listening to that, it also occurs to me to wonder, whose water is being carried here? What is this about? This is crazy. But that is an accurate picture of where we are under this leadership in Congress. That is where we are. There is you cannot put up an amendment in which the criminal offense is so remarkable or the victimization so heart-rending that the majority will pause to say, you're right, we can't go that far. They will not do it. And that tells you what you need to know. This bill is either about messaging, but it's not a very good job of that, or it's about carrying someone's water. Someone in particular is in mind of the committee, of the majority, in pursuing this bill, because they have shown no reticence at all about disregarding actively serving military members or veterans in any of a number of respects. And they will not accept any, to use the term employed by Mr. Bentz, any guardrails, any limitations on whom they consider appropriate to furnish special consideration to return to the United States or avoid deportation when they leave. And the one thing that has sort of popped in my mind a number of times is the Attorney General, the Democrat Attorney General over recent days saying no one is above the law. No one is above the law. But they seek to give an exemption from the law to anyone who is not a citizen of the United States who has served in the United States military. That's it. You're above the law if you've done that. That's where we are. That's what they propose. And they can pass it because they got the numbers right now. But it's not going to be the case for long. And all this is going away. And the ridiculous ideas are going away. And we can return order and law and the principle that indeed no one is above the law. The law applies equally to everyone. No more dual standard of justice. No more politicized justice. Law and order. And it is high time for that, and I yield back.
Gentleman yields back. For what purpose does the gentleman from Georgia seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you. I rise in opposition to this amendment to very common sense legislation where Democrats are putting people over politics, trying to get something done for those brave men and women, immigrants, who came to our country. They loved it so much that they signed up to defend the country in our military, and they served oftentimes with distinction, only to come home and catch a DUI, as my young people like to say, and when they catch that DUI, they become excluded. It interrupts the home, takes them away from their children. It's not funny. It's really quite tragic. And so this legislation seeks to bring some compassion and some mercy into our immigration proceedings when it comes to these brave men and women who have given of themselves to our military. And having done so, they really deserve to be treated with respect and dignity, the same way we would treat our fellow Americans. And but instead, tonight, what we have is immigrant bashing. Basically, Latina and Latino bashing. We don't have any Latinos on the other side of the aisle, so I guess it's easy to bash. When I look amongst my brothers and sisters on this side of the aisle, I can't see anything but Latinos and Latinas, black folks and women. And so we know we know how it feels.
Would the gentleman yield? This is outrageous.
I'm not
This
finished.
has nothing to do with race.
The gentleman.
Nothing to do with race.
The gentleman from Georgia has the time, and he has not yielded.
And yes, this is a charade that has been conducted by my friends on the other side of the aisle. We see them looking over here on the camera as if they're looking at us, but they're actually looking at the camera, and they're performing for the camera.
Will the gentleman yield?
Because they believe that
Will the gentleman yield?
they believe that their fellow MAGA Republicans are just eating this up, and this is
Your argument's going to tip over.
this is great food for my MAGA Republican loving people out there who are watching this. I mean, they're eating it up. But people in America who want us to put people over politics, want us to go to work, making sure that we lower cost for Americans. We can't do that because the MAGA Republicans won't go along with it in the Senate, aided and abetted by these MAGA Republicans here in the House. We want to do something to continue to create better paying jobs for Americans. They resist and obstruct safe communities. We passed gun reform legislation here. They oppose that with ridiculous amendments that they tendered that kept us here half the night, which is what they're going to do tonight. You know, and instead, what their program is, they want to criminalize women's health care. This is what the MAGA Republican crowd wants to do as they shoot arrows at us as we put people over politics. They want to end Social Security as we know it. And they want to foment continued attacks on our democracy. It's very serious business what we're doing here, and I think the American people see through this continuing parade of ridiculous amendments that are keeping us here on this very common sense bill. If you don't like the bill, just vote against it. We'll understand, but there's no need to keep us here with these amendments that the American people can look at and see that each amendment becomes more ridiculous than the previous one. So I think people have gotten tired and they've cut the TV off, so it's time to stop performing. Let's go ahead and get down to business and pass this legislation, and with that,
Mr. Chairman.
I'll yield back.
Mr. Chairman.
Gentleman yields back. For what
Mr.
purpose?
Chairman.
What
Mr.
purpose does
Chairman.
Mr. Buck seek recognition?
Move to strike last word.
Gentleman's recognized.
Oh, my goodness. The party that wants to defund the police is now talking to us about being unreasonable, about grandstanding, about fermenting. I think you meant fomenting, but you said fermenting. We might as well go with fermenting.
I corrected myself.
Oh, okay. All right. Well, it stinks like it's fermenting. It might be fomenting. I'm not sure which. The party that's responsible for the gas prices that we see at the pump is telling me about grandstanding. Let me think. Oh, yeah, meat prices have gone up. I'm grandstanding. The border is wide open, and we have an administration official telling us it's secure. All of America is united in laughing about that. Crime rates throughout the country have gone up. And this bill is allowing people who have committed crimes to come into the country. The crime rate's not high enough. You now need to outsource and import some more crime. 5 DUIs. That's like the Harvard of DUIs right there. You can't achieve that in kindergarten. You got it. Yeah, that's a graduate degree of DUIs, and you're opposed to it. I'd like to ask any member on the other side, what would be the number that you would say enough is enough? 12? 20? How many DUIs does somebody get before they don't get special privileges from the Democrat Party to come into this country? I'd just like to know a number. And maybe it could be a round number. Let's go in tens, 10, 20, 30, 40. You can't give me a number. This number 5 was picked because it's an outrageous number. There are very few people who survive 5 DUIs. But my friends on the other side of the aisle who are defunding the police, who are spending all their time criticizing the party, the grand old party. You know, you talk about MAGA. I have to tell you, the country was a lot better off with MAGA than it is with a president of the United States who can't even get off a bicycle without falling. I think we're pretty good. And the American people will make that decision in November, again. And I agree with my friends who want to do away with this nonsense of proxy voting on the floor and remote voting in committee, and it's time we face each other. I appreciate the gentleman's comments about how we're grandstanding here. We're grandstanding because the grand old party actually got something done when we were in power. We gave people back their money so they could spend their own money with a tax break. We deregulated the economy. And by the way, that lifted all boats, not just some boats. You want to talk about racism? How much money went to historically black colleges in the Trump administration compared to the Obama administration? Let's talk about racism. But no, you rather talk about giving criminals access to the United States because we just haven't created enough victims yet. We want to create more victims. I've gone to a lot of scenes of drunk driving accidents. I have grieved with families of victims from drunk driving accidents. This bill, this amendment, is an absolutely reasonable and necessary part of what we should be doing. The survivor of those 5 DUIs is lucky, because there are so many people in this country who have not survived the traffic accident from a DUI. This is crime prevention. I understand the party of defunding the police doesn't appreciate crime prevention, but this is crime prevention. And to ignore this and to minimize this amendment is so unfortunate. But I stand with my fellow grandstanders over here. I proudly believe that enough is enough. If you can't accept 5 DUIs, let's have that debate on the floor of the House, and let's see just how many Republicans join you in an effort. I understand you've got a weak record on veterans. You're not going to make up for it with this bill, and I yield back.
Yes.
Gentleman yields back. For what purpose does Mr. Owens seek recognition.
Strike the last word, please.
Gentleman is recognized.
Boy, I don't know really where to start on this one, to be honest with you. We're talking about crime. We're talking about pain of millions of people across our country. We're right now talking about drunk driving that's killing people, hurting our neighbors, our friends, and for some reason, my friend across the aisle decided to bring race into it. You know, this is the problem we've had, my race, for decades. With all due respect, it's called elitism. It's people who see other people in misery and don't get it. It's people who use misery as a political strategy. We have people across our country miserable. And we're here to talk about how to alleviate some of that. And out of that comes MAGA and race. My growing up, my definition of racism were those who looked at race first. Those who looked at outside in versus inside out. And the statements made earlier to me is, with all due respect, racist. And I don't care the color of those speaking it. We start looking at each other based on our color, and not based on getting solutions done. It's racism. And I tell you, American people are getting sick of this. We're sick and tired of divisiveness. We're sick and tired of every single city that's run by my party, my friends across the aisle, is a place where misery is highest, crime is highest, murder is highest, education is lowest, families are destroyed, and there's no sense of accountability. Instead of pointing a finger, let's look at some of these policies. This is a good example of one right now. We're trying to say 2 DUIs or 5 DUIs is too much to bring people like that back into the country to do more misery. That's what we're trying to say. It has nothing to do with race. It has to do with what they're doing, the action. And I think at some point there has to be some sense of no shame. You can't continue to say these kind of things and think it's okay. My friends, listen, I can't say enough. I would appreciate what we'll say a little earlier. You know, this is like Twilight Zone, some of the things we're going through right now. I mean, we're grown adults, we're responsible people. Come on, we need to be able to do some of this stuff where it's not total politics. This should be a no-brainer. And yet, here we are, saying that 5 DUIs is too much for the person who's culpable of this. We need to give them a break. Well, let me tell you this. American people across the country are tired of giving criminals a break. We want justice, we want fairness, and we want to live in a place where we don't feel fear every single time we walk out our door. And if you're not feeling that, that means there's a little bit of lack of empathy. Too many people are feeling that right now. I want to give my time to.
I thank the gentleman for yielding. I just want to pick up on, and I appreciate so much what he said, and the gentleman from Colorado earlier. But I want to pick up on something that the gentleman from Georgia said. He said, we need, and this is a direct quote, we need to bring compassion and mercy into our immigration system. Well, someone needs to tell President Biden and Secretary Mayorkas that, because their policies are creating so much misery for the people that the cartels are exploiting and bringing to our border and then moving into our country. We're all for compassion and mercy when it comes to what's happening, particularly to women and children on that journey. Everyone knows they don't get here but for the cartels who are exploiting them, making tons of money, not to mention what they're doing with the drug trade, bringing that into our country and our communities, and we all know people who've been impacted by that. So if we want to talk about compassion and mercy, someone better tell Joe Biden and Secretary Mayorkas, start thinking about that with your crazy policies, because they are harming people. And everyone knows that. And why you guys won't help us deal with that, I do not know. I yield back to the gentleman.
Would the gentleman yield?
Yes, go ahead. Yes, I yield.
I just had a chance to talk to Mr. Johnson of Louisiana, and I have a suggestion that might bring us together, and I think Mr. Johnson agrees, that we add on line 9 unless the convictions were, how did we say it, Mike? Are older than 25 years old.
And would you yield for a moment?
Yes.
So the idea would be to balance justice and mercy, which is, by the way, what Scripture calls us to do. And so that this is not recent convictions, but it covers your scenario where, you know, you've got a 79-year-old who had a problem many years ago, but he's redeemed himself. And all. If there's a reasonable limit, then that makes some sense. But the problem still is with the discretion that is provided to the Secretary that we don't trust.
I understand that, but we might be able to dispense with this if we, through unanimous consent, added unless the convictions are older than 25 years old, and then we accept the amendment.
I'm trying to think through the language and make sure that.
And also on the line 14, both parts.
And so how many DUI convictions are we bargaining for here? Is it 5?
Well, we're taking your amendment and saying, but if the convictions are more than 25 years old,
Okay. What number of convictions? Any 2?
well, it's the 5 that you've got in this amendment.
Okay.
And we are going to, I mean, this is the amendment before us, and you know, let's do this. Can we do this, Mr. Johnson?
Well, it needs to be 2, though, if we're going to exert this, right? I was going to bring the amendment for 30 and really test everybody tonight. I really was. It's prepared, so I mean.
Well, I guess the question is, we should have AA here to give us advice on what is.
No, we should have district attorneys here
Well,
to give us.
but also in terms of recovery. And what I have been told, and I do not claim to be an expert, but for those people who I personally know who have beaten alcoholism, if you know, you get a gold coin at your 5-year period, and you think, you know, in most cases, you're not going to relapse if you've got your 5 years in, but if you had 5, you know, we want to be even more cautious than that. So I'm just trying to find some common ground here that would be sensible.
I mean, look, I like the spirit of it. It does, you know, put an end to the absurdity of the position that everyone is being backed into over there, and it, you know, maybe that's reasonable. So I would concede that. All my colleagues have to make their own decision on it, but that's acceptable to me.
Well, if we can rewrite this in rather than try and do it verbally,
Okay.
we'll temporarily withdraw. We'll have the staff
I'll agree
write
to do
this
that.
up, and the 2 staffs can talk, make sure that it reflects the discussion that we've just had, and
Very good.
all right,
I agree to withdraw.
temporarily.
Amendment is withdrawn temporarily. Who seeks recognition?
Mr. Chairman.
For what purpose does Mr. Issa seek
I
recognition?
have an amendment at the desk.
Clerk will report the amendment.
I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Issa. Page 20.
Without objection, the amendment will be considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. As an twice honorably discharged veteran, I hold a great deal of credence beyond for an honorable discharge. But as someone who served as an officer adjudicating men and women who broke that promise, who were punished under UCMJ, some of whom were discharged administratively and some of whom were discharged because of the court-martial process, I am all too aware that bad conduct discharges and even general discharges represent a less than honorable service during the modern times. For that reason, my amendment simply raises the bar for these individuals to those who have been honorably discharged. The term veteran, and I want to briefly, I'll ask unanimous consent to place into the record from the .mil website veterans and military funeral honors and benefits at Military One Source, the definition, and the entire into the record, if I could, Mr. Chairman.
Without objection.
But it starts off with, if you served at least 90 days of active duty since September 11, 2001, you may be eligible for, and it goes on with a myriad of benefits. Mr. Chairman, if you entered the military and you served 90 days, 60 of which you were AWOL, you were discharged, probably other than honorable, but you were not given a dishonorable discharge, and therefore you are a veteran. It is that simple. 91 days before we kicked your butt out, even if you were AWOL, okay, all you had to do is come back to be discharged. The standard for the other than honorable, the bad conduct, those discharges do not deserve our consideration, and no veteran would stand up and say, yeah, the guy with a bad conduct discharge, he was just misunderstood. Mr. Chairman, it doesn't work that way. People who get those discharges earn them, and they deserve what they get. Now, we do still give them certain benefits. We do recognize that if they were injured, whether it was falling down or whatever in the line of duty, they can still go to the VA. So they do have benefits. And yes, even if they've been sent out of the country, we'll make sure they get their veterans benefits. But Mr. Chairman, this simple change to narrow the scope to those who have served honorably. And again, 90 days gets you honorable discharge technically. You come up as medically disqualified after 90 days, you still get an honorable discharge. I can go through a myriad of people who did not meet that challenge that Mr. Carrera or Mr. Johnson or others have said about these valiant people who served in harm's way. The fact is, we're going to still include people who simply showed up, served 90 or more days, and were discharged, as long as it's honorable. If it's less than honorable, Mr. Chairman, we should not be considering this broad bill under any circumstances. I would hope that the term veteran would mean honorably served veteran and not just anybody who managed not to get court-martialed at the highest and worst level, which is what the current bill says. And I've been stewing on this all day as a veteran, and I quite frankly insist on this amendment, and I see no reason that it would not be accepted by those in good faith who want to go through those who might be out there that meet that standard. It's not a high standard. It's the minimum standard that should be considered for somebody to be granted a reentry into the United States. And with that, I would yield back.
The gentleman yields back. Does the gentlelady insist on a point of order?
I do not insist on my point of order.
The gentlelady seeks recognition.
Yeah, I do seek recognition.
Lady's recognized.
I understand that my colleague from California, Mr. Eisner, has very strong views on this, and he's given some examples that are of interest. On the other hand, I can't help but think back on Mr. Roy's comments earlier in the day, talking with a great deal of passion that someone who has declined to comply with the vaccine requirements of the military could end up with a general discharge. Someone else was quoting, it might have been you, Mr. Bishop, I can't recall, was reading the various types of activities that could lead to a general discharge. And one of them was committing adultery, in a custody, in a divorce proceeding. So I think there would be occasions where a general discharge would not be the kind of activity that you, Mr. Issa, have just described in defense of your amendment. And therefore, we ought to, let's say that we've got a legal permanent resident of the United States in the Navy. And the Navy was very concerned about, especially on ships with COVID, and remember the transmissibility, and was very insistent on the vaccines to protect their readiness, is what they said, because they didn't want to have the fleet disabled because of disease transmission, the COVID transmission. You have a legal permanent resident who's in the Navy, who, for whatever reason, in good faith, I'm sure, doesn't want to do that. And so the option is, you do it, or you're not going to be on that ship with the hundreds of other sailors, and you're going to ultimately be discharged if you can't serve, but you're not going to be dishonorably discharged for that. That would be very unfair.
Would the gentlelady yield?
I'd be happy to yield.
Yeah, your point is quite valid, but again, these are people who committed some other crime for which they were removed from the country. So all the examples you give would not have that legal permanent resident be removed. It would simply take away this special privilege of coming back.
Reclaiming my time, we do know that there are a number of individuals who have been removed, but not because of criminal activity. We've also discussed at great length the commission of offenses that are relatively minor in nature, where you might have a need to consider that because these are people who served our military. The only point I'm making, your amendment really would preclude consideration of anyone with who didn't get an honorable discharge, and there are people who, as I understand it, can get a general discharge who really haven't engaged in egregious behavior in the military. They just didn't go with the program in some way. For example, Mr. Roy's example of the military person who declined the vaccination. And it seems to me that that person with a general discharge should not be precluded from at least applying for discretionary relief, just like someone with an... was it you? I'm sorry. I beg your pardon.
He's from North Carolina. No problem.
Okay. Seeking discretionary relief because they're a veteran. The whole issue is whether you've served your country, and I guess the point I'm making is that you could serve your country and we could admire your service and yet have done something that results in a general discharge instead of an honorable discharge, but we would still honor your service because of what you've done for our country. It doesn't necessarily reflect the full panoply of the service that you have given to the United States, and that's why I think we'd be better off not adopting this amendment, and I yield back.
Gentlelady yields back. Who seeks recognition? For what purposes, the gentleman from Kentucky seek recognition?
I seek to speak on the amendment.
The gentleman is recognized.
There are just a few things I want to correct in the story or examples that were just given. I think it's been dispelled that the vaccine prevents the spread of COVID. I mean, I don't know why we're still saying that. I mean, the CDC director has apologized for being wrong about that. The NIH director said that he was wrong about that. Literally everybody, Deborah Birx.
Gentleman, yield.
I will yield.
Did Dr. Fauci admit that he was wrong about that as well yet?
I believe they've all admitted that.
No way.
So
they got the vaccine and they got COVID.
Yes, they've all gotten COVID. The president himself is contagious right now, even though he's had 4 shots of the vaccine, and that is why he's staying away from people. So I just take a little bit of issue that we are in a congressional markup, still perpetuating this falsehood that was propagated by the pharmaceutical companies that stood to profit by this. They knew it wasn't even true. Their tests with 50,000 people in the trials were designed not to explicitly not show whether it did or didn't stop the spread of COVID. So I'm just offended that we're still perpetuating that myth when virtually everybody has admitted that it was a myth. And the reason we need to acknowledge that is the myth that underlies the entire rationalization for kicking somebody out of the military for not taking the vaccine.
Would the gentleman yield?
I will yield to the gentleman from California.
I can't wait for January 3rd, maybe the 4th, when one of our early HRs restores those men and women, those brave men and women who asked for and were denied their valid exemptions, and we restore them to full active duty, which, by the way, will unring the bell of any question of a general or other than honorable discharge. And I look forward to working with the gentleman on that.
I look forward to that too. They should all be reinstated. None of them should have been given anything less than an honorable discharge at all for this. And while I've still got time on the clock, I have to mention that the Secretary of Defense issued a statement on August 24th saying that the vaccines that were required and that would be administered would be the FDA-approved vaccines, and not a single dose of FDA-approved vaccine, aka Comirnaty in the case of Pfizer, or Spikevax in the case of Moderna. Not a single dose of that has been given to a single member of the military, as the Secretary of Defense specified. And it was his only legal way to require the vaccine for members of military, was that it was FDA approved and that the doses that they would receive would be the FDA approved, legally distinct from the other vaccines that they received, and also labeled as such, labeled appropriately. None of those vaccines have been given, yet tens of thousands of members of the military have been kicked out for not taking that vaccine.
Gentleman yield?
I would yield to the gentleman from North Carolina.
Is the gentleman suggesting that the military engaged in a bait and switch and substituted a different vaccine than that which was approved?
I am absolutely saying that what the Secretary of Defense is doing right now is illegal. We know it. I would characterize it as a crime in progress.
Would the gentleman yield?
I'm going to yield to Mr. Tiffany, who's asked for
Yeah, I want to
time.
make sure I'm clear on this. Are you saying they've received the experimental use vaccine?
The emergency use authorization vaccine is all they've received. Not a single member of the military has received the FDA-approved version.
Well, it's good you're dispelling this notion that's out there that they're getting the FDA-approved vaccine.
There are two notions I want to dispel, and I would give the gentlelady time to respond to this. The notion that the vaccine stops the spread of COVID. Would the gentlelady like to clarify her comments on that?
Does the gentleman yield?
I do.
The point I'm making is that there's activity that service members could engage in that we would not find to be egregious. For example, the
Adultery. You gave
adultery.
that
I
example.
mean, I'm not in favor of it. I think it's a
Right.
sin, but I don't think it's
reclaiming my time. And I think the gentlelady gave valid examples, but the one that with all due respect, I don't think it's valid, is to substantiate the disproven notion that the vaccine stops the spread of COVID, and that would be a reasonable reason to give somebody a discharge that's less than honorable. And with that, I yield back.
Gentleman yields back. Who seeks recognition?
Mr. Chairman,
What purpose does the gentleman from Louisiana seek recognition?
speak in favor of the amendment.
The gentleman is recognized.
Thank you, Mr. Chairman. I want to support the ISA amendment because it does raise the bar, and I'm in favor of raising the bar by any means necessary because I think the underlying bill is ill thought. And I want to say again and emphasize that the primary reason we have a problem here is because of the man in charge of DHS. This bill gives him unilateral authority, and it is given to a figure that we do not trust. And I've been waiting for an opportunity to summarize this and tell you why, because some of you over there don't seem to understand. You act as though you're surprised by that. I've been making a few notes here while everybody's been talking. Let me just go through some of this. First of all of us have been to the border here, and we're outraged by what we've seen. We're outraged by it. Okay, but because of Secretary Mayorkas's deliberate and defiant policies, here's a list. We have a literal flood of lawless masses flowing across our border from more than 160 countries, and if you just turn on some news stations and you'll see accurate reporting of this. The safety and security of the American people are being directly threatened, and innocent children are being abducted, assaulted, raped, and murdered by human traffickers. You talk about problems that we should be addressing? That's within our jurisdiction. Because of Mayorkas, countless numbers of known terrorists and vicious gang members are coming across our border and making their way into our communities all over our country. The precious treasure of American taxpayers is being used to incentivize and reward illegals with food, clothing, health care, welfare benefits, and they even pay for ghost flights and bus tickets to secretly transfer waves of illegals into our communities all across this country. Hey, because of Secretary Mayorkas' policies, our entire country is becoming a crime scene. We're dealing with a humanitarian disaster that would have been unimaginable just 3 or 4 years ago. Because of Secretary Mayorkas' policies and decisions, the drug cartels are making billions of dollars and building their empires and drowning our streets in fentanyl and other deadly substances. We have made drug overdoses the #1 cause of death for Americans age 18 to 45. Our brave Border Patrol, law enforcement agencies, and officers are completely overwhelmed and personally endangered. The rule of law is being trampled underfoot every single hour that we sit here and dither over this stuff, and the stability and the very sovereignty of our nation is being threatened like never before. Secretary Mayorkas is doing more than insulting the intelligence of the American people. He is subjecting them to extraordinary danger, and this is not a game, because he's presided over the greatest immigration catastrophe in American history. It is an objective truth that he helped design and implement a system that has allowed record levels of illegal immigration, record levels of sex trafficking, all these narcotics, humanitarian disasters, and all the rest. He took his oath of office on February 2nd, 2021. By the end of that first year, listen, ICE recorded the highest number of border crossings and the lowest number of deportations in history. He stated publicly in direct defiance of our laws, and that's the key, quote, being here illegally by itself is not enough to be removed, unquote. And quote, having an order of removal is not enough to actually remove someone. What? That's federal immigration law. If DHS does not deport illegals, apprehend, quickly remove people who cross into our country illegally, then we don't have border security at all. We have a total collapse of operational control. Mayorkas makes those decisions. If people are allowed to simply walk in here and live and work and collect taxpayer-funded benefits and assistance for years upon years and even permanently, then in a very short period of time, we're going to be totally overwhelmed and crushed by the sheer numbers and weight of illegal immigration. The American people understand this, and the Democrats in charge do not. And that's why we're outraged over this nonsense. There's no longer going to be any border, any security, any sovereignty at all. We're not even going to have our own country if this continues. I called for Secretary Mayorkas' resignation in July last year and explained that it had become crystal clear that he was either unable or unwilling to do his job. Based on the evidence we have now, we've reached the inescapable conclusion that his actions are intentional. His actions show that he is not competent as an agency head, and he is certainly not competent for this committee to give him any more authority over anything. Certainly not a unilateral, unchecked decision. It's dangerous, it's subversive, it's intentional, it's deliberate, it's premeditated. What else you gotta know? The evidence is out there. Border Patrol agents turned their backs on Secretary Mayorkas in Arizona last year because they don't trust or respect his leadership. And you know what? We don't either. He lied to Congress. He told us as recently as last week that the border security knows it's not true, and you guys know it's not true. So don't give him any more authority and don't ask us to participate in it. I'm not a part of that. It's a dereliction of his duty, and it's a dereliction of ours if we continue.
Could the gentleman yield?
I yield.
I might, in his remaining time, remind everyone, the gentlelady did say that, there were these situations in which, quote, you could get other than a honorable, which would include general. But that's not what the bill says.
Right.
The bill includes a bad conduct discharge. It only has dishonorable, the worst of the worst. You need years at Leavenworth to get a dishonorable in most cases. So let's understand it. This bill was carefully written. I assume that the people who wrote it are smart and well-informed, and it is flawed and should be changed, and this is a minimum change. I yield back.
Gentleman yields back. For what purposes the gentleman from Georgia seek recognition?
Move to strike the last word.
Gentleman is recognized.
Gosh, I thought I had heard everything, but we keep hearing about illegals. When we're talking about our men and women, many of whom are our Latino brothers and sisters who have served in our military, came here, served us, while many of us did not serve. They served, and they came back with post-traumatic stress and all other kinds of ailments. And we don't have the decency to have a heart for them when they need a second chance, when their families are suffering. We callously keep talking about drug dealers and rapists and criminals, just like we heard when down the dissension of the Golden Stairway back in 2015, it's become okay to keep talking about drug dealers and rapists and saying that people are invading our country, our borders are under assault. We're losing our country. If we don't stand up and take our country back now, you know, from these people, from these hordes of illegals coming across our border, frightening people. This is not the way that we talk about people who have served our country, but this is what we hear from the MAGA Republicans. It's getting rather sickening. I yield back.
Gentleman yields back. Who seeks recognition? Nobody seeks
I would.
Nobody seeks recognition. The question occurs on the amendment. All in favor say aye. Aye. Opposed, no?
No.
No.
In the opinion, in the opinion of the chair, the noes have it. Recorded vote is requested. The clerk will call the roll.
Mr. Nadler.
No.
Mr. Nadler votes no. Ms. Lofgren.
No.
Ms. Lofgren votes no. Ms. Jackson-Lee. Ms. Jackson-Lee.
Put your
Ms. Jackson-Lee votes no. Mr. Cohen. Mr. Johnson of Georgia.
No.
Mr. Johnson of Georgia votes no. Mr. Deutsch.
I wish I could tell you.
Ms. Bass.
No.
Ms. Bass votes no. Mr. Jeffries.
Oh, wait, Deutsch votes no.
Mr. Cicilline. Mr. Cicilline votes no. Mr. Swalwell.
No.
Mr. Swalwell votes no. Mr. Liu.
Okay, so Escobar and McClintock, of course.
I'll ask her, but I'm sure
Mr. Raskin.
No.
Mr. Raskin votes no. Ms. Jayapal.
That amendment in that they've agreed on.
Ms. Stimmings. Ms. Stimmings.
Demings votes no.
Ms. Stimmings votes no. Mr. Correa. Mr. Correa votes no. Ms. Scanlon.
No.
Ms. Scanlon votes no. Ms. Garcia. Ms. Garcia votes no. Mr. Neguse.
No.
Mr. Neguse votes no. Ms. McBath.
McBath votes no.
Ms. McBath votes no. Mr. Stanton.
No.
Mr. Stanton votes no. Ms. Dean.
Dean votes no.
Ms. Dean votes no. Ms. Escobar.
No.
Ms. Escobar votes no. Mr. Jones. Ms. Ross.
Ross votes no.
Ms. Ross votes no. Ms. Bush. Mr. Jordan. Mr. Jordan votes yes. Mr. Shabbat. Mr. Shabbat votes aye. Mr. Gomert. Mr. Issa.
I will be yes on my amendment.
Mr. Issa votes yes. Mr. Buck. Mr. Buck votes aye. Mr. Gates. Mr. Gates votes aye. Mr. Johnson of Louisiana. Mr. Johnson of Louisiana votes aye. Mr. Biggs. Mr. Biggs votes aye. Mr. McClintock.
Aye.
Mr. McClintock votes aye. Mr. Stube. Mr. Tiffany. Mr. Tiffany votes aye. Mr. Massey. Mr. Massey votes aye. Mr. Roy.
Aye.
Mr. Roy votes aye. Mr. Bishop. Mr. Bishop votes aye. Ms. Fishbach. Ms. Fishbach votes aye. Ms. Sparts. Mr. Fitzgerald. Mr. Fitzgerald votes aye. Mr. Benz. Mr. Benz votes aye. Mr. Owens. Mr. Owens votes aye.
How am I recorded?
Mr. Deutsch, you are not recorded.
No.
Mr. Deutsch votes no.
How's Jayapal recorded?
Ms. Jayapal, you are not recorded.
Jayapal votes no.
Ms. Jayapal votes no.
Are there any,
How is
Are there any-
Jackson Lee recorded?
Ms. Jackson-Lee, you recorded as no.
Thank you.
Are there any members who wish to be recorded who haven't been recorded? Clerk will report.
Mr. Chairman, there are 16 ayes and 20 noes.
The amendment is not agreed to. Are there any further amendments? For what purpose does Ms. Luffen seek
I
recognition?
have an amendment at the desk.
Clerk will report the amendment.
I ask unanimous consent that the amendment be considered as read.
Amendment is considered as read. The gentlelady is given 5 minutes to explain her amendment.
I won't take 5 minutes. We had an animated discussion earlier about the gentleman from Louisiana's amendment precluding consideration for 5 convictions. And as we discussed publicly, I suggested that we add the words unless the conviction is older than 25 years. So this amendment reflects that discussion, that someone with 5 offenses would not be eligible for review unless the conviction was older than 25 years. And I don't feel a need to discuss it further since we had a long discussion earlier, so I would yield back.
Gentlelady yields back. Does anyone else seek recognition? If not, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no.
Aye.
The ayes obviously have it, and the amendment is agreed to. Are there any further amendments to the amendment in nature of a substitute? The question occurs on the amendment in nature of a substitute. As amended. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. 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 Opposed, no. In the opinion of the chair, the ayes have it. The amendment in nature of a substitute is agreed to. Are there any amendment?
Wait.
Reporting quorum being present, the question is on the motion to report the bill H.R. 7946 is amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no. The ayes have it. In the opinion of the chair, the bill. The recorded vote is requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee. Ms. Jackson Lee votes aye. Mr. Cohen. Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch.
Aye.
Mr. Deutsch votes aye. Ms. Bass. Ms. Bass.
Aye.
Ms. Bass votes aye. Mr. Jeffries. Mr. Cicilline.
Aye.
Mr. Cicilline votes aye. Mr. Swalwell.
I will.
Aye.
Mr. Swalwell votes aye. Mr. Liu.
Aye.
Mr. Liu votes aye. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Jayapal.
Jayapal votes aye.
Ms. Jayapal votes aye. Ms. Dimmings.
Aye.
Ms. Dimmings votes aye. Mr. Correa. Mr. Correa votes aye. Ms. Scanlon.
Aye.
Ms. Scanlon votes aye. Ms. Garcia.
Aye.
Ms. Garcia votes aye. Mr. Neguse.
Aye.
Mr. Neguse votes aye. Ms. McBath.
McBath votes aye.
Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean.
Dean votes aye.
Ms. Dean votes aye. Ms. Escobar.
Aye.
Ms. Escobar votes aye. Mr. Jones.
Aye.
Mr. Jones votes aye. Ms. Ross.
Ross votes aye.
Ms. Ross votes aye. Ms. Bush. Mr. Jordan. Mr. Jordan votes no. Mr. Shabbat. Mr. Shabbat votes no. Mr. Gomert. Mr. Issa. Mr. Issa votes no. Mr. Buck. Mr. Buck votes no. Mr. Gates. Mr. Gates votes no. Mr. Johnson of Louisiana. Mr. Johnson of Louisiana votes no. Mr. Biggs. Mr. Biggs votes no. Mr. McClintock.
No.
Mr. McClintock votes no. Mr. Stubbe. Mr. Tiffany. Mr. Tiffany votes no. Mr. Massey. Mr. Massey votes no. Mr. Roy. Mr. Roy.
Roy, get with the program.
Mr. Roy.
No.
Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach? Ms. Fishbach votes no. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Bentz? Mr. Bentz votes no. Mr. Owens? Mr. Owens votes no.
This is Mr. Cohen. How am I recorded?
Mr. Cohen, you are not recorded.
Record me as aye.
Mr. Cohen votes aye.
Thank you.
Are there any other members who wish to be recorded who haven't been recorded? Clerk will report.
Mr. Chairman, there are 23 ayes and 16 noes.
The bill is agreed to. The ayes have it, and the bill is amended. It's ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment, nature of a substitute, incorporating all adopted amendments. The staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 2920, the American Families United Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2920 to amend the Immigration and Nationality
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 2920, the American Families United Act of 2022, is bipartisan legislation to fix barriers in our legal immigration system that separate U.S. citizens from their spouses and children. Earlier this Congress, the Immigration Subcommittee held a hearing that shined a light on how our immigration laws are particularly harsh for U.S. citizens with undocumented spouses and children. For example, under current law, many U.S. citizens cannot sponsor their spouses and children for a green card. In large part, this is because there are very limited discretionary waivers of inadmissibility or deportability and significant bars for unlawful presence. As a result, many family members are virtually shut out of the system with no means of obtaining lawful status. Today, 1.7 million U.S. citizens are married to an undocumented person. Roughly a quarter of them have been married for 20 years or longer, while more than half have been married for 10 years or longer. Among the many people facing hardship because these restrictive immigration laws are my constituent, Dr. Kevin Kells, who has lived apart from his wife for over 15 years. In 1998, before they met, Dr. Kells' wife traveled to the United States to attend a high school graduation party. She didn't speak English, but the driver of her car told the border officer that she was born in the United States. Her record now shows that she made a false claim to U.S. citizenship, and she is permanently barred from the United States. Under current law, there is no ability for Dr. Kells to obtain a green card or lawful status for his wife, nor are there options for many others, given the limited discretion of immigration judges and officers to waive the consequences of past acts, even those that were based on honest mistakes made decades ago. H.R. 2920 is a bipartisan compromise introduced by Representatives Veronica Escobar and David Valadao. It provides a narrow solution that would give Dr. Kells and other separated American families an opportunity to sponsor their family members. This bill would simply provide immigration judges and officers the discretion that they need to waive certain grounds of inadmissibility or deportability on a case-by-case basis for the spouses and children of U.S. citizens. To be clear, this bill does not address all of the issues affecting family reunification. For example, it would not provide discretion for immigration judges and officers to help the undocumented parents of millions of U.S. citizen children. We have passed bills through the House, including the Build Back Better Act, to give relief to these worthy individuals. Sadly, that legislation is stalled in the Senate, but we will continue to fight for relief for all. In the meantime, we can also put forward solutions where there is common ground with our colleagues on the other side of the aisle. I'm pleased to support this bipartisan solution that would take a significant step toward reuniting countless mixed-status families. I would like to thank Ms. Escobar and Mr. Valadao for their leadership and for working together to support American families. And I urge my colleagues to support this important legislation. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. This legislation is an attack on the rule of law. H.R. 2920 would give the AG and the Homeland Security Secretary the power to prevent removals and provide immigrant benefit to aliens in cases where the removal or denial of a benefit will be a, quote, hardship to a U.S. citizen, spouse, child, or parent of alien. This discretion is allowed even if the alien has received due process and has been ordered removed by an immigration judge. The bill before us would untether immigration policy from requirements laid out by Congress and hand this decision-making power to the AG and the Homeland Security Secretary so that they don't have to enforce the law. What a deal for taxpayers. There have been over 800,000 known, quote, gotaways since President Biden took office, thanks to his embrace of radical open borders policies. And of course, that's on top of the 3 million alien encounters at the border during this administration. During fiscal year 2021, there were 1,734,686 encounters, and we are already at 1,746,119 encounters in this fiscal year, with 3 months remaining. Fiscal year 2022 is on track to have the most encounters of illegal aliens at our southern border ever in history. Meanwhile, the Democrats on this committee refuse to even acknowledge that there is a problem. And rather than to do anything to address this crisis or enforce law and prevent more people from crossing illegally, Democrats want to relax the laws so that bureaucrats in Washington can more easily reward those who broke the laws. This is wrong, Mr. Chairman. We strongly oppose this legislation and yield back.
Without objection, all other opening statements will be included on the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2920.
I ask unanimous consent that the reading be dispensed with.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will now recognize myself to explain the amendment. The changes in this amendment are either technical in nature or are necessary to clarify the intent of the underlying legislation. Most of these changes reflect the advice of the Department of Homeland Security and Department of Justice, both of which provided technical assistance on the bill. To avoid any unintended negative inferences, the amendment makes changes to ensure that the waiver authority in this bill does not impact any existing authorities in the Immigration and Nationalities Act. This change was recommended by the Department of Homeland Security. Among other changes, the amendment includes language to clarify that the waiver authority in this bill is limited to the family members of U.S. citizens, and for purposes of relief under the legislation, family separation must result from removal or denial of a benefit. The amendment also clarifies that the family members of U.S. citizens and lawful permanent residents who committed crimes that would make them inadmissible or deportable would not be eligible for the waiver in this bill. In addition, the amendment removes a provision that is outside the intended purpose of the bill to reunite families in the United States related to naturalization for the children of U.S. citizens abroad. To close gaps in the bill that would leave some American families behind, the amendment also makes changes to ensure that widows and orphans of U.S. citizens and lawful permanent residents can still receive the benefits in this bill, and to allow those American families who are separated before this bill passed a chance to sponsor their family members for a green card. All of the changes made in the amendment are minor and improve on a good bill. I urge all of my colleagues to support it. And I want to make note for the members that I intend to recognize Ms. Escobar and Mr. McClintock for statements on the bill. Then we expect to move to a vote on final passage of the bill. At that point, we expect to conclude our business for the day. Ms. Escobar.
Thank you so much, Mr. Chairman. I'm grateful to you and Ms. Lofgren, our Immigration Subcommittee Chair, for bringing my bill, the American Families United Act, before the Committee for Markup. Colleagues, I'd like to share the story of my constituent, Edgar Falcon, with you, who is the inspiration for this bill. Edgar is a great person, born and raised in my community of El Paso, Texas. In 2013, Edgar, an American citizen, married the love of his life, Maricruz, a Mexican citizen. In fact, right behind me is their wedding photo. They married atop the Paso del Norte International Bridge between El Paso, Texas, and Ciudad Juarez, Chihuahua. Edgar and Maricruz have a beautiful 3-year-old American daughter, Giselle. Edgar is a loving husband and devoted father. But Edgar and his family are denied the opportunity to live their lives to the fullest because of a 1996 law, the Illegal Immigration Reform and Immigration Responsibility Act, or Ira. Maricruz is a Mexican citizen who, as a child, was persuaded by an older family member to falsely claim American citizenship at a U.S. port of entry. Because of Ira, and because of that one incident at the land port when she was a minor, taking the advice of a trusted adult, Maricruz is now forever barred from entering the country. As a result, Edgar has had to make a terrible choice: either leave his community and his country in order to raise his family and live with his wife and daughter, or self-separate from his wife, daughter, and everything he holds dear in order to remain and work in the United States. He and his family have suffered significantly because of Ira. It took away an immigration judge's discretionary authority to review and decide cases like Maricruz's. But it's not just Edgar and Maricruz who are suffering this way. Millions of Americans, including American children like Giselle, are being denied the ability to live in the United States together as a family. And because of Ira, they are denied the ability to go before a judge to lay out the facts of their case so that the judge may determine if they are eligible for a chance at legalizing their status or not. The American Families United Act is a long overdue piece of bipartisan legislation that would restore the opportunity for American families across the United States to have their day in court. Simply put, my bill will grant immigration judges and officers the ability to waive, on a case-by-case basis, certain grounds of inadmissibility or deportability if denial of immigration relief would result in hardship to a U.S. citizen, spouse, parent, or child. I remind my colleagues this discretion is not new or unprecedented. This judicial discretion was taken away from immigration judges with the passage of IRA in 1996, and this bill would restore it. Colleagues, the results of this provision in IRA have been devastating, heartbreaking, and unnecessarily destructive to American families, and there are innumerable examples of that heartbreak even in your own districts. Many of those families, your constituents, are actually watching this hearing right now, praying for an end to their nightmare. My colleagues, you frequently say, all of us frequently say, that we support legal immigration. This is an opportunity to put that support into action, to stand by that claim and to recognize the rights of Americans, to make sure that they have the opportunity to go before a judge and possibly have the chance to live together, a family united. This bill does not grant amnesty, nor does it reward undocumented immigrants for being present in the United States. My bill does not require that anyone be issued a green card. It simply allows spouses and children of U.S. citizens to have an opportunity to argue their case in order to finally get in line for a green card. The American Families United Act gives families a fighting chance to stay together and ensures that children can have both of their parents at home while righting a 28-year wrong that has kept families apart, living with unnecessary pain and separation. I urge you, my colleagues, to support this bill today. Mr. Chairman, I yield back.
Mr. McClintock.
Thank you, Mr. Chairman. 18 months ago, we had achieved operational control of our southern border. The border wall was nearing completion. The Remain in Mexico policy and enforcement of court-ordered deportations had slowed illegal immigration to a trickle. American workers were finally seeing major wage gains, and the gap between rich and poor in this country was finally narrowing. All of that ended on January 20th, 2021, when Joe Biden canceled the Remain in Mexico policy, ordered ICE to stop enforcing court-ordered deportations, and canceled the border wall, leaving construction gaps through which thousands of illegal immigrants now pass every day. Since this administration took office, more than 3 million foreign nationals have illegally entered our country, with roughly half being trafficked across the country by this administration. While the Border Patrol's been overwhelmed, an additional 900,000 illegal entries evaded authorities that we know of and are now in the United States. In other words, in 18 months, the Democrats have allowed into our country an illegal population larger than the size of the states of Alaska, Vermont, and Wyoming combined. Fentanyl crossing the southern border has exploded. The death rate from fentanyl overdoses in this country has more than doubled in a single year. The effect on school and hospital overcrowding, homelessness, depressed wages and opportunities for working families, and crime will mean a much more dangerous and impoverished country as a direct result of these policies. Deaths at the border have skyrocketed as more and more illegal migrants are encouraged to make this dangerous journey. On every trip I've made to the southern border, border agents have told me to warn my constituents that the tragedies that they encounter every day in the border communities are being exported across the country and that every town will soon become a border town. And now I'm hearing the same thing from my own constituents in Northern California. This committee has blocked every Republican effort to address this national crisis. Every hearing the Democrats have had about this crisis is how to increase it. The bill now before this committee, H.R. 2920, gives the Attorney General and the Secretary of Homeland Security the discretion